get the jurors in here, but plaintiff have anything else that we need to address this morning?
I think there's a few exhibits that Mr. Delich will read into the record that have been stipulated.
Okay.
No, Your Honor.
Right.
The proffer that we were going to make with Mr. Otto, I've shown it to Mr. Friedman, and we're just going to submit it as
a filing?
Yes, to save time from having to read it into the record.
All right. You want to submit that to the clerk and
Mark it as
she'll mark it as a proffer?
mark it as exhibit not admitted. Would that be the way it would go in the file? What's our next exhibit? 90?
Yeah.
590. I was going to say, that sounds kind of light. 590?
And
All right.
for the record, Your Honor, obviously plaintiff objects. But
That's why it's a proffer.
yeah, no, I know. I just.
All right. Yep. Clerk's just going to mark it for identification, so it'll be part of the record in the case. Obviously, it's not going to go back to the jury. All right. You want to, Mr. Delich, you want to, I'll hang on.
Thank you, Your Honor.
Hang on. Let me get the clerk ready to jot those down. For that, the proffer, I guess they were saying 590 was the next defense exhibit. No. All right, and plaintiff's got some exhibits that were stipulated too. So you ready? Go ahead, Mr. Delich.
Thank you. It's Plaintiff's Exhibit 111, Plaintiff's Exhibit 126, Plaintiff's Exhibit 287, Plaintiff's Exhibit 140, Plaintiff's Exhibit 143, Plaintiff's Exhibit 148, Plaintiff's Exhibit 171, Plaintiff's Exhibit 194, Plaintiff's Exhibit 197, Plaintiff's Exhibit 204, and Plaintiff's Exhibit 347.
All right. There's no objection to those?
I will represent that it's the exhibits on the post-it you gave me the other day.
We'll accept that representation.
All right. Those plaintiff's exhibits will be admitted. All right. Anything else from the plaintiff?
No, Your Honor.
Anything else from the defense?
No, Your Honor.
All right. Last night after we got done with the jury, we went through discussion on the jury instructions and the verdict form. I know it was just emailed a couple hours ago. I had gone through looking at a bunch of those cases, and I was waiting for an answer back from the staff attorney who was looking at some of that for me as well. Just for purposes of the record, and what I'll do is I'm going to explain why I did or didn't do whatever I included in there. I'll give each side 3 minutes to state anything else that we didn't discuss last night or anything else you want to preserve for purposes of the record, but otherwise what I sent y'all this morning was what we're going to go with. And for the record, the verdict form, the difference that we had that we discussed last night was in number 3. I just added, and this came out of the language of the mitigation defense. I added, what is the total amount of Zachary Young's damages for both lost earnings in the past and for loss of his earning capacity in the future, reduced by, and the added part was reduced by any amount he failed to mitigate. So that was just to clear up and to address the defense as based on the instruction. On the jury instructions, plaintiffs had requested one on the eggshell plaintiff. And we talked about it a little bit last night, but there's really not any evidence to say that any physical, emotional, pain and suffering sort of damages in this case that Mr. Young was claiming were overly inflated based on the circumstances or not reasonable under the circumstances, such that there's not even real evidence to discuss the eggshell plaintiff aspect of it. Also, it's not something, even though it's applicable and it's a statement of the law, It's not something that's normally given as any sort of standard instruction. We do talk about aggravation of a pre-existing condition, and those sort of circumstances would be appropriate under the facts as presented in this case. That's why I didn't give that one. On the outrageousness, again, I looked at it a lot when we were addressing it on summary judgment, obviously addressed it in a footnote in my summary judgment order. I like the times when I go back and I research something again and I reach the same conclusions that I did before. But outrageousness is talked about in the context sometimes for punitive damages. What's really kind of funny is the word outrageous is nowhere in 768.72. And the other ironic part about that is the language that's in 768.72 that talks about gross negligence or intentional misconduct is usually not in defamation punitive damage cases. But in looking at the case law that does deal with it, and I do recognize that it was mentioned in next to the last sentence or so, the last paragraph anyway of the first DCA order in this case. Generally, outrageousness is talked about in the context of explaining circumstances that are gross negligence and intentional misconduct and relate to cases different than defamation. And I think that the descriptions of actual malice or express malice as they pertain to defamation cases covers the kind of conduct that is considered in the other cases to be outrageous conduct. Hence, outrageousness would be subsumed in the definition of actual malice or express malice. So I'm not going to give it separately for that reason on that. The two other requested instructions that were labeled as defendants 14 and 15 that kind of talked about intent. That would need to be found on the part of the defendant. I'll be honest, I looked at every Florida case, whether state or federal. I also looked at, there's a citation at the bottom of of number 14 that is summary judgment order at page 15. I couldn't find anything close to any of this language in any of the Florida cases. That's not to say that there may be another state that applies it. And actually, one of the 11th Circuit cases was out of Alabama, and I even looked at that one too. What is talked about in, New York Times or Gertz or one of them is, states can have their own substantive law on defamation, that can develop it, but the threshold or the standard is what we're saying of actual malice that's required. So to the extent that there's some other states that may adopt some of these things, I couldn't find anything close, like I said, to the language that's in here in any of those cases. And again, I think to the extent that you look at defendant publishing something knowing it was false or having a high degree of awareness of its falsity necessarily has an intent on the part of the defendant in there. So I think it's baked into the definitions of actual and express malice that we are instructing the jury on, and I don't think there's anything separately that would need to be instructed on there. So that's my reasoning on why I did not include those. I think those were the only ones I was still marinating or pondering, or whatever the words were that I used last night. But anyway, if you want to go ahead, is there anything else you want to state on the record to preserve? I'll give each side 3 minutes to preserve anything else you want to do regarding the jury instructions beyond what we did last night.
Not for planning.
Mr. Tobin, anything on the fence?
Nothing further. Objections preserved. Thank you.
Yeah. No, and I appreciate the arguments. Maybe you can go back and start writing another set of standard instructions for defamation cases.
Go to work. Thank you, Your Honor.
Make all of our jobs a heck of a lot easier down the road. All right. Where'd my list go? I can't find what oh, there it is. All right, that deals with number one on my list of 6 things that I wanted to address before we got them in here. The other ones I think will hopefully be a little bit quicker. The next one brought the issue the other day on releasing the alternate juror when they go to deliberate on phase 1 this afternoon. I polled our other judges here. Nobody really had a good answer of having had this come up. The closest they came to, there's a rule of criminal procedure that deals with death penalty cases where you got a phase 1 and a phase 2. And I think the criminal rule says you excuse the juror and only the ones that go to deliberate phase 1 deliberate the death penalty aspect of it. Did y'all, and quite frankly, we couldn't find a Florida case on it. I had staff attorney working on that too from whenever I brought that up a couple days ago. My thoughts are if we have the 6 go back and deliberate on phase 1, those probably should only be the ones that would deliberate or be part of the deliberations for phase 2, but then we run the risk of if they determine entitlement today and we come back tomorrow on phase 2, and God forbid somebody gets in an accident, gets sick or whatever, do y'all stipulate having 5 decide phase 2?
We probably should have to make that decision now and not wait to see which one leaves, right?
Well, I mean, y'all know who the alternate is that would be excused.
No, but of the 6.
Oh, yeah, well, you're saying is see, I keep the other alternate and then we see who doesn't show up tomorrow?
No, not keep the other, but decide whether you go forward with 5. I'd say go forward with 5.
We're fine with that.
Okay.
Yeah, so
All right, so
If somebody leaves after phase 1, then
I'm cutting the alternate loose when they go to deliberate today, and she doesn't need to come back tomorrow. And if somehow we lose one of the 6 coming back tomorrow, if we have to, then we'll go with 5.
okay.
Y'all are good? Y'all both good?
Yes, Your Honor.
Okay.
Thank you, Your Honor.
All right. Yeah, I guess we probably ought to have our Civil Rules Committee look at it like they did in the context of criminal cases. All right. That deals with number 2. Number 3 on my list, I went back to the discussions we had yesterday morning before we started the getting the jurors on here with testimony. I counted up at least 2 occasions, some instances by Mr. Friedman and by Mr. Axelrod, 2 each, were y'all in the context of the arguments that were being made relative to the Helios stuff of going beyond normal advocacy and taking personal jabs at the other side. So that's $200 each to you from yesterday to North Florida Legal Services. That was before I upped the ante after that, so I'll adhere to the $100, so $200 each on that. Mr. Friedman, and really this applies to everybody, when you were arguing yesterday, you were sitting back in your chair, stand when you make an argument. Just as a matter of professional courtesy, I know there are times in this case when we've shown up for summary judgment arguments or whatever, we've done it in person. I said, feel free to sit. If I say sit, sit. Otherwise, stand up when you're addressing the court. Mr. Axelrod, did Mr. Tobin talk to you last night?
He did, Your Honor, and
All right, and that's I'm taking it as just a slip. But now you're on notice that if you do it again today, I'm taking it as a direct, deliberate, conscious insult, and we're going to deal with that issue.
Your Honor, it was not deliberate. As you know, I had a very long day. I was on my feet most of the day, so I certainly apologize.
And that's how I was chalking it up, and that's why I just mentioned it to him last night. All right, and did you apologize to Mr. Young?
I have not.
All right. Why don't you do that, and I will judge whether it's an apology, because I didn't ask for an apology yesterday. You tried to apologize to me, but saying, I'm sorry you were offended by that, or that's not an apology. So if you could apologize to Mr. Young.
Okay. Mr. Young, I apologize for the statements I made about the Helios contract and what it represented. I said you lied during your deposition. Your deposition testimony was similar to what we saw in the Ian Conway letter, and for that I do apologize.
All right. You accept that, Mr. Young?
no, I don't.
Don't make accusations when you don't have a basis of accusing them of making discovery violations, and calling him a liar for saying that he doesn't have any work when he testified truthfully that it was a contracting agreement to hold a security, or an agreement to hold a security clearance, which is not inconsistent with him making a claim that he doesn't have work. All right. If we got nothing else, we got all the jurors. Awesome. Let's get them in here. Yeah, Mr. Levine, why don't you come up, and I'll have the clerk swear you in after the jury comes, since you do that. Oh, and on the jury instructions and stuff, I gave you the clean set as well as the ones that had all the crazy headers that we had. I'm going to have Brittany print out copies of the clean set. I'll give you each a copy, and y'all can verify it before I even start reading them, just to make sure that what I set this morning is what we printed out, and then we'll make copies for the jurors to take back to the jury with them. All right? All right.
Jurors entering.
I'll try to find something there, right?
Watch your steps going into the back row. Welcome back again.
All right, y'all be seated when you get back to your chairs. Good morning, everybody.
Good morning. Good morning.
Glad the rain stopped before anybody had to go driving out this morning. Let you settle in. And Mr. Levine, since it's a new day, we'll have the clerk administer the oath again. If you'd raise your right hand.
I do.
All right, and have a seat. And y'all ready?
Yes.
All right, and Mr.
Good.
And Mr. Friedman, we just started across, so I'll let you continue.
Thank you, Your Honor. Good morning, Mr. Levine.
Good morning.
Sir, do you consider CNN to be fair and balanced,
I do.
no matter what?
Yes. That is what we strive for.
So there's been a lot of media presence in the courtroom in this trial. Is CNN covering this trial?
I actually don't know. I've been told not to take track of media.
Corey, do you have any of the DX exhibits, DX 71? Can we show that to Mr. Levine, please? Your Honor, may I shift this just a little to the left?
Sure.
Thank you. Mr. Hagan, can we publish that?
I see it now.
There we go. Can we get it on the big screen too? It's in there. I believe so.
It's in evidence. What was the number?
DX 71, I think.
Defendant 71. It's in. Okay.
And can we scroll down? Do you recall looking at this yesterday?
Yes.
Can we scroll down a little bit more, Corey? So I believe your testimony, this is the one of the pitch emails that came from Alexander Marquardt to yourself?
Correct.
And I believe your testimony yesterday was that this pitch got you interested in the story, right?
That's right.
So fair to say that a pitch about extortion of desperate Afghans is what got you interested in the story?
No. It's fair to say the description of what he was going to try and report out is what got me interested in the story. the headline is not a headline of any consequence. It's not a final story.
Right, but I didn't ask if it was their final story that you were interested. I said that your testimony yesterday was that this pitch got you interested in the story, correct?
No, you asked me if that headline that you highlighted, and I'm saying no, it was what the description is below it.
Well, let me bring you one step back. The pitch from Alexander Marquardt got you interested in the story, correct?
That's correct.
And the pitch from Alexander Marquardt begins with a bold, underlined heading, extortion of desperate Afghans, correct?
That's correct.
But your testimony here today is that that had absolutely nothing to do with your interest in the story.
My testimony is that is the entirety of what he wrote here that got me interested in the pitch.
So the entirety of what he wrote here, Mr. Levine, includes the bold, underlined heading of extortion of desperate Afghans, doesn't it?
Okay, sure.
Were you not interested in a story about extorting desperate Afghans?
I potentially could have been, but I read through the whole thing, and that's what got me interested.
So I think that brings me, thank you, Corey. That brings me to something else you said yesterday. You said stories like start here and end here, or sometimes they start and end where you thought they would be. Do you recall that testimony?
Yes.
This story start and stayed where it started, didn't it?
It pretty much tracked. Alex had done a fair bit of reporting before he even wrote this proposal. But, you know, as to what was going to end up in the story, that was still undecided.
I believe yesterday you were asked some questions about the use of black market in the story. Do you recall that?
I do.
And I believe your testimony was something along the lines of you thought it was okay to use the word black market because the story was about how desperate Afghans were coming up against even more hurdles.
Right, and I described those hurdles.
Why didn't you use the word lawless market instead of black market?
Could have, but that's not the word we use.
Why didn't you use the term chaotic market instead of black market?
Again, could have, but that's not the word we use.
Why didn't you use the word like dangerous market instead of black market?
Also a good synonym, but not the word we use.
Do you know Jake Tapper?
I do.
Have you spoken to Jake Tapper?
In general, yes.
Do you follow Jake Tapper on Twitter?
Off and on. I don't follow Twitter too closely.
Or X, or whatever we're calling it.
Whatever you want to call it.
So it's called X, but are they X's or tweets? That's the thing I'm a little...
I think they're still tweets.
Tweets, okay. All right, so do you follow his tweets on X?
In that I am someone who chose to follow Jake
Right.
Tapper's account. Correct.
Okay. Are you aware that he has a show on CNN called United States of Scandal?
Yes.
And have you seen any posts from Mr. Tapper talking about how high the ratings are for United States of Scandal?
I haven't.
Have you ever talked to Mr. Tapper about ratings?
No.
Does CNN care about ratings?
I think parts of CNN care about ratings. Our advertising department cares about ratings. I think our programming team cares because it's a measure of performance.
Do you care about ratings?
Not as much.
When I say you, I guess we have to clarify.
Yeah, me as a senior vice president of news, in my role in that, I'm more worried about the reporting and the quality of it than I am about the ratings.
Okay. But you as CNN?
Me as CNN, I think there are elements of CNN that I described that are, yes, interested in ratings.
CNN makes money off of its ratings, right?
I think that's a very simplistic thing. CNN makes a significant amount of money off our cable fees. Where it comes to advertising, ratings are a helpful measure in order to negotiate that. But I don't think it's the sole thing that drives the CNN revenue.
Well, I didn't purport to say it was the sole thing, but can we agree that it's an important metric for CNN in order to be profitable? Meaning ratings are an important metric for CNN to be profitable. Is that a fair statement?
I think it's an important measure for CNN in order to engage with advertisers.
And therefore, for CNN to be profitable, since...
Well, to earn revenues, yeah.
So, again, I think it's...
I'm not trying to be difficult.
No, it's
I'll
okay.
give it to you. Ratings matter, profits matter, and that factors into it.
Okay. Do you recall giving testimony yesterday that there's, actually it was a DX109, Corey? Do you have DX109? Playing a little bit of Russian roulette here to see. There we go. And Corey, can we just, there we go, thank you. Can we scroll down a little bit? Here we go. That message from you at November 10th at 17:05. Do you see that?
I do.
And do you recall talking about this yesterday?
I do.
And you talked about how there was a difference in your mind between an Afghan being evacuated by the United States versus an Afghan who's paying by themselves, and therefore you wanted to explain this difference. Do you recall that testimony?
I believe what I said, and if I wasn't clear about it, was that there is a difference between those who were helped out by the U.S. government, who wouldn't have been asked, I believe, to pay any money, and the people that were left behind that were now struggling to get out.
Okay, and the people that were helped out by the U.S. government that weren't asked to pay any money, you're talking about Afghans, right?
Yes.
And they got out without having to pay any money because the U.S. government paid for them to get out, right?
Yes. That's my understanding.
And you've sat through this whole trial, right?
I have.
And the testimony in this case to date has shown that the people that Mr. Young evacuated also did not have to pay any money because someone else paid for them to evacuate, correct?
That's right. He evacuated employees of companies.
Okay, so why wasn't it important to explain that difference in your story that you published, but it was important to you to explain the difference between U.S. Let me ask a better question. Why I'm struggling to understand why you thought it was important to explain the difference between the United States paying for an Afghan to be evacuated, but you did not find it important to explain the same issue with regards to Mr. Young, that no Afghan had to pay.
I disagree with that. I think we did. We used his own words in explaining that he felt that those who he evacuated needed a corporate sponsor in order to pay the fees that he was asking for.
So I want you to take off your CNN hat.
Sure.
And I want you to be Adam Levine on the stand. Mm-hmm. And do you truly believe that the video segment left the impression that Afghans were not being asked to pay by Mr. Young?
I absolutely do. I think what the impression given by the Zach Young portion of the story is that Afghans who were desperate and had come up against different obstacles then came up to Mr. Young. This is what I explained yesterday. And what Mr. Young represented to them is someone who seemed like a legitimate way to engage with someone and perhaps commercially get them out of the country. But in engaging with them, they realized that the prices were exorbitant to them. As well, it was out of reach with this extra demand that they had to find some sort of corporation or otherwise to pay the fees to Mr. Young, which was also out of their hands. So he was a hope raised and a hope lost. And that is how he appeared in the story.
I mean, there was words about Afghans being exploited. Do you recall that?
Not in connection to Mr. Young.
So you have made an artificial division in your head. Well, let me not call it artificial. You've made a division in your head between the first 3 minutes of the story and the part about Mr. Young, right? Is that fair?
I think it's absolutely fair, and I know you didn't mean to say artificial, but I think this is what storytelling is. It can move through different parts of a story, different angles and different representations as you go through it. And I think that's what you see in this story.
You recall the lead-ins and the teasers that we watched from Jake Tapper. And he said things like preying on desperate Afghans, asking them to pay big time to get out. Do you recall?
That's right. And I believe we had 2 anecdotes before we get to Mr. Young where that is described.
But no one is named in the entire segment. No evacuation operator but Mr. Young.
Right.
So sitting here today on the stand with your CNN hat off, do you really think it would be unreasonable to interpret that statement as applying to Mr. Young?
Yeah, I mean, I think it would be unreasonable to think that it only applies to Mr. Young just because he appears in a story. I think Mr. Young was represented with doing exactly what he was doing publicly, saying publicly, going on LinkedIn and doing, and that is exactly what was there. We didn't say anything beyond that. We didn't say he charged anyone. We didn't say he exploited anyone. So, no, I think the tease and the lead-in were general descriptions of the situation, and I think the story takes the viewer and the reader through that.
Put your CNN hat on.
Okay?
Same answer?
Same answer.
Now, you've a couple times throughout these proceedings, or yesterday, you've both yourself and your counsel have said, well, Mr. Young's own words were quoted in the segment. Do you recall hearing testimony to that
Yes.
effect? Did you use all his words?
No, we left out the spiteful bee, for example.
That's true. He also left out the fact that he said no Afghan is expected to pay, right?
Well, we did use that, not in those specific words. And look, hold on. We did say exactly what he said about his expectation that a corporation would pay the fees. We did not use. I mean, he said many things
So you didn't
to
use
our
all his
reporters, but we didn't. We can't use everything. That's editing.
I didn't ask if you could or you couldn't. I asked if you used all his words.
I did not use the words you quoted, or we did not. I didn't write the story.
So fair to say you did not use all of Mr. Young's words, correct?
That's fair.
All right. So do you understand that if you quote parts of someone, it can be highly misleading, right?
Yes, but I don't think in this case it was. I think what you cited and what we use in the story are basically the same thing.
So, for example, if I said to you, ideas won't work unless we improve the process, and then you quote me as saying, I said the ideas won't work, that would be misleading, right?
Yeah, I think you're leaving out a key part of the quote.
You don't think you left out a key part of Mr. Young's statements?
Well, I think we caught the tone of what he was saying to us with what we used.
Yesterday you gave testimony about the fact that you might have pulled the story 1 minute before it aired. Do you recall that?
Yes.
Sir, we have been litigating this case for 2.5 years, have we not? Mm-hmm. We've been in trial now for over a week and a half, haven't we?
Yes, we have.
Every CNN employee that has taken the stand has said they would publish the story again, right?
That's right.
Every CNN employee that has taken the stand has said that they are not sorry, right?
I'm not sure that's what they said.
Are you
I mean,
sorry?
they did express some empathy to Mr. Young,
Okay, well,
but they're not sorry for the story, if
We-
that's what you're getting.
let's agree to disagree on whether empathy was expressed, but that wasn't my question. My question was, every CNN employee has said that they are not sorry.
I actually can't recall what everyone said each time, so I'll take your word for that.
Has any CNN employee on the stand apologized to Mr. Young when offered the opportunity?
No.
Do you want to apologize to Mr. Young?
No.
So let's be real, Mr. Levine. Mr. Young was never going to be able to stop CNN from pulling that publication, was he?
I disagree with that. You know,
Sir, you've
Okay.
answered the question. Is it your testimony here today that this story wasn't about Mr. Young?
the overall story was not about Mr. Young. It was about the situation that Afghans found them in. Mr. Young does appear in the story.
So he appears in the story. Story's not about him.
That's right.
His face is in the story. Story's not about him.
That's right.
Names in the story. Story's not about him.
That's right.
Messages from him are in the story. Story's not about him.
That's right.
At the end of this segment, Marquardt says that person offering those evacuations, Mr. Young, story's not about him.
The entirety of the story is not about him. I mean, I get that he appears there. I get we discuss him. I get he came up in the tag. It doesn't make the whole story about him.
Stories about Afghans facing exorbitant fees and a black market trying to get out.
Yeah,
And Zachary Young is the only person offering those services mentioned in the story.
that's not true.
Who else is named in the story as offering those services?
Two people are described as offering those services, and their interactions with the gentleman in California and the gentleman in Kabul are described. He's the only one named.
Oh, Mike, let me
He's
ask.
the only one publicly out there.
Maybe I misspoke, but I think maybe, let's try this again. Stories about Afghans facing exorbitant fees and the black market trying to get out, correct?
Correct.
Zachary Young is the only person named offering those services in the story, correct?
That's right.
Story's not about Zachary Young.
That's right.
Was that with your CNN hat on or your Adam Levine hat on?
Both hats.
You testified yesterday about an apology. Do you recall that?
An apology or?
Yeah, the apology that retraction and apology. I forgot what was the name of the woman from CNN that
Oh, Pam Brown?
Pam Brown. Do you recall the Pam Brown apology?
Yes,
And you testified about it yesterday. Do you recall that?
I did.
And I believe you said essentially that you did it to try to avoid a lawsuit, right?
Yeah.
So CNN's not really sorry, right?
Here's how I look at it. And I think CNN made a decision based on what Mr. Young and you had brought forward that it would make sense to do this correction. Editorially, I think you've heard that people don't think that what they did misrepresented anything editorially, and they don't agree with our legal department. If you're asking me, as I listened to everything that was happening here, that only gets deepened. I mean, there's a lot about what was being asked of us by you and Mr. Young that I question whether these were already things that happened before the CNN story. You know, his business had already basically disappeared, right? Omentum's contract was up 4 days later. That was in the works for a while. He had been going back and forth.
Were you in touch with Momentum?
I'm still talking about this.
Your objection, narrative.
I'm basing it on what I've heard in this.
Objection.
Finish his answer.
His evacuation service, with a flurry of activity in September and early October, had stopped as of late October before our story. Your own financial expert came up and said he hadn't had any prospecting of anything new beyond that. I also heard him, the testimony that he told 2 Viennese doctors that he had a traumatic experience related to Afghanistan. I get there's some question whether he said in Afghanistan, but there's a traumatic experience there that had nothing to do with our story. I also ask about the banner where there's a question of reputational damage, but there's another thing that comes up on reputation, and that's his public actions on LinkedIn. If I was a hiring manager, and I often am, that would come up as a consideration too, and he would have to account for that. How do we know that's not what was impacting him before our story even ran? So there's a lot to me that suggests it wasn't a correction that needed to be run. But our legal department had a reason to do it, and I support them as the legal department for our company.
Sir, are you an expert in the intelligence community?
I'm not.
Do you speak German?
I don't.
Did you read the medical records from Germany?
No, but I read the medical records as they were presented in court.
So
Or I didn't read it, I heard about it.
When were the medical records presented in court, sir? When were the medical records presented in court, sir?
With your expert.
You saw medical records from
Well, they were
our
discussed.
expert? So you heard a discussion of medical records.
That's right.
And your take from there was that there was a traumatic event that occurred related to Afghanistan. Is that fair?
That's my understanding of what was said in those records based on what was testified to in court.
So you understand that the story CNN chose to run related to Afghanistan and evacuations in Afghanistan, correct?
I do.
So a traumatic event related to Afghanistan would very easily cover exactly this story, correct?
Not necessarily.
Sir, did you hear any testimony from any expert that Mr. Young said he was traumatized in Afghanistan?
I heard that that's how it was written and translated and presented in the discussion with the expert.
Okay. Getting back to the questions about the apology. You said yesterday that Drew Schenkman determined an apology was necessary
Right.
and told you to issue the apology.
Didn't tell me. He told the show. I wasn't involved in the decision.
Okay. Drew Schenkman is CNN's in-house counsel, their lawyer.
He's a lawyer there, yeah.
Why did Drew Schenkman issue the apology?
He didn't issue the apology.
Why did he recommend it be issued?
That was his legal decision based on his interaction with you and the letter from Mr. Young, and he thought it was prudent to do.
Okay, why did he think it was prudent to do?
I think he thought that you guys were making a case that the banner in opposition to Mr. Young's face had created a concern by Mr. Young that it created the wrong impression, and he thought it was clear where this was going to be headed from the letter, that it was best to run the correction to try and take that issue off the table.
So see if I got this right. CNN's in-house lawyers took a look at the video after they got a letter from me, right?
I assume so.
And then said, oh man, we should issue an apology and a retraction.
I think in some.
But the business disagrees with the lawyers. They don't think that you should have issued a retraction and apology. Is that fair?
Yeah, I think the editorial part, and this isn't uncommon, just the lawyers in editorial don't always agree. They make, they look at things differently.
We talked a little bit about yesterday the now infamous theater video. Do you recall that?
Yeah.
And at one point, you got pretty fired up. You said that phone call happened. It legitimately happened. Do you recall that?
I have no reason to doubt it didn't.
It's
I
not what
do
asked.
recall it, yes.
Okay. Did you check Alexander Marquardt's contact to see whether it was truly Mr. Young's phone number?
No, I have no reason to think Alex would mislead that way. He's never done that before.
I mean, did you see the call record, the call logs?
No, but why would I?
Oh, they were up here multiple times in these proceedings. Did you not see them when they were displayed? There was a big red box where the outgoing call from Mr. Marquardt should have been and the missed call from Mr. Young should have been.
Right,
Did you see those?
I did.
That doesn't give you reason to doubt that call actually happened?
No,
So let me just make sure that the record is clear here. You have no personal firsthand knowledge of whether that call took place. Is that a fair statement?
I could see the video. I trust Alex. Alex is a journalist who reports to me.
Not what I asked, sir. You have no personal firsthand knowledge that that call actually took place, correct?
I do. I saw the video of the call happening.
Sir,
Now, I understand you're cynical that that call was placed, but as far as I saw, the call to Zach Young was made.
we saw a call placed to a contact named Zachary Young, correct?
Right, and Alex testified that it was the same number that was used to text with Mr. Young,
I understand what Mr. Marquardt testified to on the stand, sir.
under oath.
Okay. I'm aware that he said it under oath, sir. Trust me. But we're both aware of that. We both saw a call go to somebody called Zachary Young on the telephone, correct?
Correct.
All right. We both agree that Mr. Marquardt placed a call to a contact called Zachary Young, correct?
Correct.
My question to you is, do you have any personal knowledge of the phone number that was under that contact name? Personal knowledge.
No, I have no personal.
So you are taking Mr. Marquardt's word for it, correct?
Yeah, of course.
And you are, strike that. So you actually don't know whether or not Alexander Marquardt placed a call to Zachary Young, correct?
I mean, I believe Mr. Marquardt. If you want me, did I go look at the call records, compare the numbers, and know for sure? No.
So you don't actually know, correct?
Sure. I'll give you that.
Or how many people work at CNN?
Several thousand?
Is Jake Tapper one of CNN's biggest stars?
Yeah.
Sir, you have sat through this trial, correct?
I have.
Oh, let me back up one second. We talked to you a little bit about some of the Nielsen ratings of the shows, correct?
Yes.
And the various shows we had, for the domestic shows, we had how many people watched them, right?
That's right.
And for the apology, we had how many people watched it, right?
That's right.
But there were 2 international shows, right?
Correct.
You don't have any Nielsen ratings on those shows, right?
No, we don't get Nielsen ratings or really any ratings for those shows.
How many people watched those shows?
I have no idea.
Could it have been 10 million people?
I don't think so, but I don't know.
Could be.
Could be.
Could it have been 20 million people?
Maybe. Could have been 4.
Could have been 4 million.
Or 4 people.
Do you really think CNN's international broadcast reached 4 people, Mr. Levine?
I don't, but I have no way to know. As I said, I don't know what the measures are.
But CNN says on its website that it broadcast over 80 million homes, doesn't it?
That's right. But homes is, the number of homes that have TVs aren't the number of people watching CNN.
So how is this jury meant to know how many people saw the allegedly defamatory broadcast? If 2 of your shows have absolutely no viewership information whatsoever.
I don't have an answer for that. We gave you the ratings that we had to measure for the shows that we could measure, and we've been honest about what we do and don't have about that.
You understand Mr. Young lives internationally, right?
Yes.
So walking down the street, he has no idea if 10%, 20%, 40% of the population have seen that allegedly defamatory broadcast, right?
I guess that's true.
Sir, Mr. Young's testimony about, you sat through this trial, correct?
I did.
And you heard Mr. Young testify about the effects the piece have had on his business and mental health.
I did.
Correct? You heard the testimony about how it has affected his relationship with his wife.
I did.
You heard Dr. Vincent testify that he believes Mr. Young has major depressive disorder and other specified trauma disorder, right?
That was your, yes.
You heard General Young testify that he'd have hired Mr. Young before the piece aired,
Yes.
and now he wouldn't even hire him to save a 16-year-old girl in Afghanistan.
Yes.
Are you aware, sir, that Mr. Young has now lost his security clearance?
No, the last I heard, Mr. Young said he wasn't sure what the status of his security clearance was.
You don't know the status of Mr. Young's security clearance? You're under oath here today, Mr. Levine.
I don't, this is where I'm a little unsure of what the rules are, of what I've heard from counsel and what I've heard in court. So
I want to know nothing that you heard from counsel. I want to know what you've heard personally sitting here in court. Do you believe Mr. Young has his...
are you referring to Helios?
Hang on.
I'm just a little confused what I'm around to.
What's your... He said he doesn't want any attorney-client communications.
I know.
So if there's an objection, I would instruct him not to talk about anything that he heard from counsel.
It's not so much that, as also foundation is based on what he's been listening to as he sits here through not hearings that are happening outside of the context of the jury. He's just a participant. He's a spectator in things that aren't before this jury.
If you confine it to testimony, you ask him questions about testimony that's been presented in this case, but beyond that, or
I mean,
client or attorney communications, he doesn't need to answer those questions. I'll sustain the objection on those two bases.
Your Honor, can I just add one basis for the record? He is the corporate representative. He's not just Mr. Levine, and aware of documents received by...
Yes.
Still overruled? I mean, sustained?
Still sustained, yes.
Okay, understood. Thank you, Your Honor. Did you hear, Mr. Levine, Mr. Levine, did you hear CNN's expert say that if Mr. Young does not have a security clearance, he's dead in the water?
For those types of jobs, yes.
Meaning for the jobs he's trained to do, correct?
Right. But I didn't hear him say he couldn't get security clearance. I just heard him say if he no longer has security clearance, he couldn't just automatically apply to those jobs.
So if he's lost his security clearance, I think the words were something like dead in the water, right?
If he's lost, he's dead. I think so.
So you heard all this testimony from Mr. Young and Dr. Vincent and General Young, right?
I did.
You still stand by CNN's story?
I do.
Your CNN hat on?
Yeah.
Take it off?
Taken off.
Still stand by the story?
Still stand by the story.
Put the hat back on for me. Would you have CNN publish the story again?
Yeah.
Take it off?
Yeah.
Do you believe CNN did anything wrong here?
No.
Take the hat off?
No.
Do you think Mr. Young deserves an apology?
Mr. Young got an apology.
Do you think he deserves it? Was the question, sir.
Okay, do I? Does CNN?
Put the hat on. Does he deserve an apology?
A further apology? No.
Did he deserve the apology he got?
From his perspective and what he felt, I think that apology was apt. Editorially, no.
Sir, I don't want to ask you about, from Mr. Young's perspective. I want you to put on CNN's hat. You're talking to CNN's corporate representative.
Mm-hmm.
Did Mr. Young deserve the apology?
As a way to resolve the legal matter, yes.
No, sir. That wasn't my question. Did he deserve the apology?
Again, I think, and this is where we got into this in my deposition, I think as a legal matter that the legal counsel felt that apology was deserved. But
Does CNN, you have your CNN hat on, does CNN think
Well, our lawyers represent CNN, so it's the same answer as the CNN Corporation and the CNN lawyer.
Take the hat off. Do you believe he deserves an apology?
No, and I think I've explained why.
No further questions, Your Honor.
Mr. Director.
Yeah, just a couple. So, Mr. Levine, Mr. Friedman was just asking you a couple questions about the international broadcasts of CNN, correct?
That's right.
And I think he referenced Mr. Young being in Austria, and walking down the street, he doesn't know who's seen the thing, who's seen the story, or whatever, right?
That's right.
Have you heard any testimony in this trial that Mr. Young has been accosted on the streets of Austria?
No.
Have you heard any testimony in this trial that Austrians have reached out to him and said, I can't believe what I saw on CNN?
No, in fact, the only thing we heard about Austria was that he was paranoid that the Austrian police were going to knock on his door. And so he started ripping up documents or deleting documents. But as far as I could tell, the Austrian police didn't give it any heed at all.
Have you heard any testimony in this case at all that Mr. Young received any messages talking about the CNN publications?
No.
Can you put up Defense Exhibit 103, please? And I think this is something that Mr. Friedman just asked you about. Thanks very much. And do you recognize this to be Alex Marquardt's Signal LinkedIn or Signal chat with Zachary Young?
Yes.
If you look up at the top in very small letters under the phone number, it says, for your security, conversation history isn't transferred to new linked devices. Do you see that?
Yes.
So do you understand that to mean that if Mr. Marquardt had made a call on another device that it wouldn't show up here?
Yes.
You can take that down. Mr. Friedman asked you about the apology and the correction. At the time, March 17th, when CNN gets the letter from Zach Young himself, had CNN ever heard Mr. Young's concern before that black market implied he was doing something illegal?
No.
From anyone?
No.
Was never on the radar.
Never on our radar. No one ever reached out and said, I don't know why you guys are using the term black market to describe Afghanistan. No one ever reacted.
That was the first time.
That was the first time.
You take that down. Mr. Friedman asked you whether, if Mr. Marquardt or Ms. Lillis had gotten more information, whether it would have changed the story. And you said that, yeah, it would have changed the story, or we would have pulled the story or something like that.
Right.
And you wanted to explain why you disagree with Mr. Friedman's question that CNN wouldn't have changed the story. Can you explain to the jury why you disagree with Mr. Friedman?
Because it's an entirely speculative concept that it depends what that information is. You know, I've heard a lot about, well, you didn't speak to Bloomberg and you didn't speak to Audible, for example. Well, if Bloomberg had returned our calls and talked to us about Mr. Young, that series of questions would have gone something like, Mr. Young says he worked for you, and they would have said, yeah, he got 3 of our employees out of Afghanistan, and he charged you this much, and they would have said, yes, and we were happy to pay probably because we got them out of Afghanistan. And then we'd say, you know, Mr. Young's online, and he's been saying he aligns corporate people to Afghans in need. Did Mr. Young ever ask you if you would support other Afghans that have approached him? And they would have said, no, that never happened, because that's what Mr. Young testified to. So actually, that might have been added into the story in a different way than they're implying. Maybe we would have said, you know, we were able to confirm that Mr. Young did do these great extractions for some corporate clients, but his representation that he's trying to help other Afghans and get them, corporations to help them, was something that no corporation could confirm to us as happening. So, you know, it's all context. Like, we don't know what people would say that we hadn't talked to, but we have to leave open the idea that more information would come in that might change our understanding. You know, I've talked about pulling stories, and it doesn't happen. I mean, this happened once or twice where it's the last minute, But those were because a source emerged out of nowhere and said something that we said, hold on, that's changing our understanding of the story. We can't go forward with the way it is. We're going to have to wait a day or two and change that. So it all depends what people say and how it impacts what we already have.
Mr. Nemex, if you could put up DX 123. So I'm showing you the script, or not the script, the transcript of the lead show on November 11th of 2021. Do you see that?
Yes.
Let's go to page 15. And Mr. Friedman was asking you questions about what words you used of Mr. Young in the story. Do you recall those questions?
I do recall.
If you would blow up the top, yeah, Mr. Nemex, you're right there, the second paragraph. Yeah, thank you. Nope, keep going up, please. Thank you. I'm sorry, we're doing this on the fly. Nope, not that one either. I'm sorry. Nope, not that one either. Keep going up.
Thank you.
Yeah, we just got to go to the top. There we go. Now blow up the second one. Thank you. I'm sorry about that. I need some caffeine. Can you read that for the jury, Mr. Levine?
We got Young's number and called, but he didn't pick up. In a text message, he told CNN that Afghans are trying to leave or expected to have sponsors pay for them. Quote, if someone reaches out, we need to understand if they have a sponsor behind them to be able to pay evacuation costs, end quote, which Young says are, quote, are highly volatile and based on environmental realities, end quote. Young repeatedly declined to break down the to say if he's making money.
Do you recall Mr. Young's testimony about this quote where he said it was clear as day that he was only taking money from corporate sponsors?
I do.
How do you interpret that quote?
I think it's very clear that he expects the money he takes is going to come not from an Afghan directly, it's going to come from someone underwriting that.
And those were his words that he provided CNN?
Those were his words.
And CNN included those in the article?
That's right.
Sorry, in the segment?
And the article.
Okay. I have no further questions, Your Honor.
All right. Ladies and gentlemen, the jury, if you've got any questions for Mr. Levine, jot them down. Otherwise, either way, tear out the page out of your notepad and fold it over, and the bailiff will collect it.
First, that's how good that white noise is.
Yeah, you get to hear that. Come on, counsel. Come up, we'll do our abbreviated review first. Are you ready? All right, we had a few juror questions, and just for the record, there were no objections by counsel or the court to any of these. First one, does a news outlet have a right to use someone's name if they don't want it used and ask several times not to use it?
Yeah, I think so. I mean, if they have a good reason. I mean, you see two people whose names we didn't use because there were security concerns. So there are reasons that we would do it. And I know, we're coming up to people who aren't in the news media, but we do give them a chance to explain that and explain why they don't think their name is. Just keep in mind, like with Mr. Young, he's asking to keep his name out, but he's out there publicly saying these things. It's not like and I think as we went through things, you actually saw Emma or Fuzz ask the question about one of the Afghans. Is he using his name when he's on Facebook asking for help? If so, why would we be giving him like a shadow over him if that's not what he's doing? So it is a consideration. It is something we listen to, but in the end, it's a judgment call how we do that. But especially if we're reporting the same thing someone is saying publicly, there's no reason for it. It doesn't make sense.
What amount of consideration was taken into account of Mr. Young not wanting his story to be told on air and saying legal action would be taken?
I would say, based on what Alex and Katie Bo have told me and what I recall, not much, because it really did feel like an attempt to stiff arm us and just keep us and scare us off. That's a pretty common tactic with a lot of people who aren't interested in having their story told. Doesn't mean we don't want to pursue the story. We felt it was an important story to tell, so that it wasn't a legit, that's how it was read in the interaction.
All right, and the preliminary note on this from the juror was Adam Levine testimony as himself, not CNN rep. Okay, so this is not in your CNN representative capacity.
Okay.
Do you think an organization that issues a disingenuous apology is discredited by that?
I don't think it was disingenuous in that our lawyers felt there was an apology that needed to be made for any misconception about aligning that banner with Mr. Young. Editorially, I know it gets so confusing going through all my different capacities I'm answering these questions. Editorially, though, I felt we were in solid ground. I felt like that story was legit. The banner was legit. I get that it ran, at the same time that Mr. Young was on camera, but it wasn't written that way. It wasn't written to refer to him. So editorially, I didn't see it. But as a corporation, our lawyers felt it was a due apology. And so in that sense, it was a sincere apology.
All right, and this next question has two parts. When you watch or read an apology, do you believe it right away? If you don't, why not?
I don't know what capacity I'm answering this as a viewer.
This is you as yourself, not as a CNN rep.
Yeah, I do. I mean, obviously, for the viewer, they have no sense of what's going on behind the scenes, and it was meant as the corporation to apologize to Mr. Young. I mean, what the viewer didn't know is it was done because there was a threat of a legal suit that he was demanding this apology happen. But they wanted the apology, they got the apology.
Yeah. Councilor, come up real quick. All right, and just for the record, one of the jurors that asked one of the questions that I just asked you had handed another note, and there's no objection from counsel or the court to kind of the follow-up on this. This is relating to the question where you, Adam Levine, testifying as yourself, not as the corporate rep, when I asked you on behalf of the jurors, do you think an organization that issues a disingenuous apology is discredited by that? The juror was asking, please answer the question directly, a organization, not yours. So,
If you repeat the question again.
yeah, the original question was, do you think an organization that issues a disingenuous apology is discredited by that?
No. And an organization or a company has a lot of reasons to issue those apologies. Sometimes it is for something like this, to resolve a legal matter. It's an attempt to do so. They're doing it for that. You know, I don't think an apology has to be, you know, an emotional apology when you're talking about a company. That correction that ran on the air was sincere. It was written to be as clear as possible about what the issue was at hand for our viewers, and that there was no intention of doing that. And so that apology was issued.
All right. Mr. Axelrod, any follow-up on those questions?
Yeah, just one question. I know, one question. Mr. Levine, you heard the juror question about naming Mr. Young in the story.
Yes.
Why did you feel it was all right to name Mr. Young?
Well, as I said again, nothing in that story that we used or described was any different than what Mr. Young was saying publicly himself, separate from CNN, gone on LinkedIn, said all these things, interacted with these people. In that sense, like, he's out there saying these things. Why does CNN feel they shouldn't be using his name if he is publicly out there doing so?
Thank you.
Mr. Friedman, any follow-up?
Your Honor.
Mr. Levine, you can step down.
Thank you.
Defense, next witness.
With that, Your Honor, CNN rests.
All right.
Your Honor, plans to have a motion. Can we just preserve our right to do that later?
We'll preserve that, yes.
Thank you.
We'll do that during a break.
Okay.
All right. You don't have any issue with that?
No, I mean, we have a motion. We
Yeah.
renew a motion.
All right. Both sides can preserve that. Plaintiff's rebuttal.
Yeah, Your Honor, plaintiff would call Mr. Young to the stand.
All right, Mr. Young. I think you know the drill. Just face the clerk.
I do.
All right. And just, yeah, make sure that microphone's positioned up close to your mouth.
Thanks.
Okay, Your Honor, I think we've just saved some time. We can, I think there's a stipulation, PX 9, 10, 11, 12, 15, 16, 22, 23, 29, 30, 45, 230, and 231. I will represent. They are Mr. Young's bank statements. And I believe there's a stipulation for them to come into evidence.
Yeah, we haven't had a chance to verify that all of those are bank statements. Assuming they are, that is fine. And we'll take it as soon as we get a break.
When we'll take a break, just look at those
Yep.
exhibits, make sure those are all, did you get all the numbers? Okay. All of those numbers, starting with 9 and going through whatever, plaintiff's exhibits will be admitted.
Morning, Mr. Young.
Good morning.
Do you still have a security clearance?
No, I don't.
When did you find out?
2 days.
Your Honor, plaintiffs have no further questions.
No. Any cross?
Yeah, very briefly, Your Honor. Just looking for my notes. Mr. Young, is it true that if a company holds your security clearance, they have to be all right? They have to be okay or have to approve doing work with you?
I don't know the details of that.
But you would agree that a company that agrees to hold your security clearance, isn't saying that we wouldn't do work with you, right?
That's right.
I know your testimony is that you now found out you don't have a security clearance. Isn't it true that you just know you don't have a security clearance with Helios?
Helios was the only one company can hold a security clearance. In my case, for many years, that was Helios. And I just found out that that hasn't been the case for a couple years.
Since 2022?
That's right.
But you have no idea whether the U.S. government has actually canceled your security clearance, correct?
No, I do. That it's common knowledge in our industry. You have to have a company hold your clearance for you. You don't get to keep it as an individual. I think you understand that.
And I'm asking you, did the U.S. government ever tell you that your security clearance was canceled?
They wouldn't do that. That's not how it works.
Really, my question is just, did the U.S. government ever tell you that your security clearance was canceled?
No, because that's not how it works.
For the record, I'll overrule the objection. I think he answered anyway. But did he answer the last question? Because I heard both of them talking at the same time.
Looking at the live, said, no, that's not how it works.
Yeah.
On the last one, when you started objecting?
Yeah, that's
Okay.
But you are aware that your security clearance was in place with Helios till November of 2022, correct?
Yes.
No further questions, Your Honor.
Any redirect?
No, Your Honor.
All right. Jurors have any questions on Mr. Young on the issue that he just testified to? We'll make you do. All right. Yeah. Go ahead and write down your note, any questions that you have, and pass your papers to the bailiff. Counsel. Mr. Young, I got a couple questions for you, but I do want to say that y'all submitted a couple of questions that I'm not going to ask, and based on the rules of evidence or procedure, prior rulings by the court, those are not appropriate necessarily for asking Mr. Young at this point. And just for the record, also, we'll discuss those issues on the record when we take our break in this case. So anyway, the questions that I can ask you, Mr. Young. And I'll read the question as it's written, because that's what I'm supposed to do. Do we have documentation
I assume that's related to the clearance, and we do have documentation that I had a clearance through Helios, and now we have additional documentation that's come to light in the last 2 days, also from Helios, informing me that they no longer hold my clearance.
What was the explanation of denial, is what's written in the question?
Am I allowed to get into that?
I mean, if you have the explanation.
Okay. I don't have a lot of detail at this point, and I don't want to speak for Ian Conway, who was the CEO of Helios, who was holding my clearance for many years. But, and again, I don't have the details, but they made a decision in 2022 that they no longer wanted to maintain my clearance, and I just found out about it. So I was pretty shocked.
All right. And the last question, which is similar, what was the reason your security clearance was canceled?
Similar answer. I just don't have the details yet. I plan on trying to get more information in the near future, but this came as a surprise to me and also my lawyers.
All right. Mr. Friedman, any follow-up on those questions?
No, Your Honor.
Yeah. Mr. Axelrod?
Yeah, just a few. Mr. Young, isn't it true that Helios let go of custody of your security clearance because the U.S. government never reestablished the contract that Helios had in September of 2022?
Yes.
Okay. And you have no information that Helios let go of your security clearance in 2022 because of the CNN publications?
That's correct.
Thanks. No further questions.
Anything on that, Mr. Friedman?
Just one question, Your Honor. Mr. Young, you don't know that it wasn't because of the CNN story, do you?
No, I don't. As I said, this just came to light, for me anyway, 2 days ago. So I still don't have a lot of details.
That's it, Your Honor.
All right. All right, Mr. Young, you can step down. Plaintiff have any other rebuttal?
That's all for Your Honor. That's all for us, Your Honor.
Okay. All right. So plaintiff rests.
Plaintiff rests, Your Honor. Plaintiff rests.
All right. You want to, I've got the copies of everything, but I wanted y'all to take a look at them real quick before I start reading any other instructions.
I also think, Your Honor, you need to potentially resolve those motions.
Okay. Well, and we need to address that. All right, so ladies and gentlemen of the jury, the testimony and evidence is concluded at this point in time, so that gets us into giving some instructions to you and closing arguments and then getting y'all to start deliberating. We need to take care of a couple things. Why don't we take a break till 10:15? So it's just over a half hour. I think we should be able to get that wrapped up, but y'all can go hang out in the juror lounge. If you need to use the restroom, do that. But be back in the juror lounge at 10:15. and then we'll get you back in here. All right, we're going to take our morning recess. Remember, all the rules I've given you apply even when we're outside the courtroom, such as at recess. Remember the basic rule: do not talk to anyone, including your fellow jurors, friends, family, or coworkers, about anything having to do with the trial except to speak to court staff. This means no emailing, text messaging, tweeting, blogging, or other form of communication. You cannot do any research about the case or look up any information about the case. Remember to observe during our recess the other rules I gave you. If you become aware of any violation of these rules at all, notify court personnel. And when you're coming back in the courtroom, if you do use your phone or electronic device, make sure they're turned off. Just go ahead and put your notepads in the folders, leave them on your chairs, and we'll get you back in here hopefully right about 10:15. We'll be in recess till then. All right. Jurors are out of the courtroom. Y'all can be seated. I've got my judicial assistant bringing the printouts and copies so y'all can take a quick look at them on the jury instructions and the verdict form. Look at that timing. Six copies for the jury and one for each side. So have them take a look at those. Or take a look at it real quick. We'll need the 6 copies back, but I just want them to make sure that. Yeah. All right. My assistant's got the printouts from the clean set of instructions that I sent y'all this morning. Yeah, there's one verdict form for each of y'all. There's one set of jury instructions for each of y'all, and then there's 6 copies to go back to the jurors. There's one of the.
Are we supposed to have the copies for the jurors?
No, I just wanted y'all to make sure and verify that you're good, that they're the exact same thing. And under Rule 1.470B, it says each juror gets a copy. That's why there's 6 copies.
We just need a couple, thanks.
Yeah, there's 1 copy for each side and then 6 extra copies, but I just wanted y'all to verify that you're good, that the 6 copies are exactly the same as what I'm reading.
They're not different based on the color coding, are they? No.
Hope not.
In Your Honor, would you like to hear directed verdict? Or
Yeah, we'll do those.
You give me those questions, the last set of questions.
And let's do this real quick. The juror questions for Mr. Levine, since we didn't make a record at sidebar. Not for Mr. Levine, sorry. For Mr. Young. There was a question that was asked, did you try to find work after the CNN publication, and if so, what did you do? An objection was raised by the defense that the court agreed with, that it was outside the scope of his testimony in rebuttal. So I sustained the objection to that one. There was another question, beyond reaching out to former colleagues, have you sought employment? Again, there was an objection by defense counsel as being outside the scope of his rebuttal testimony, and the court agreed with that and sustained the objection and didn't ask it. And finally, there was a question that was not asked of why did you wait 4 months before writing to CNN? That was objected to. I know defense objected to it. Did plaintiff agree that it was outside the scope of rebuttal?
I don't believe so. What was the question?
Why did you wait 4 months before writing to CNN?
Seems fairly outside the scope of rebuttal.
I think plaintiffs agreed. And the court agreed. So we were all on the same page on that one. And hence I didn't ask that. So on both of the first two plaintiffs, plaintiffs did want to, and I don't know if you want to state on the record your reason, your argument of why you wanted those questions asked.
Your Honor, I just think that Mr. Axelrod asked questions that related to doing work with Helios, and so it opened the door to those questions.
All right. So that deals with that issue. I guess since defense rested, plaintiffs have a motion. Mr. Roche?
Yes, Your Honor. Plaintiff moves for directed verdict on the affirmative defense, on CNN's affirmative defense of mitigation. I think there's 2 points that are worth emphasizing. So to start, CNN has the burden to show that Mr. Young failed to mitigate his damages. And the law on mitigation in Florida requires 2 things. 1, for it to be comparable work, and 2, for it to be confined, the work needs to be confined to the immediate community or neighborhood. Going in reverse order, CNN presented no competent evidence of any opportunities available to Mr. Young in the immediate community or neighborhood of where he lives, Austria. Case site I'd like to give you is 290 SO.2D 505. It's Punkar v. King Plastic Corp. Discusses the law on, it is in relation to a wrongfully discharged employee, but the law on mitigation is the same in that context. The area in which a search is confined to must be reasonably related to where Mr. Young lives. And the only evidence that defense presented was evidence of opportunities here in America, not abroad. Their expert, Mr. Humphreys, said he wasn't aware of work that Mr. Young could perform in Austria, comparable to work that he could perform in Austria. The second reason that they didn't meet their burden, there's no competent evidence to show that they've met their burden on mitigation, is Mr. Young doesn't have security clearance anymore. And I think Mr. Humphreys said it best, if you don't have a security clearance in this industry, you're dead. And so there's no evidence in the record that Mr. Young could go and get the comparable work that Mr. Humphreys testified. We would dispute that it's comparable, but I think it's an easy issue to decide because he doesn't have a security clearance right now. I understand they're going to argue, well, maybe he could go get a security clearance. Maybe it didn't have to do with this segment, but that's their burden. And if they wanted to make that argument, they brought this exhibit into the case. Won't relitigate that, but they knew he no longer had a security clearance when they made their mitigation, presented their evidence on mitigation. And so the fact that he doesn't have it now, they have failed to meet their burden that there is comparable work that Mr. Young can go and secure. So on those 2 bases, can't find there's no comparable work that they've presented that the jury could consider deciding that Mr. Young failed to mitigate damages. And second, they presented no work whatsoever, comparable or otherwise, that Mr. Young could find work in the immediate community or neighborhood. They've failed as a matter of law to present their mitigation defense to the jury.
Does it matter? Normally you'd be making your argument at the close of the defense case that during their case in chief, they didn't present evidence to substantiate the burden. However, the evidence that he didn't have a security clearance wasn't until rebuttal case after they had arrested. Does that matter or not from the standpoint of a directed verdict as to the second issue?
So at the time they arrested, there was no competent evidence that they presented that he still did maintain his security clearance. And so I'd say even at time of arrest, I understand in our case that Mr. Young testified he believed that he still held his security clearance. That turned out to be not true. And so I believe that, and I don't, I'm not going to shoot from the hip on this one. I don't know whether or not the rebuttal case can be considered in the directed verdict motion. But I think the fact is that they failed to meet their burden that he still does have a security clearance. And I think, I think the easier issue, quite frankly, is the immediate community or neighborhood.
All right. Anything else, Mr. Rich?
Nothing at this time.
All right. You want to respond to that one?
Yeah, very, very quickly, Your Honor. On the immediate neighborhood or community or neighborhood, I think that kind of is a irrelevant issue for this case. I mean, Mr. Young testified that really his work was international. I mean, even when he was in Vienna, he was doing the Saudi Arabia project for Amentum. And why I highlight that is Mr. Humphreys testified that he didn't even need a security clearance for Amentum. And he said, and the record testimony is that he made $360,000 a year working for that KSA project for Amentum. And Mr. Humphreys was very clear. He said there's lots of jobs on the boards you can get on the clearance jobs. But for Amentum, you didn't even need a security clearance because that was just a private contract. That was Mr. Humphreys' very clear testimony. Mr. Young also testified that he never did, first of all, he testified that he had this large community of contacts who referred him jobs. He then testified that he never did anything to reach out to those people after the CNN publications. So the combination between Mr. Young's testimony that he did nothing to reach out to those people after CNN and Mr. Humphreys' testimony that there were all these job boards available for people in his industry. And as Your Honor may remember, he walked through kind of a LinkedIn profile of how Mr. Young would have gone about buffering up his profile to get a job like that. And then tying that in with the fact that Amentum was not a job with which he would need a security clearance, I think more than satisfies our burden to survive a directed verdict on mitigation.
All right. Anything else?
Your Honor, I can't answer competently the procedural question.
Yeah, and maybe it's really not. Obviously, I don't know that I'm suggesting this, but obviously I can renew it at the close of the trial anyway. So
right.
I don't know that the timing aspect necessarily matters other than the evidence before when you rested your case was you had a security clearance still current, but to the extent that they would be renewing it at the close, I don't know that it necessarily matters, and I can consider the rebuttal. All right.
Thank you.
All right. On the plaintiff's motion for directed verdict, I'll reserve ruling on that. Any other motions or anything else on the plaintiff's side?
Your Honor, I think the only concern I would have is, in reaching the verdict form, if the jury's instructed that they can consider mitigation, it could substantially, I don't know if there's a way, I don't know if you can unring that bell.
Oh. We'll deal with that if I need to.
Okay.
All right. Any other motions or anything else on the plaintiff's side?
No, Your Honor.
Defense?
No, Your Honor.
All right. You said something about renewing.
Yes.
I guess you're waiving that? All right, good. And the record will reflect defense waived renewing their motion for directed verdict.
We are. CNN is renewing its motion for directed verdict, Your Honor. But for all the same grounds that Mr. Tobin already argued.
All right. Anything? You're not adding anything else, Mr. Tobin, at this point?
Not
Mr. Axelrod.
Your Honor, other than the testimony, the additional testimony, of course.
Right.
We offer all the same evidence in rebuttal. The only thing I'd add is I recall the next morning I woke up and remembered that I forgot to say that one of the pieces of evidence of malice is Mr. Young warning CNN that the statements were untrue and that he would come after them. And so I had forgotten to say that, so I will add it to the renewed, in opposition to the renewed motion.
Your Honor, just to respond briefly on that, the case law in Florida, Don King Productions case versus ESPN with mile marker. I think mile marker also stands for the proposition of the fourth DCA that a mere denial or a mere threat from the story side does not give rise to it if it's a malice.
All right. All right, now reserve on defendant's renewed motion. All right, anything else we need to address before I start talking and reading a whole lot?
Well, we're almost finished, just proofreading.
Yeah, no, I'll give you a moment on that. We got another 16, 17 minutes or so. I was going to go get some more coffee in case my throat gets dry, because I'll be reading a whole lot. So I'm fine with coming back and addressing it, but before that, anything else we need to deal with?
No, Your Honor.
All right. Do we need to?
One moment, Your Honor. So, Your Honor, we have some evidence for the evidence finder for the clerk, but I'm not sure we need to do that right now.
Things that are already admitted that just need to be added to it?
Yes, Your Honor.
Okay. All right. Why don't we, when I go grab some more coffee, they've seen it, they know what the documents are?
I'll walk it over and work.
Okay. Just verify the documents that he's adding to the evidence binders here, and we'll get those added in as exhibits that we had. What I'm contemplating is me reading the instructions and then going, and now the parties will give their closing arguments. We've got an hour and 45 minutes that y'all had stipulated to for closings in the pretrial stip. That probably would, and I'm sure the plaintiff will reserve some amount of time, that'll probably get us up till 12 or right around 12, and hopefully lunch will be here right around 12. You want to break, let them eat for a half hour, come back and do your closing and then your rebuttal, and then I'll do the final instructions and get them out to deliberate.
I would rather not break. I mean, I know they need a break.
Yeah. I mean, they're going to have to be a break after an hour and 45 minutes, plus me. They'll need a break.
I don't know how long. I would be surprised if it took an hour and 45 minutes. Candidly, I don't know, because I have never tried to go start to finish, given that we were furiously typing earlier this morning, Your Honor. So I actually don't know how long it's going to take. But it may be less, significantly less.
All right.
But I think I'm sorry to cut you off.
No, it's okay.
I mean, even if it was less, I mean, we would still come up against 12 o'clock, and we would be running. I mean, if we started at 10:30, which is probably optimistic.
Yeah, I mean, me reading, because I'm going to read the majority of that set, and that'd probably take at least 15 minutes.
So, Mr. Sanborn is providing very good counsel that we should probably take a break in between the two closings.
Yeah, and we can do it a little bit shorter if we want to. I mean, I don't know that it'll take them that long to eat lunch, but I mean, obviously a half hour would be the max that we're going to go. That's what we've been doing, but we'll see if they're okay with spending 20 minutes grabbing something and then coming back.
I'd ask the jury how much time.
Yeah.
There is one issue about plaintiffs. Plaintiffs and defendant swapped closing decks, and we have one issue with plaintiff's closing deck. I don't know if you want to hear it now or we can hear it later.
No, let's do it now, because when I get them back, I'm planning on
Is it only one slide?
reading and rolling.
I think it's only one slide, I think. It looks like plaintiffs intend to show video that's been cut from the YouTube live stream, which is quite honestly something that we considered, but in consultation with Mr. Sanborn thought better of it, because that is not what's in evidence. And well, perhaps, maybe we all know that it probably is accurate. We can't say that. And so we would ask, I think it's just slide 74 of plaintiff's closing, though there might be other ones that we missed. But we would ask them not to show the live stream video.
I think 74 is just a I see. It's got the little banner on the bottom.
Yeah, there's just a link to YouTube.
I see.
So you don't want the video played, or you have an issue just at the banner at the bottom of it saying YouTube?
I have no problem with it with YouTube.
Okay.
It's the video itself.
I don't know that it's a video as opposed to a still. I don't know what 74 correlates to. If it is just a still capture, does it bother you?
I'm not going to object
Is
to
it
it.
something the jury saw?
And they saw.
Yeah. I mean, well, obviously, yes. This is an evidence.
Yeah.
I mean, they didn't see his picture. I think the picture looks a little older than Mr. Hogan when he took the stand.
But I'm flattering picture.
But I'm not going to quibble about that.
Give me the bad picture back, actually. There.
Yeah, but if you look at, so this is a little bit, there's a banner at the bottom of the insert that says Law and Crime, and that certainly didn't come in as evidence in this case.
Is there a way that y'all can address the banner at the bottom?
Yeah, and there's actually a comment right under his name that says, his efforts to save lives in Afghanistan as a security consultant were distorted by...
Yeah, we might be able to redact that.
Yeah, can y'all redact that? And can you verify if it was just a still? Oh, it's a video?
Is it a video clip? 74 is a video clip? No. Makes sense. It does actually appear to be a video of him testifying, which we will remove that. I wasn't aware of that. So if you give me a few minutes, I'll figure out how to...
Yeah, I mean, I'd probably have more of an issue of the Law and Crime logo or whatever's on there, and if there's a commentary that was posted by them of what the testimony was, because that's clearly not evidence or testimony that was presented to them.
Only because it might be easier if we are able to, and I don't know if this is possible, if we can redact that.
You can put a box over the video on the banner.
If we put a box over the banner, can we then play, it would still be his testimony, the video of his testimony.
It was testimony of one of the witnesses, Mr. Hogan.
Mm-hmm.
And we can put a black box over the banner, right, Corey? Just want to make, okay.
And I still do have concerns about it. Yeah, it's YouTube. If it was court, if it was the court, if it was a deposition, fair game.
That was shown to the
That was shown to the jury, of course. But the YouTube aspect of it, I think, just introduces uncertainty. And again, I say it's probably accurate. I'm not.
It's not very long. Do you want to take a look at it?
I mean, what's the difference, though? I mean, I would do it all the time where we'd get, well, you guys got the dailies here. I mean, I did it without the dailies where we'd tell the court reporter, print us out, these pages on the testimony, and we'd blow up the transcript of it. I mean, this is just the actual, I don't have a problem with it if it's his testimony here, it's what the video was. Why don't you look at it and see if you really have a problem with it? But I don't know that it's really any different than getting the transcript of, and reading the transcript, other than it's not Mr. Hogan's face saying it.
Part of it is you instructed the jury not to watch, they couldn't go back and watch the previous days, and that's effectively doing the same thing if they roll the tape.
Ask Bill about that.
But if it's a short clip and it's
Well, my question is, how is that any different than getting a copy of the transcript and reading it?
as long as we can verify that, it's accurate, but with YouTube, you don't have, with AI, I'm a knuckle dragger when it comes to technology, but somebody could dub in a word over something else.
All right, and maybe there's a way that you can verify wherever it was in Mr. Hogan's testimony that it matches the transcript, especially if it's not very long.
Yeah, if it's not,
How long is it for you, Cliff?
25 minutes. No.
Less than 10 seconds. Less than 10 seconds.
Less than 10 seconds.
All right, why don't you see if you can find on the dailies what page you got of Mr. Hogan's and verify, so y'all look at the video and verify that he's not, it's not a deep fake as Mr. Sanborn's concerned about.
Okay, so I now I know why this is happening. The actual transcript has an official correction filed, but it's the official correction filed by the court reporter says you should insert the word true into the question. And so the court reporter issued the transcript. It was inaccurate. They filed an official correction of the transcript, but they don't like replace it with a new one. They just say, they file a page that says you should insert the word true. So it's very, very complicated to kind of present.
I need to understand this.
Do you have the pages?
Do you have the page of Buzz Hogan's transcript?
They supplemented the transcript.
Me neither. This is all new to me.
Yeah, I'll have extra copies.
Yeah.
Transcripts. Yeah.
All right, why don't y'all talk off the record and see if you can, I think I understand what Mr. Freeman was saying was that instead of trying to read a printout of the transcript of what Mr. Hogan said, because the transcript as originally sent out by the court reporter left out a word and they just supplement it with you need to insert the word true here or something like that instead of it reading the way. That's why I wanted to play the video, because it actually had him saying it with the word that had been left out of the transcript.
That's right. But we're going to pull.
But I think that may be what the issue is. But why don't y'all talk about that? I'll be right back. Let me just get more coffee.
Yeah, so
Y'all resolve the issue on,
We did.
okay. Well, good. All right, we all okay with the clean set of instructions?
Yes.
Do we have the 6 copies?
I guess we'll give them, Judge, because we forgot to review them, so.
So we have one for each side and then 6.
And there were 6 copies.
Here's one. Yeah, we have one copy still.
You get to keep one, Your Honor?
Y'all each get to keep 1, and then there were 6.
Can I return our other 3?
There you go, here's the other 4. Oh, we got another one. Here's the 5th.
You want extra copies?
We printed out what you sent us this morning.
Okay. All right, you got 6? 5. Yeah, they each got a copy of the verdict.
Yeah, we just have one copy over here.
All right, here's a,
Here. Yeah, I researched my copies.
you got it? All right.
We'll be fine, we'll be fine.
Where the guilty party, agreed.
All right, because I had it said I was going to hand it to the clerk to file. And I guess let me, I know defense, y'all had filed your requested ones, the ones that we talked about, 14, 15, and all those, y'all had already filed that. Mr. Delich, what you guys sent me this morning,
I think it's okay, Your Honor. We don't need to.
well, I was just going to say file a copy of it so you've got it in the record of the request that you had on the eggshell plaintiff one.
Yes, Your Honor.
And y'all got that email?
We did.
Okay. All right. All right. Anything else we need to? Anything else we need to address before we get the jurors back and I start reading instructions?
Not for plaintiff.
And not from CNN.
All right. Good deal. And we'll go till right about 12 with the plaintiff's closing, and then take a break for, and I'll ask them how long. Okay.
Jurors entering.
All right. Y'all grab your seats when you get back to them. All right. Members of the jury, you have now heard and received all the evidence in this case. I'm now going to tell you about the rules of law that you must use in reaching your verdict. You will recall at the beginning of the case I told you that if at the end of the case I decide a different law applies, I will tell you so. These instructions are slightly different from what I gave you at the beginning, and it is these rules of law that you must now follow. When I finish telling you about the rules of law, the attorneys will present their final arguments, and you will then retire to decide your verdict. And let me tell you, you're going to get a set of these back in the jury room, so you don't necessarily need to take notes on all the law that I'm instructing you. Okay, so. Plaintiff Zachary Young seeks to recover damages from defendant Cable News Network, Inc., CNN, for allegedly false statements that plaintiff claims defendant published about plaintiff on defendant's television programs, its website, and in social media posts. The law calls this type of claim a claim for defamation. And the publications at issue in this case, the publications at issue in this case were made at the following times and through the following mediums. 1, a video segment that aired on The Lead with Jake Tapper on November 11, 2021, hosted by Jake Tapper. 2, a video segment that aired on Connect the World on November 12, 2021, hosted by Max Foster. 3, a video segment that aired on CNN Newsroom on November 13, 2021, hosted by Boris Sanchez and Amara Walker. 4, a video segment that aired on CNN Newsroom on November 13, 2021, hosted by Jim Acosta. 5, a video segment that aired on CNN Newsroom on November 14, 2021, hosted by Michael Holmes. 6, a video posted on Facebook. 7, a video posted on CNN's website. 8, the lead tweet. 9, at NetSec CNN tweet. 10, Alex Marquardt's tweet. 11, Alex Marquardt's Instagram post. 12, the digital article. The issues for your determination on plaintiff's defamation claims are: 1, whether defendant published the statements. 2, whether the statements were of and concerning Zachary Young. 3, whether the statements were materially false. 4, whether the statements were defamatory. 5, whether defendant acted at least negligently in publishing the statements. And 6, whether plaintiff suffered actual damages as a direct result of the statements. Plaintiff must prove his claims by the greater weight of the evidence. Additionally, if you find that the greater weight of the evidence supports plaintiff's defamation claims, you shall also consider whether plaintiff should be awarded punitive damages. If you find that the greater weight of the evidence does not support plaintiff's defamation claims, then your verdict must be for the defendant. I now want to instruct you on certain issues that have already been decided in this case. The following issues have already been settled. Defendant published the segment, the article, and each of the social media posts at issue. Plaintiff advertised his services to Afghans. Plaintiff did not act illegally or criminally. Plaintiff did not take money from Afghans. For purposes of the defamation by implication claim, that the publications were of and concerning plaintiff. Defendant's use of the words exorbitant and exploit to refer to plaintiff's prices and/or his business activities are not by themselves actionable because they are statements of opinion and cannot alone serve as the basis for liability for defamation. And defendant did not publish any statement that called plaintiff a scam artist or state that plaintiff was operating a scam. These are issues that have already been decided in the case and that you will not be asked to decide. In deciding the issues that you will be asked to decide, you may take into account these already decided issues. And I will now define some of the terms you will use in deciding this case. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Plaintiff must prove that persons who viewed and read the segment and article understood them in the way that he claims. That is, as implying that he was engaged in criminal activity or that he was preying on Afghans by taking money directly from Afghans. The meaning of a challenge statement must be determined by its natural and probable effect on the mind of the average viewer or reader. The average viewer or reader is a reasonable person of ordinary intelligence, education, and background who would be representative of those who actually read or viewed the publication. To determine whether a statement is actionable, you must examine the statement in its totality in the context in which it was uttered or published. You must consider all the words used, not merely a particular phrase or sentence. In addition, you must give weight to cautionary terms used by the person publishing the statement. Finally, you must consider all of the circumstances surrounding the statement, including the medium by which the statement is disseminated and the audience to which it is published. To recover on his claims for defamation, plaintiff must prove that the statement and implication he takes issue with were, in fact, reasonably understood by the ordinary reader as referring to him in particular, that is, that it must be of and concerning the plaintiff. I've already determined that for purposes of the claim for defamation by implication, the statements were published of and concerning plaintiff. For plaintiff's defamation per se claim, you must find the statements were published of and concerning Zachary Young. A statement is defamatory if it tends to harm plaintiff's reputation, tends to lower him in the estimation of the community, tends to expose him to hatred, ridicule, or contempt, tends to injure him in his business, reputation, or occupation, tends to deter third persons from associated or dealing with him, or charges that plaintiff committed a crime. Not every unpleasant or uncomplimentary statement is defamatory. A statement is not defamatory merely because it is mean, embarrassing, or upsetting. Florida law holds that certain statements are so harmful in nature that they are presumed defamatory as a matter of law. A publication may be defamatory per se when it, 1, charges that a person has committed a crime, 2, it charges a person with having an infectious disease, 3, it tends to subject one to hatred, distrust, ridicule, contempt, or disgrace, or 4, it tends to injure one in his trade or profession. Defamation can also be implied. Even when statements are true, they are defamatory if the statements juxtapose facts and create a false impression that tends to harm plaintiff's reputation, tends to lower him in the estimation of the community, tends to expose him to hatred, ridicule, or contempt, tends to injure him in his business, reputation, or occupation, tends to deter third persons from associated or dealing with him, or charges that plaintiff committed a crime. A defamatory implication can also be created by omitting facts. An omission of fact is defamatory if it creates a false impression that tends to harm plaintiff's reputation, tends to lower him in the estimation of the community, tends to expose him to hatred, ridicule, or contempt, tends to injure him in his business, reputation, or occupation, tends to deter third persons from associating or dealing with him, or charges that plaintiff committed a crime. In order for plaintiff to recover on his claims, the statement and implication about which plaintiff complains must be materially false. A statement is materially false if the substance or gist of the statement conveys a materially different meaning than the truth would have conveyed. A statement is also materially false if it creates a materially false impression or implication. To determine whether a statement is materially false, you should consider the context in which the statement was made. The fact that a publication may have contained some false information does not necessarily make the publication materially false. Minor inaccuracies regarding factual information do not make a publication or statement false. If the gist or the sting of the allegedly defamatory statement produces the same effect in the mind of the recipient as the precise truth would have produced, then the statement is substantially true and not materially false. To recover on his claims against defendant, plaintiff must prove that defendant was at least negligent in publishing the statements in this case, and if so, whether that negligence was a legal cause of the loss, injury, or damage to plaintiff. Negligence is the failure to use reasonable care, which is the care that a reasonably careful person would use under like circumstances. A statement is a legal cause of loss, injury, or damage if it directly and in natural and continuous sequence produces or contributes substantially to producing such loss, injury, or damage, so that it can reasonably be said that, but for the defamation, the loss, injury, or damage would not have occurred. In order to be regarded as a legal cause of loss, injury, or damage, a statement need not be the only cause. A statement may be a legal cause of loss, injury, or damage, even though it operated in combination with the act of another, if the defamation contributes substantially to producing such loss, injury, or damage. If you find for plaintiff on the defamation claims, you should award plaintiff an amount of money that will fairly and adequately compensate him for such damage as the greater weight of the evidence shows was caused by the statements and publication of the statements in question. If you find that the statement and implication plaintiff ascribes to the segment and article were not the legal cause of any actual injury to plaintiff, then your verdict must be for defendant. Any amount of damages which you allow for loss of ability to earn money in the future should be reduced to its present money value, and only the present money value of these future economic damages should be included in your verdict. The present money value of future economic damages is the sum of money needed now which, together with what that sum will earn in the future, will compensate plaintiff for these losses as they are actually experienced in future years. If, however, the greater weight of the evidence supports one or more of plaintiff's claims, then you shall consider the defense raised by defendant. As a defense to plaintiff's claim for economic damages, defendant contends that plaintiff could have reduced his damages by making a reasonable effort to seek and retain comparable employment. Comparable employment means alternative employment similar to plaintiff's former job in the nature of the work, responsibilities, and skills required. Plaintiff need not accept employment that is unsuitable or demeaning when compared with plaintiff's former job. The burden is on defendant to establish that plaintiff failed to exercise reasonable diligence in mitigating his damages. If the greater weight of the evidence supports defendant's claim that there was comparable employment available to plaintiff and that plaintiff failed to make a reasonable effort to seek and retain such employment, then you should reduce any damages you award to plaintiff by the amount of money that plaintiff could have earned from the comparable employment. If, however, the greater weight of the evidence does not support defendant's contention that there was comparable employment available to plaintiff and that plaintiff failed to make a reasonable effort to seek employment, then your verdict should be for plaintiff in the total amount of compensation for economic damages that is fair and just and not wholly remote or left to conjecture or guess. There is an additional claim in this case that you must decide. If you find for plaintiff and against defendant, you must decide whether, in addition to awarding damages to compensate for his injuries, whether punitive damages are warranted as punishment to defendant and to deter others. The trial of the punitive damages issue is divided into two parts. In this first part, you will decide whether the conduct of defendant was such that punitive damages are warranted. If you decide that punitive damages are warranted, we will proceed to the second part of that issue, during which the parties may present additional evidence and argument. I will then give you additional instructions, after which you will decide whether, in your discretion, punitive damages will be assessed, and if so, the amount. Punitive damages may be awarded if you find by clear and convincing evidence that defendant acted with express malice and actual malice. Express malice means that defendant acted with a primary motive to injure plaintiff and had ill will, hostility, or an evil intention to defame plaintiff, or was motivated by a desire to harm plaintiff. Actual malice means that defendant either knew the statements were false or published them with reckless disregard of whether they were false or not. Reckless disregard is where the defendant, in fact, entertains serious doubts as to the truth of the publication and is not measured by whether a reasonably prudent man would have published or would have investigated before publishing. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such weight that it produces a firm belief or conviction without hesitation about the matter in issue. Plaintiff claims that punitive damages should be awarded against defendant for the conduct of its employees in reporting, writing, and delivering the challenged statements. You may award punitive damages only if plaintiff has proved by clear and convincing evidence, 1, that any of those employees personally acted with actual malice and express malice, 2, their actions were a substantial cause of injury to plaintiff, and 3, that defendant was also complicit because A, defendant actively and knowingly participated in the conduct of its employees, or B, the officers, directors, or managers of defendant knowingly condoned, ratified, or consented to the conduct of its employees, or C, defendant engaged in conduct that constituted gross negligence and that contributed to the injury to plaintiff. Gross negligence means that the conduct of defendant was so reckless or wanting in care that it constituted a conscious disregard or indifference to the life, safety, or rights of persons exposed to such conduct. In deciding this case, it is your duty as jurors to decide the issues, and only those issues, that I submit for your determination. You must come to an agreement about what your answers will be. Your agreed upon answers to my questions are called your jury verdict. The evidence in this case consists of the sworn testimony of the witnesses, all exhibits received in evidence, and all facts that were admitted or agreed to by the parties, and any fact of which the court has taken judicial notice. In reaching your verdict, you must think about and weigh the testimony and any documents or other material that has been received in evidence. You may also consider any facts that were admitted or agreed to by the lawyers. Your job is to determine what the facts are. You may use reason and common sense to reach your conclusions. You may draw reasonable inferences from the evidence. In addition, you may, but are not required to, make certain adverse inferences I will instruct you about. But you should not guess about things that were not covered here, and you must always apply the law as I've explained it to you. Let me speak briefly about witnesses. In evaluating the believability of any witness and the weight you will give the testimony of any witness, you may properly consider the demeanor of the witness while testifying, the frankness or lack of frankness of the witness, the intelligence of the witness, any interest the witness may have in the outcome of the case, the means and opportunity the witness had to know the facts about which the witness testified, the ability of the witness to remember the matters about which the witness testified, and the reasonableness of the testimony of the witness considered in the light of all the evidence in the case and in the light of your own experience and common sense. You have heard opinion testimony on certain technical subjects from persons referred to as expert witnesses. You may accept such opinion testimony, reject it, or give it the weight you think it deserves, considering the knowledge, skill, experience, training, or education of the witness, the reasons given by the witness for the opinion expressed, and all the other evidence in the case. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited just because the witness talked with the lawyer about his or her testimony. If you find that plaintiff destroyed or otherwise caused evidence to be unavailable while it was within his possession, custody, or control, and the evidence would have been material in deciding the disputed issues in this case, then you may, but are not required to, infer that this evidence would have been unfavorable to plaintiff. The court has already determined that plaintiff had a duty to preserve the following evidence, but he destroyed or otherwise caused this evidence to be unavailable. 1, screenshots not preserved, transferred, or saved in electronic format after November 11th, 2021. 2, data not preserved or transferred pertaining to messages or phone calls made by plaintiff's old cell phone, or made on plaintiff's old cell phone after November 11th, 2021. 3, signal messages that were deleted and not saved after November 11th, 2021. And 4, plaintiff's LinkedIn private messages that were deleted after November 11th, 2021. You may consider this, together with the other evidence, in determining the issues of this case. During the trial, I've ordered that certain testimony or other evidence be stricken from the record, and you have been instructed to disregard this evidence. Do not consider any testimony or other evidence that I have ordered stricken. Do not speculate about what a witness might have said or what an exhibit might have shown. That is the law that you must follow in deciding this case. The attorneys for the parties will now present their final arguments. When they are through, I will have a few final instructions about your deliberations. Any other preliminary instructions subject to, obviously, our prior discussions on this plaintiff? Anything else from the defense? All right. And Mr. Friedman, whenever you're ready, how much time do you want to reserve?
Can you let me know when I'm at 15?
Left.
Left, but I may end early, in which case I'll
Okay.
reserve a little longer.
That's fine.
Good morning.
And if you want to move that over anymore, feel free. Yeah, 'cause I think we did opening somewhere in there, but I'm just saying, wherever y'all, either one of y'all feel comfortable, that's fine.
Good?
Okay. Good morning. It's been a while since I got to talk to you. I enjoy voir dire a lot because it gives me an opportunity to interact with you. And today, I don't really get to hear from you until you render your verdict, but at least I get to speak directly to you. Most of the time, I'm facing this way, so it's a nice change. I've obviously had a lot of opportunity to spend time with Zach, and we're staying in this beautiful hotel down the block, and we've tried to make a little bit of a ritual of taking a little bit of a morning walk or so just to kind of debrief. And I told him that today was going to be the last time I get an opportunity to talk to you, and was there anything he wanted to say? And he just said he wanted to tell you that he thanks you all. He's been watching you. You're all paying very close attention, and the questions you all are asking are just really demonstrate how closely you paid attention to this. And whatever your verdict is.
Your Honor.
Okay. During CNN's opening statements, well, let me say I thank you for listening and paying attention. It's been obvious how engaged you are, and on behalf of my client, thank you very much. During CNN's opening statement, their lawyer told you that every word you're going to see in CNN's reporting was true. Every word was going to be accurate. That was not a true statement. Fuzz Hogan, a member of CNN's triad, testified that he was satisfied with a story that was 3/4 true. Now, they did use some of Zach's words, but they deliberately left out the most important points. The parts that some witnesses said were interesting, that no Afghan was ever expected to pay, and that he only worked for corporate sponsors. The lies CNN told got so convoluted on the stand that they couldn't even keep them straight. Ms. Lillis thought CNN had actually included those statements in their reporting. Even CNN's on-air apology to Mr. Young was a lie. Every single CNN employee got up on this stand and told you that they thought black market was accurate. Each of them paraded a uniform lie that they thought the term black market meant an unregulated market. Each of them conveniently told you that they understood the word to mean the opposite of every single dictionary. And Mr. Levine, CNN's star witness in this case, who sat through the entire case, told you that the only reason they apologized was because it was legal strategy. None of them are sorry. All of them said they would do it again. We made a point of making sure that was clear. Would you do it again? We asked every one of them. Everyone said they would. They said they had nothing to apologize for. And when we asked Mr. Marquardt if he had any remorse for the fact that, let me rephrase that, when you all asked Mr. Marquardt, I don't know who, but one of you asked Mr. Marquardt if he had any remorse for the fact that Zach can no longer work in the space he was trained for as a result of this reporting, He said he had no remorse. Now, Mr. Levine said something yesterday that I thought was really important. He told you that there's no evidence that came forth in this trial that there was a conspiracy. Mr. Levine was either mistaken or misrepresenting the truth to you. At the beginning of this trial, we told you to look very closely at the words CNN used before this lawsuit was filed and compare it to the words that you would hear in this courtroom. Each and every one of CNN's employees who testified that came into this courtroom looked you all in the eyes and told you that words don't have meanings, up is down, and wrong is right. Mr. Lumley, Tom Lumley, the British man, he was the only one who couldn't lie to you with a straight face. He lied with his words, but we each saw that that man was shaken to the core. That man's conscience was ripping him into on the stand, and he hated the fact that CNN was forcing him into this conspiracy. If CNN is willing to do this to Zach, a patriot who served this country as extensively as he did, they're willing to do it to anyone. Something that makes America unique is that it's not always the politicians or the rich or the powerful that drive the course of our country. Some of our most important moments are driven by everyday Americans, like you. That's how this country was founded. To this day, we may not know the names of the people that dumped the tea in the Atlantic up in Boston, telling Britain that we would not answer to their king. But they're responsible for this country and where we are today. America is one of the only countries in the world that has jury trials for civil cases. Think about that for a second. We are the most powerful and richest country in human history. And we also just happen to be the only country that allows a group of strangers to decide cases of this magnitude. We believe that each one of you has an opportunity to change the course of history today. These are polarizing times, and mainstream media organizations are responsible for driving much of the nastiness that we've seen in our culture. Mr. Young took this case this far because he's always believed in the concept of America. He chose to serve this country because of that belief, and he's now choosing to put his trust in you to cure this injustice and send a message that our news organizations must be held accountable. I want to start to take you through some of the evidence we've seen in this case. And I want to start where it began. And I think it's important that the story begins with Zach. And it's important that you know who he is, or who he was, I should say, because it's important to remember what CNN destroyed. Zach loves his mom, supports her. He's been doing it forever. We learned that part of the panic and terror he endured over the past few years is because he doesn't know what's going to happen to her. Zach loves his wife, Irina. She couldn't be here today, even though she really wanted to, because, as Zach told you, her mother's really ill in Austria. But she's been watching and asked me to thank you all. And Zach loves Misha. Misha, who has been one of Zach's only comforts since CNN destroyed his life. But we learned more about Zach than just his family. We learned that he wanted to serve his country. We learned that he enlisted in the Navy. Trained to become a Navy SEAL, but got seriously injured before he completed that training. His dreams were derailed, but he was resilient. He returned to school, he completed his education, he worked at rehabilitation, he served his country in Pakistan and Afghanistan, protecting U.S. government officials in Blackwater. We learned that Zach got noticed by a U.S. government agency while he was there. And while Zach wouldn't tell you, I think it's pretty obvious now from all the testimony in the case that it was the CIA. He was recruited, trained, and served our country in the CIA for many years. And we learned that during that time, he developed a very deep network of skilled individuals. When he left government service, Zach was
a real-life former spy. He had been trained by 3 different outfits: Blackwater, the CIA, and the Navy SEALs, in some of the skills that we only see people have in movies. CNN's own expert took the stand and called him a SME, a subject matter expert, without hesitation. But after serving his country for so many years, Zach decided it was time to leverage those skills and his network to build a corporate business working with defense corporations. We call this sometimes going corporate. You heard how he traveled to the UAE and trained the SSD for defense contractor called Near East Consultants. How he expanded that into working with Frontier Services Group, and then further expanded that for working for Arrow, which soon became the largest defense contractor in the United Arab Emirates. We heard how his network and good work led him to be introduced to Matt Gunning and John Keeley, senior CIA officers with deep relationships in Saudi Arabia. We heard how Zach bet on himself and invested 1.5 years of his life working for free to design, create, and implement a revolutionary idea, a private corporation providing spycraft training to U.S. allies abroad. And we heard and saw the $400 million contract that resulted from those efforts. To service the Kingdom of Saudi Arabia, Zach and his team brought in a massive defense contractor called DynCorp. Now, by any definition, Zach was succeeding. He was not only making great money, he was working with what he called the dream team of former spies. No one had ever assembled a team like this, and Zach worked intimately with all of them as their director of training. Zach was at the peak of his professional career. He was rubbing elbows with Leon Panetta, former U.S. Security and Defense, and the CIA director, Michael Morrell, former acting and deputy director of the CIA, and some of the other incredible people you see on this list. And then the Kingdom of Saudi Arabia project suffered a setback. Happens. After working for years on that project, interviewing hundreds of people, drafting reports on the issues and the path forward, the United States denied the technical authorization needed to continue training Saudi Arabia. Zach is a patriot, not a mercenary like others have called him. The minute the United States said no, he returned home immediately, even though he knew that that vacuum would immediately be filled by China and Russia. Zach told you how China was willing to do it for free, and Saudi Arabia was paying them $400 million to do it instead. But that was okay. Zach had severance, he had a wife that had missed him terribly, a dog that needed some significant attention, and the knowledge that his network would soon be tapping him for more work. He had a tremendous reputation. He had the respect of his peers. And we heard from Mr. Humphreys, CNN's own expert. These jobs come with high salaries and massive kickers. The contract for the Kingdom of Saudi Arabia contract was a $400 million contract. The potential upside on getting these contracts signed is astronomical. And as expected, it happened quite soon. Amentum had acquired DynCorp and brought him back in to begin a non-specific contract-based relationship where they were paying him $200 an hour for work. And while he was working for Amentum, his network came through for him again, as it always had before CNN broadcast this defamatory video. He gets a call out of the blue. It's Audible, the multi-billion-dollar corporation owned by Amazon.com. They got his name from a contact at the FBI. Can Zach help evacuate 3 women in Afghanistan? They had people stuck there. Zach sprung into action. This was his opportunity to expand his network of corporate clients beyond Near East Consultants, beyond Frontier, beyond Arrow, beyond DynCorp and Amentum. This is exactly what he was specializing in: security and intelligence for corporations. And so he tapped his network, one of his biggest assets,
We saw documents where he was asking DynCorp and Amentum how they would compensate him for leveraging that network. He stopped his work for Amentum. He supervised the plans of evacuation, and he successfully extracted 3 women from Afghanistan for Audible. Now, after that extraction was successful, word travels fast in these small circles. Bloomberg called him up. They had 4 women and a baby stuck in Afghanistan, and Zach got him out. Then he got a call from Civil Fleet. A middleman had connected Zach with Civil Fleet. Zach got 3 of their women out of Afghanistan. Then a call from Hero. 3 separate evacuations, getting 12 women out of Afghanistan. All told, Zach saved 22 women and a baby from Afghanistan. Now, to be clear, this was a business. Zach was serving customers as he always has. He was serving his customers, corporations and NGOs. But you're allowed to be proud of the work you're paid to do. Many of us are. And we heard Zach. The requirement of a corporate or NGO sponsor wasn't only because that was his clientele. It was also because these refugees needed someone who could navigate the complex legal issues that arose when Afghans arrived in new countries. And with all this success, Zach decided to try and tap his network to see if he could find more corporate clients. Now, you heard General Young testify that these jobs aren't listed. There it is. These jobs aren't listed on monster.com or websites. A 2-star general came in here and testified. He said, you don't find these on websites. So, Zach, trying to be entrepreneurial, turned to LinkedIn, where he was connected to chief security officers, chief executive officers, chief operating officers, and other security and corporate-oriented folks. And he made posts trying to find other corporate clients. LinkedIn is a network of professionals. You heard CNN's own expert testify that he uses LinkedIn to fill jobs. Now, Zach hoped he was onto something. As it turns out, he wasn't. You don't get these sort of jobs from monster.com or from LinkedIn. But he tried. No money ever came in from his efforts on LinkedIn. But what happened when Zach began posting on LinkedIn is that many Afghans began reaching out to Zach too. And so Zach refined his messaging. He started posting, if you're a sponsor, with funding in all caps. If you are a sponsor, funding is required. He was reacting in real time. It was a business idea. That's what entrepreneurs do. They react in real time. Now, Zach doesn't deny that his public advertisements were seen by Afghans, and that he therefore, as a technical matter, advertised to Afghans. It's like if I have 20/20 vision and someone puts an advertisement on the television about LASIK surgery. Now, technically they're advertising to me, but I'm not their target audience. And the court has told you that Zach advertised to Afghans, and he's not denying that. But he was also clear that he reasonably expected and only wanted his post to be pushed to his network of security professionals. Now, I'm not a journalist, but to me, the real story has all the markings of a great feel-good story. A former CIA operative, small business owner, entrepreneur, evacuating women and a baby from a murderous failed state on behalf of Fortune 500 companies. What might that story look like? Maybe something like this. CNN investigation. Former CIA officer evacuates 22 women and a baby from Afghanistan for Bloomberg, Audible, and NGOs. This would have been a good story. More importantly, this would have been a true story. And CNN could have run this story. But it's not what CNN had in mind. It had all the information, or almost all the information it needed to run the story, but it didn't do it. And in a lot of ways, this case is about choices. CNN chose to not report that it confirmed Zach was former CIA. CNN chose not to report that Zach was conducting evacuations for Bloomberg and Audible. CNN chose to not report that Zach's evacuations were successful. And CNN chose to report on Zach alongside people he had nothing to do with, like Mr. California and Mr. Kabul. CNN chose to label his face and his name with a black market label. CNN chose to paint him as a predator that preyed on helpless human beings. In other words, again and again, CNN chose theater over truth. And now, you all get to choose what to do about it. Now, CNN knew the truth. They knew that Zach was only serving corporate clients. They saw all of Zach's communications where he was doing that. They saw, do you have a sponsor able to provide funding? Do you have a sponsor able to provide evacuation costs? Sounds like it ended pretty quickly after she said she didn't have a sponsor. They knew. And by the way, Zach told them in plain English to Katie Bolillis, the straight shooter, no, on November 3rd, over a week before they went to publication, no Afghan is expected to pay for evac costs. None would ever be able. If you recall moments ago, I asked Mr. Levine if they included this in their story. They didn't. Now, CNN admitted this expressly in its internal communications. Mr. Marquardt, Young's MO is asking Afghans if they have a sponsor, and when they say no, he drops them. Just talking to another woman in Kabul who was in touch with the young guy and who just stopped answering her once she said she didn't have a sponsor to pay the bills. I've seen him shut people down immediately if they don't have a sponsor for money. No, this is interesting. Katie Williams repeated Zach's message that we just looked at to Mr. Marquardt. He claims no Afghan is expected to pay for evac costs. None would ever be able. Mr. Marquardt admitted under oath that he knew Zach's MO was to require corporate sponsors. You saw in 7 instances that he shut people down when he didn't have a sponsor. Correct. Time and again, you saw his interactions where he dropped people if they didn't have a sponsor. Yes. I was just talking to a woman from Kabul. We looked at that message. Yes, that's more or less his pattern. You told her that you'd seen him shut people down. Correct. So you knew that. Yes. And Zach told them. He told them before they went to press. That's definitely not a realistic deadline. I can tell you for sure some of your facts and assertions are not accurate. And if they were published, I will seek legal damages. He told them they were wrong. They knew it, and they went to press anyway. He told them they would stand here to face you if they went forward, and they chose to do it. Because they wanted to hurt him. Because they wanted clicks, they wanted views, and they didn't care at all about the truth. Now, there's only one thing that explains these actions, and that's malice. Clear, actual, and express malice. Let's think about what CNN did for a minute here. They had no evidence that Zach had ever taken money from an Afghan, because he didn't. To be clear, there was no evidence that Mr. Young ever accepted money from an Afghan. Answer, that's correct. I have no evidence that he took money from an Afghan. I have no evidence that he took money from an Afghan. The court has told you that, Mr. Marquardt, right? That he didn't take any money? That he didn't take any money from an Afghan? Correct. You found no evidence of it? Correct. And the court has found it? Correct. They knew. Mr. Marquardt admitted on the stand. They also knew that they had no evidence Zach had ever taken advantage of an Afghan, because he didn't. Sir, that's not what I asked you today. Maybe you want to say it now, I'll ask you again. You have no evidence that Mr. Young took advantage of an Afghan. Answer, that's correct. And as we covered earlier, you do not have any evidence that Zach took advantage of an Afghan. Answer, that's correct. No evidence he took money from an Afghan. No evidence he took advantage of an Afghan. It doesn't stop there. They had no evidence that he ever exploited an Afghan, because he didn't. You also do not have any evidence that Mr. Young actually exploited an Afghan, correct? He was exploiting the situation, but I don't have evidence that he exploited an Afghan in particular. No evidence he took money from an Afghan. No evidence he took advantage of an Afghan. No evidence he ever exploited an Afghan. No evidence Zach committed a crime. Despite the investigation, you found no evidence that he committed a crime. That's correct. The next part of that sentence is a lie. We never ever reported him doing anything illegal. Do you contend that Mr. Young was doing anything illegal? Answer, absolutely not. They had no evidence he was doing anything illegal. They had no evidence he committed a crime. They had no evidence he exploited an Afghan. They had no evidence he took advantage of an Afghan. They had no evidence he took money from an Afghan. But they ran their story anyway. The story that they ran clearly said that Zach was a bad actor, preying on desperate Afghans and charging them money. They didn't care about the truth. Let's take a look at the digital article. The title, Afghans face exorbitant costs. Afghans didn't face exorbitant costs from Mr. Young. They didn't face any costs. Another part of the digital article. Afghans, desperate to flee, are increasingly have to negotiate with private operators, charging exorbitant funds. Afghans didn't have to negotiate with Mr. Young. They weren't being charged exorbitant funds by Mr. Young. He didn't deal with Afghans. Look at the digital article again. Thousands more Afghans want to leave, and many Afghans are turning to potentially unscrupulous operators. He didn't deal with Afghans. Now, all of these quotes show that CNN was crafting a narrative of Zach preying directly on Afghans by demanding money from them, something he never did. Now, their videos did the same thing, worse. Zach was a bad actor preying on desperate Afghans and taking money from them. And don't take my word for it. Take CNN's words for it before this lawsuit, where they said, when they were teasing the full segment that was about to come, look at those words and you will see the way CNN characterized its own upcoming video.
Desperate Afghans still trying to escape the country, being preyed on by folks demanding that they pay up big time to get out.
Desperate Afghans are being preyed on by folks demanding they pay up big time to get out. Is that the evidence you saw about Mr. Young? He didn't deal with desperate Afghans. He didn't pay with Afghans. He didn't prey on Afghans. He didn't demand they pay him big time to get out. This is how they characterize their story. But it's not the only one. There's another one. This one went international.
And as our Alex Marquardt discovered, there are plenty of unscrupulous people ready to take advantage.
He didn't take advantage of Afghans. But there's more. Another teaser by Mr. Tapper, describing what was coming in a minute, the segment you've all seen 100 times.
They say they will help Afghans escape the country, but only for a price, a steep price. How desperate Afghans are being preyed upon. That's next.
Afghans escape, but only for a price. How desperate Afghans are being preyed upon. That's next. It's not Mr. Young. Now, the gist of the segment could not be clearer. There are bad people preying on desperate Afghans and taking money directly from them. Look at what CNN said in this segment. Look at what CNN said this segment was about when they were peddling scandal for views and clicks. Don't listen to what they are saying now after they are facing you. They literally put this man's face over a banner and said,
so he went online, where he found a man named Zachary Young.
Afghans and activists, Afghans, report demands of $10,000 to $14,000. Mr. Young never demanded any money from an Afghan. He worked for corporations. This is a clear accusation that Zach was demanding money from Afghans, something they knew was false. We looked at their testimony. And then look at what they did next. After telling you in the teasers that this video was going to be about a bad actor preying on desperate Afghans and taking money from them, they played heartbreaking stories about two Afghans trying to get their families out, even though they knew that there was no connection between Mr. California and Mr. Kabul and Mr. Young. Look at Mr. Marquardt's own pre-litigation admissions. The Kabul interview I just did was heartbreaking. Nothing to do with this guy, though. Either of your two interviewers talked to Zachary Young? No, there's no connection there. They put a message on the screen in their segment and blurred his name. They blurred this name, but it's David Lerner. It made it seem like he was interacting with Afghans. Afghans trying to flee face a black market, exorbitant fees. And they put this American activist on the screen and blurred his name. We know that David Lerner is an American from the Midwest that didn't really have any Afghans to evacuate, who lied to Zach about having a sponsor. Sponsor, yes, I'm not corporate. And Zach believed was just wasting his time. That's who they put up there above a banner about Afghans. CNN, in this way, and other ways that we've talked about and will, editorialize their segment in ways the news never should. This isn't a short film. This isn't supposed to be theater. This is supposed to be news. This is supposed to be the most trusted name in news. They leverage their influence and their massive resources to paint a very clear picture of a bad actor preying on desperate Afghans by taking money from them. And it was clearly about Zach. He was the only operator mentioned in the story. And importantly, for the defamation by implication claim, the one where you have to decide the gist or the implication of it as opposed to the definition of black market, the court has already told you it was about Zach. Zach, an American veteran who was serving corporations and NGOs, something CNN knew and didn't care about because they hated Zach as much as they love ratings. Now we watched as they imposed their own hypocritical moral values on Zach. God forbid he should make money providing a needed service to corporations in a war zone. Only CNN is allowed to make money off war zones. Only CNN is allowed to sell ads while reporting on wars. When Zach got paid by corporations to provide a needed service in a war zone, he was a mother effer that needed to be nailed. He was a shitbag. He was an a-hole. He was a shit. He had a punchable face. All by Alex Marquardt, CNN's cowboy. Zach's desire to make a living by providing services to corporations and saving the lives of 22 women and a baby meant it was his funeral bucko, according to CNN. They were right. When they went to publication, we lost part of Zach. CNN cries foul on a small business owner's 65% profit margins for very risky work when you heard its own CFO testify that they predict a massive corporation 42.5% profit margins for themselves. 42.8%, excuse me. CNN has the gall to get up here and say that clear, obvious, and common sense interpretation of the gist isn't right. CNN is so arrogant, they are so used to getting whatever they want without being holding to account, that they stand up here and they talk down to us with bold-faced lies about what the segment's gist really is. And they expect you to believe it. I mean, do they think we're all stupid? Do you remember The Wizard of Oz? I grew up on that. My mom loved it. Pay no attention to the man behind the curtain. CNN has a man behind the curtain too. CNN's own reporter, Nicole Gaet,
She saw the reporting at issue here. And what did she say to CNN before it was facing this historic lawsuit? She said it plainly. She said, so the inference running through Alex's story that these people, Zach was the only people, that these people are just bilking desperate Afghans for their money might not be fair at all. They get up here and swear to you that that's not what they meant, even though their teasers say it, their banners say it, everything they say says it. Their own internal people said it. And they expect us now to believe what they say on the stand? CNN's own reporter knew that gist. The inference is that Zach was bilking Afghans for their money. CNN's own reporter knew that the story was not fair. She knew the story was not true. And CNN published it anyways in reckless disregard of the truth. Do not let CNN rewrite history. Do not let CNN tell more lies. Do not let CNN destroy someone else's life for views and clicks and their own self-righteousness. This isn't just about a defamation by implication case. There are two claims in this case. The defamation by implication, that Zach was preying on desperate Afghans, taking their money. There's more than just the defamatory gist of bad actors. Because Zach is also suing for defamation per se. Because CNN called him a black market criminal and ended the career he spent so many years training for. We saw Zach's corporate contracts with clauses in the section entitled Compliance with the Law. The employee must comply with all laws, including black market. And if you engage with the black market, you would be terminated for cause, and you would lose your severance. These contracts expressly required you stay away from a black market. We looked at 3 different dictionaries. Google, an illegal traffic or trade, about what black market means. Not that we should have to. It's obvious, but we're in a court of law. Let's get formal. We pull out the dictionaries, the authoritative source of what words mean. If you're in an argument with somebody about what a word means, how do you end it? You pull out the dictionary. Well, look at the dictionary. Google, an illegal traffic or trade in officially controlled or scarce commodities. The American heritage, the illegal business of buying or selling currency or goods banned by a government. A place where such illegal business is carried on. The illicit trade in goods or commodities in violation of official regulations. I'm going to touch on this later, but 7 CNN employees came in here and gave you a definition of black market that can't be sourced to any source at all. Ask yourself how that happens absent a conspiracy that Mr. Levine denied was happening. It's not just a made-up definition. It actually is refuted by the dictionary. Webster says that a black market is an illicit trade in violation of official regulations. That means in order to have a black market, you have to have regulations to violate. An unregulated market can't be a black market. You know what's an unregulated market? It's a free market. So CNN was telling you that instead of saying black market, they could have said free market, same word. Don't check your common sense at the door. Do not let CNN rewrite the English language to avoid liability in this case. And then, CNN ran a story that in no uncertain terms called Zach a black market criminal. The first segment opens like this.
Still, many Afghans who desperately want to flee Taliban rule, and Afghans who say their lives are at stake, they remain behind. As CNN's Alex Marquardt has discovered, Afghans trying to get out of the country face a black market full of promises, demands of exorbitant fees, and no guarantee of safety or success.
So Afghans face a black market. He says it, it's on the banner. And as the video continues, Zach's name gets put on the screen above The black market label. Now, CNN likes to call it a chyron or a banner. Zach called it a label for a reason, because it labeled him in a way he can never get away from. It labeled him as the black market operator the Afghans were facing. But the image changes as the video goes on. Now it's not just Zachary Y, it's Zachary Young. And it has his face on it too. And there's that label in that indelible ink, black market. That man is the black market operator. The image changes again. They blow up his face real big in case you had any doubts about who is the person operating on the black market. Who is the criminal? Telling the world and CNN's millions of eventual viewers that Zach is a black market operator. The CNN investigation on the bottom, it's more like persecution. CNN says that the video isn't about Zach, that the black market isn't about him, but they're just lying. Listen to what they showed in the video. Look at what they said before they were called to this court to be judged by you. CNN couldn't have been clearer. After running a piece about black market evacuations and talking about Mr. Young as the provider of that operations, Mr. Marquardt, when commenting on the black market of evacuations, says this.
That person offering those evacuations, Zachary Young.
I mean, come on. Does it get clearer than that? That person offering those evacuations. There's only one evacuation talked about in the entire video. The black market evacuations. In openings, CNN's lawyers told you that neither story accused Zach of doing anything illegal. Opposing counsel said, never implies Mr. Young is doing anything criminal. That's just untrue. And that's a favorable way to say it. Now, Fuzz Hogan, one of the members of CNN's triad, testified that the story was reporting that Zachary Young was operating in a black market and that he intended to suggest that Zach was operating in a black market. Mr. Hogan, you agree the story was reporting that Zachary Young was operating in a black market, correct? Yes. Now, this is a symptom of trying to put on 7 people on the stand and get them all to engage in a conspiracy. They can't keep it straight. Liars eventually crack. And so I'm sure some of them will hold the line. And it's easy to hold the line on words like, oh, black market means unregulated. Yeah, that's easy to hold the line on. But under questioning, documents, prior depositions, cracks start to form. Hogan admitted it. You agree the story was reporting that Zachary Young was operating in a black market? Answer, yes. Is that because you intended to suggest that Mr. Young was operating on a black market? Answer, yes. Alexander Marquardt testified. In this example, CNN uses Mr. Young as an example of someone who operated in a black market. Is that correct? Answer, yes. Cracks. The truth eventually comes to light. Now, the use of the words extortion and fraud alongside black market in the communications of the story from pitch to publication prove that everyone inside CNN knew that this story was about criminality and illegality the entire time. And we saw those. I brought Mr. Marquardt through those communications. Remember, I kept repeating them. Deception, scams, black market, extortion. I said, I don't know what you're doing with that. Well, now you know what I was doing with that. It shows their intent. Now, when you go back to deliberate and you look through the emails and Slack messages, you'll see it for yourself. CNN not only knew it was reporting that Zach was operating on a black market, it was gleefully reporting that he was engaging in illegal activity. It knew it the whole time. Moments ago, Mr. Levine was on the stand, and I asked him, I said, you testified yesterday that sometimes a story starts here and ends up here. But this story started here and ended here, right? And he said, yeah, pretty much. Started with illegality, started with scams, deception, extortion, fraud, price gouging. That's where it ended. CNN's own corporate representative said it, admitted it on the stand. This story is about illegality. It knew it in October, it knew it in November, when it was still referring to it as an Afghanistan extortion story. Now, CNN republished its hit piece 11 more times. And in many of them, they stress the black market nature of Zach's activities, adding intros and outros that double down on this defamatory accusation of criminality. With 434,000 more people watching, CNN said this.
As CNN's Alex Marquardt discovered, many are turning to the black market for a way out.
And then they played the segment. It was Zach they were turning to, CNN said, on the black market. On November 13th, with 503,000 more people watching, CNN said this.
A CNN investigation into the black market business of fleeing Afghanistan. CNN's Alex Marquardt found a black market ready to take advantage.
You know who they found? Zachary Young. Now, the damage of these videos was immediate and overwhelming. And I want to get to that in a minute. I want to talk about malice. Because accidents happen. But this was no accident. In opening, my partner, Mr. Roche, told you we have the burden of proving our case to you. For negligence, by the greater weight of the evidence. For punitive damages, by clear and convincing evidence. And he told you that we welcome that burden. I want to double down on that. Hold me to our burden. I am confident we have satisfied this burden and more. CNN's malice and willful desire to harm Zach is documented by their reporters. Think about that for a second. This organization is so arrogant, they respect the American people so little, that they don't even hesitate documenting their malicious intent. Hold me to my burden because we have the receipts. Hold me to my burden because the world is watching what you all are going to do today. Hold me to my burden because your verdict will stand in history as the moment everyday Americans from the great state of Florida, from Bay County, stood up to fake news, stood up to lies, and stood up to corporate greed, and shifted American media back toward normalcy. I'm not scared of that burden. I welcome it. If after reviewing the evidence you've seen, after watching CNN's pretentious and self-righteous reporters deny their own words over and over, change their stories over and over, express discomfort at owning their own words, twisting themselves into pretzels to explain them away, you still don't agree with me? I don't want a dime. Don't give me a dime. Don't give Mr. Young a dime. He feels the same way. We wouldn't have came all the way here. We wouldn't have brought this case to you if we didn't think we were going to prove it. Now, Mr. Young was offering evacuation services to corporations. I want to review what we learned in the last week and a half. Mr. Young was offering evacuations to corporations and NGOs. Everyone was happy. Zach was happy. He was making a living and building his business and reputation. His clients, corporations like Bloomberg, Audible, and the DynCorp Amentums of the world were happy too. They got exactly what they wanted. The people they wanted were extracted from Afghanistan at a price they were more than happy to pay. And the Afghans were happy because they were now out of a place where their lives were in danger. But that's not a story CNN can sell. A corporate transaction isn't newsworthy. If a corporation paid for evacuations and a corporation got evacuations, there's no story there. And CNN agreed. And Alex Marquardt agreed. He said he wasn't doing a story about corporate evacuation. So it wasn't about companies hiring private contractors like Mr. Young to get their employees out of Afghanistan, right? That's not what the story is about, no. Tell me something. If that's not what the story is about, why was he in it? If not malice. Mr. Marquardt said, I didn't want to know what Audible and Bloomberg were doing to get their corporate employees out. Then why was Mr. Young in it? You know what? Alex Marquardt explained his motivations. Clicks, views, and fame. He wanted a story that would be broadcast as widely as possible. Yes, you wanted to disseminate it as widely as possible. Yes, broadcast as widely as possible. Yes, you hoped the story would have gone on as many programs as possible. Absolutely. If you had your choice, would it have run every single hour? Yes, it would. You wanted the story to be seen by as many viewers and readers as possible, didn't you? As we do with all our stories. And Mr. Marquardt, besides admitting that he wanted the clicks and views and the fame, he also admitted that people love hearing about a good scandal in the news. People love hearing about a good scandal in the news, don't they? Sure, some do, he said. I mean, he didn't have to admit it. We know that. While he denied chasing scandal under oath, he admitted to looking for scandalous actions. You took just a moment ago, agreed you were looking at scams and deceptions, and now you're looking at exploitations. Yes, absolutely. Scams, deception, black market exploitation, all things I was looking into. Exploitation, scams, deception, black market, price gouging. These were things I was looking into. You're looking at exploitation, scams, deception, black market, price gouging, extortion, and fraud. You know what another word for these are? Scandal. And you know, despite Alex Marquardt refusing to admit it, we know that every good scandal needs a bad guy. So CNN set its sights on Zach, and it hunted him down regardless of the facts. We saw the document trail of Alexander Marquardt chasing 7 people about Zach and coming up empty-handed. He hated that I kept calling it strike 1, strike 2, strike 3. And I admit it wasn't a perfect metaphor, but I did it because it made a point. You remember now that we went through 7 people with a single-minded focus of hunting that man down. Under oath, Mr. Marquardt denied watching Zach. You kept watching him, isn't that true? I kept doing my research. In his emails, before he was facing you guys, this is the same guy I've been watching. Under oath, he denied looking at Zach's LinkedIn profile. But his messages before he came before you guys, I've looked 1,000,000 times. Under oath, he denied zeroing in on Mr. Young. You zeroed in on Mr. Young. He wouldn't admit it. He wouldn't own it. We certainly thought about it was going to be part of the story. Before he had to face you guys, we zeroed in on an American offering outrageous prices. We watched Katie Bolillis help CNN's manhunt for Zach. She lied to him. She told him she was a straight shooter. She was anything but. As one of you all said best, she pursued a path of guilty until proven innocent. She felt entitled to answers. She felt just as entitled to bury him when he didn't feel like talking. And as we discussed before, CNN found nothing about Zach, but it moved forward anyway. Alexander Marquardt was pitched a story by people who hated Zach. Jill Kornetsky, parasites can be hard to exterminate. James Daniels, there's a special ring of hell for people like Zach. When Alex Marquardt pitched the story internally, he only named Zachary Young as the person they were focusing their hunt on. CNN's top brass, Mr. Levine and Mr. Callahan. It's a good story if you have these examples of Young. Mr. Callahan, can we find out more information on Young? The whole organization was targeting this man for a scandalous story. CNN hated him. They felt that he was evil for making money while providing services to corporations involved in war. We've addressed their hypocrisy. They can be paid for this, but not Zach. CNN can exploit the desperation of Afghans to run a story about them. They can exploit the desperation of Afghans to sell ads on their stories about Afghans. Zach can't, God forbid, make money by saving people's lives. CNN made Zach the bad guy. But did they tell you about anyone they evacuated? This man evacuated 22 women and a baby. About any evacuations they funded? About any lives they saved? Of course not. If anything, they made sure there was one less person offering evacuation services. If anything, CNN caused fewer people to be evacuated. Regardless of why. Go back and read the stories CNN published. The United States government was evacuating like 200, 300 people. This man himself evacuated 22 and a baby. That's a significant percentage of what the United States government was doing. They took him off the table. Now, regardless of why they hated him, their hate is apparent. We saw it on their faces when they testified. We saw it in their internal documents. And I got to apologize for all the profanity that's been going on in this case, but we felt it was important to maintain accuracy to the records. It's court. We don't usually use profanity, but we thought it merited it. You needed to understand the true feelings of what was going on here. But I think we've done it enough, so I'm going to try to lay off a bit. Alex Marquardt, we're going to nail this Zachary Young mother effer. Matthew Phillips, I'm going to hold you to that one, cowboy. Cowboy! And then under questioning, when asked at deposition, what did you mean by you're going to hold him to that one, cowboy? He said, I'm going to hold him to the highest standards, journalistic ethics, to fulfill his reporting. I mean, come on! Cowboys are lawless, the wild, wild west. Now, CNN got up here and argued, no. So we're going to nail the Zachary Young mother effer, but just a couple messages down. I say, or maybe not. Maybe he slips away. When someone slips away, it's not that you stopped trying to nail them. It's that despite your best efforts to nail them, they got away anyway. So Mr. Marquardt's pointing out that he said, I'm going to nail him unless he slips away. That's not exonerating. That's damning. It's just a further doubling down of intent. I'm going to nail him unless he can escape. It's pretty hard to escape an organization like CNN. They broadcast into 70 million households. Mr. Conte, the producer, what a punchable face. He hated him too. Marquardt agreed, right? On the stand, when I said right, I didn't mean right. I was being agreeable, not agreeing. I mean, I don't even know where you split that hair. That's insanity. Katie Bolillis, she seemed real nice, but she called him a S-bag, an a-hole, shady as hell. She hated him too. Alexander Marquardt says, it's his funeral, bucko. And Katie Bolillis laughed. As I said before, it was. Part of Zach died that day. And Fuzz Hogan, one of the members of CNN's triad, called him a shit. They hated him. And then we watched Alexander Marquardt ignore lead after lead after lead and pursue this man until the end. He never tried to find the person that offered Mr. Kabul an evacuation for $50,000. He never even tried to contact Audible because he decided in his omnipotence that it made no sense that Audible would be in Afghanistan. First of all, it's absurd. You think People in Afghanistan don't want to listen to audiobooks. In fact, probably they have literacy issues, and audiobooks are probably popular there. But who cares? Maybe Audible had extended family that was out there. Maybe Audible just wanted to sponsor some people out. How do you sit there and just say, I'm not going to chase this lead? He knew he had evacuated people from Audible. And he's like, nah, this guy's a liar. He's a mother effer. He's a shit. I'm not going to listen to what I'm not going to chase him down. Or probably, and what the evidence shows, he didn't want to chase it down because he wanted to run his story. We hear how he reached out to Bloomberg, but Bloomberg didn't respond to him. Don't let CNN trick you. Marquardt didn't reach out to Bloomberg News. Mayor Michael Bloomberg is a billionaire. He was a mayor of New York City, and he also runs a multi-billion-dollar news organization. Bloomberg News hired Zach to extract someone from Afghanistan. It'd be like texting Jeff Bezos, the owner of Amazon, to try to find out about information about Audible. He was purposely going after people who had no information. He ignored Audible. He ignored Mr. Kabul. He ignored Bloomberg. He ignored Hazami Barmada, the activist who said to him, "You're trying to get me in trouble, Alex?" We heard it over the speakers. He said, "Have you heard of this guy, Zachary Young?" And she's like, I've heard of this company, Raven. They're charging $20,000. Have you heard of this guy, Zachary Young, Hazami? I've heard of this company, Dunkirk. I haven't heard of Zachary Young. Hazami told Alex Marquardt that that Raven was charging $20,000. If you're outraged in the prices, Mr. Young's prices were way less, $14,500. He ignored them. He ignored leads on purpose because he set his sights on this man. CNN set their sights on this man. He was ordered by his superiors to go after this man, and he went after this man. They ignored the texts that Zach sent, proving that while he really couldn't help Afghans, he wasn't heartless. He's a little rough around the edges. He's a Navy SEAL. He's a CIA officer. Spent time in Blackwater. I think Mr. Rose touched on this in opening. When your daughter is stuck in a foreign country with hostile people, you don't want a silver-tongued Mr. Marquardt showing up trying to get him out. You want Liam Neeson from Taken with a special set of skills that's going to come in, do what's necessary to take him out. This man is a little rough around the edges. Yeah, it's true. But he's not heartless. And he showed CNN he wasn't heartless. I tried to get this man, Ahmed Zuber Nouri, in touch with people. He was trying to help an Afghan called Ahmed Zuber Nouri. Do you recall that? I remember him sending screen grabs to her. Did you mention Nouri in your final report? No, of course not. That would have run counter to their goals. This one's mind-boggling. Marquardt declared that the story of an Afghan whose evacuation was paid for by an NGO. He said, I'm not going to continue talking to that man because his story right now doesn't align with mine, unfortunately. Again, look at the documents in this case. This man is no different than anyone Zachary Young evacuated. An NGO or a corporation paid for it. When it happened here, his story didn't align with mine, unfortunately. If it was because of an NGO payment, Mr. Young wouldn't be in that story. You know why this man's story didn't align with Alexander Marquardt's? Because it didn't reflect poorly on Zachary Young. It wasn't a lie about Zachary Young. That's why his story didn't align with mine. So when you look for malice, when you look for intent to harm, when you look for knowledge of falsity, look at these internal communications. Don't listen to what they lied to you on the stand. Look at the documents, the receipts. And you know what's insane is we literally have multiple admissions from Marquardt before the litigation started, before he knew that we would use the court's compulsory power to have CNN turn all their documents over to us, before he knew that was coming, and we'd be able to put them on a TV screen for you all. He literally admitted it. Do I believe charging people $15,000 a head to get out is a scam? 100%. It's not a scam to engage in a transaction with a corporation. And then he said the quiet part out loud. I believe it's a scam 100%, but I can't say that per se. It's got to hold up the veil, right? If they just go out there and become the National Enquirer, CNN will lose everything. They've got to hold up the veil. I believe it's a scam. Can't say it per se. Defamation by implication. Now on the stand, Marquardt was so desperate to get out of this document, he said, I allowed for the possibility or something like that of it developing. And I don't know if you remember, but I was like, you allowed for the possibility? It says 100%. It's not allowing for the possibility. So he orchestrated theater. And let's look at how the theater starts. He says, such a nice guy, so desperate, good English, ready to do an interview in some fashion. Good elements are lining up. Would love to get a producer assigned, and some of it on tape. He films that interview. He does some more of the shots that we saw CNN's own internal guidelines don't allow you to do. We make the news. We don't create it. He filmed the guy's hands. He filmed the guy's feet. He filmed from behind the guy's feet. He adjusted the camera down. You've seen the infamous theater video now like 8 times. But I have to break it down for you one more time. Marquardt places a call to someone he saved in his phone as Zachary Young. He makes sure the cameraman catches the contact name. We really don't know who he's calling. But we know that there's no outgoing call to Zach on Alexander Marquardt's phone, and we know there's no missed call on Zach's phone. CNN's explanation is, oh, between November 3rd and November 10th, Marquardt switched phones. Okay, where's the missed call? It's a lie. There was no call. He called one of his buddies under Zachary Young's name because he didn't want him to pick up because he wanted to set up a shot with Zach not picking up so it looked shady. Mr. Levine yesterday was so desperate for this lie to be true, he said he definitely called him. But today, under vigorous cross-examination, he agreed, I actually don't know. Let's pretend for argument's sake that some weird glitch happened that no one can explain. And he did really call. So what? One of you asked him yourselves, how many times did you try to call? 1 time. He says, but I really wanted him to get on the phone. Yeah, right. If you really want somebody on the phone, you call more than once. He told Kitty Bo Lillis not to make an introduction. So even if he did purposely dial Mr. Young's number, he set it up so he wouldn't get a response. He stopped an introduction. And then, when Alexander Marquardt was facing the camera, he picked up the phone and he pretended to be on the phone for 30 seconds. And Malaysia Bordeaux said, oh, that's a recreation. It's allowed, but it's not what their standards and policies say. And then the worst. We report the news. We don't create it.
Theater.
Yeah. He admitted it. I mean, you rarely get smoking gun documents like this in a legal case. You just rarely do.
Theater.
Yeah. And then on the stand, he tried making up a lie. He was so embarrassed. He wouldn't admit to the words theater. I kept saying, you can't own your own words. It's theater. He couldn't even. He was sick to his stomach that he was outed in front of all of you. And he made up another lie. He goes, oh, I just love SNL. I love John Lovitz. He does theater all the time. And you recall, that was on direct, or cross. And when I got him back, I said to him, no, John Lovitz doesn't say theater. He says acting. Did you see his face when that happened? The veneer shattered. He was a liar. He was engaging in theater. He was cognate. He lied about it. He was cognate again. CNN knew the story wasn't true. They knew they had no facts to support it, but they hated Zach. So they orchestrated theater. They set him up, and they took him down. And other internal documents from CNN, they admit that they knew the story was fake. 80% emotion, 20% obscured fact. Did you hear me ask Mr. Lumley, what's an obscured fact? His answer was, an obscured fact is nothing but a lie. Because when you obscure the truth, you're a liar. Other internal documents say the same thing. We don't know if they're con artists. I kind of want to say, what the F? It's an incomplete story. We really don't know what's going on. It needs more reporting. The story is full of holes like Swiss cheese. I think it's a half story. At least Fuzz Hogan. Make a quick hit video. It's an infernal story. It's not ready for prime time. I'm not sure it's salvageable. We really need to pause it. It has fundamental questions. At least Fuzz Hogan cracked again under rigorous questioning.
And you responded, yeah, he's a shit.
I did.
And then you went on to approve a three-quarter true story, didn't you?
Yes.
He approved a 3/4 true story. When you go back there and look at malice, they knew it wasn't true. They knew it was 3/4 true, and Triad approved it. That is your malice. You don't need to look at anything else. There's tons of it. But that right there is your malice. They knew it wasn't true. They knowingly published falsehoods. Malice. Yesterday, Mr. Levine got up here to testify that the idea that so many people conspired to make Mr. Young take down Mr. Young was absurd. Well, let me tell you what's absurd. And I told you I'd touch on this earlier. CNN has 7 highly educated employees come up here. When asked for the meaning of black market, every single employee has provided the same definition, but that definition appears in no dictionary or any source whatsoever. What are the odds that 7 highly educated employees, all non-nefariously, land on the same definition of a word, but none can tell you where it's from? You know what that is? That is a conspiracy. Let me tell you what else is absurd. You asked Emma Lacey Bruneau a straightforward question. What things are considered when evaluating fairness toward the subject of a story? And she couldn't answer you. She said, fairness is a tricky concept. It's a tricky, tricky question. No, it's not. Fairness is an easy concept, unless you're CNN. Fairness is honesty. Fairness is straightforwardness. Fairness is simple. What's tricky is unfairness. Trick questions are unfair. Tricks are what you use when you're not being fair. Fairness means presenting the truth, the whole truth. CNN didn't treat Zach fairly. They didn't give him the benefit of the doubt. They didn't check their facts. They didn't care about the damage they were doing. And now they want to call fairness tricky. Excuse their behavior. You need to stop them. Remember that as part of this case is something called punitive damages. You need to determine not only if what they did deserves punishment, but if a deterrent effect is needed. We asked every single CNN witness on the stand, would you do it again? Are you sorry? And down to a man and woman, every single one of them said they would do it again. Every single one of them said they are not sorry. They disavowed their own correction and apology. They admitted on the stand that they only issued it to avoid a lawsuit. CNN's not sorry. Marquardt is not sorry. You asked Marquardt directly how he felt knowing that Mr. Young can no longer work in the space he's trained in as a result of his hit piece. And what did he say? He says he does not feel bad. He said the impact on Young is not his priority. In other words, Marquardt said, look, maybe I ruined his career. It's not my problem. You need to make it Marquardt's problem. You need to make it CNN's problem. You need to make it the media's problem. You have a tool to save American media. It's called punitive damages. You need to use it. Now, the story ended Zach's career. It ended his business. Full stop. Amentum, who just a month earlier was discussing the terms of Zach's renewal contract, allowed the contract to lapse.
And you...
Zach's business, which was making him $360,000 a year, went to zero overnight. His network of quiet professionals in the security and intelligence space dropped him like a hot potato. Historically, they would call him for help, but now they won't even return his calls. He told you, I never had to call anybody. They called me. Now they won't even call him back, he said. General Young, a 2-star general, came in here, and he testified before the segment aired he would have hired Zach to help extract people from Afghanistan, but that he cannot hire him now. If you had any doubt that Zach's reputation and career has been ruined, you need no further than General Young's testimony, because under heavy questioning from CNN, we weren't able to get everybody we wanted out of Afghanistan. He is a pariah. He cannot be touched. Their whole thing about mitigation, he didn't look for jobs. They put an expert on the stand who said he didn't go to monster.com. The two-star general told you that's not where you find these jobs. And the two-star general told you it don't matter, he's unhireable. This guy was asked specifically, CNN's guy, are you offering opinion that all these steps of LinkedIn and applications, are you offering an opinion that would work? No. You know who offered an opinion that that would not work? General Young. It would not work. He'd have to let the 16-year-old go. Don't let them confuse you with mitigation. He's unemployable. What did their experts say? Without a security clearance, he's dead in the water. Well, you know what we found out 2 days ago? He doesn't have a security clearance. He's dead in the water. Now, a lawyer. I became a lawyer because I don't do math. So we hired an expert, a CPA. He engaged in a very simple analysis. We call it a before and after methodology. Now, there were two experts that talked to you about finances, Richard Balco for Mr. Young, and Brian Buss for CNN. Only one of them provided you an opinion of an actual dollar amount. I think at one point Mr. Buss said, the damages are zero. Really? Zero? Zero? Now, Mr. Balco walked you through it. He said I took his income from before, I averaged it out, I excluded the ramp-up period because you don't ramp up multiple times in a new business, you ramp up once. It's a one-time thing. I didn't include the last part of it because the last part of it was the income through not through the entire year. And if I included that, it'd have to be $500,000 over a very short period of time, which would make the model much more complicated. And in fact, that number would have gone way up. It would have gone way up. But he said, I opted for conservatism. I took the lower number. Could have gone way higher, but then I wouldn't have been as short. Now, is he positive of that number? Who can read the future? No one can read the future. The law doesn't require you to read the future. The law requires you to apply methods. And we did. Before and after, CPA came in, very simple math, projected it out. And Mr. Buss, CNN's own expert, conceded on the stand that the before and after method that was used was appropriate. And he conceded that it can be appropriate to leave off a ramp-up period. And then he offered no opinion on what damages really should be except zero, which is in itself an insult. We ask that you provide Zach with the full economic damages that CNN caused. Now, you can't take this slide back with you. So if you want to know the number of the full economic damages, you'll have to write it down on your notes. It's $21,319,456. There's also emotional fallout. The story didn't just cause Zach financial woes. It shook him to its core, changed him fundamentally. He knows it, he hates it, but he knows it. It's a man that fought in Afghanistan, trained as a SEAL, worked for the CIA, risked his life for this country, now has panic attacks and has to take medication to keep him calm. This man who trained spies to survive in warfare and evade capture now takes pills to avoid the consequences of a major depressive disorder, the most severe form of depression, according to Dr. Vincent, when asked by one of you. He questions his worth as a husband, as a son, as a provider for his mother. He was the emotional and financial rock for his family, and he no longer is. The man he was is gone. The man his wife married is no longer. That's something he needs to live with for the rest of his life. Dr. Vincent put clinical names to these things. He called them major depressive disorder, persistent depressive disorder, other specified trauma and stressor-related disorder. Zach has to take medications, something he's never had to do. Antidepressants, panic attacks, insomnia. Dr. Vincent told you how all of his specialized training didn't prepare him for this. Never prepared him for the way CNN's story destroyed his self, his identity, his ability to support his family. Zach told you the same. He told you how he tried to use his training to persevere, like he had always done in the past. But how this one time he couldn't get back up. For the first time ever, couldn't put food on the table for his family. He'd never been here before. And this is important, because all throughout this trial you heard he deleted documents. He deleted documents. Now the courts told you you have to look at the circumstances and decide whether he was trying to keep documents away from CNN or he was just in a full-on panic. And I submit to you that there would be no benefit to deleting documents. The court has found he did nothing illegal. The court has found he took no money from an Afghan. What was he hiding? There's nothing to hide. This is misdirection and red flags. This is lawyer tricks. Use your common sense. What was he hiding? CNN had the truth. What was he hiding? So, okay, maybe there's some exchange where he was rough or gruff with another Afghan and they want to put it up there or something. I mean, I don't know. But, like, what is going to be there? There's nothing there. And the security operations. You heard from General Young. That's standard operating procedure. You have to delete those. You heard from Katie Bull-Lillis. You've got to delete those. This wasn't a man trying to deprive CNN of anything. This is desperation. This is grasping at straws. So you're allowed to do it. But please look at the circumstances. Look at what was happening. Make a decision then. Not based on accusations of counsel. Zach's mental disabilities so significant, CNN couldn't even find an expert to say that he wasn't disabled mentally and emotionally. Think about that. This is one of the largest media companies in the world, and they couldn't find a single expert.
I'll sustain the objection. I think you rephrased your argument.
They couldn't put up a single expert on the stand for you. Did you see somebody come in? That means they couldn't find a single person who would take that stand. But then they imply he's malingering. He's lying about it. Really? Where's your doctor saying that? You can have lawyers accuse people who are suffering from mental disability? That's your proof? Mark Twain said that a lie can travel around the world while the truth is still putting on its shoes. What about CNN's lies? How far did they travel? Let's take a look at the evidence. The initial broadcast was seen by 669,000 people. Facebook post by 21,000 people. CNN.com by 19,000. I'm going to skip the one that says estimated for a minute. Newsroom by 434,000. Newsroom 503,000. Now the two international shows, we have no idea how many people saw them. You heard Mr. Lee on the stand. It could have been 10 million. It could have been 20 million. It could have been 4. Really? We did the best we could. We took the confirmed views, 669, 434, and 503, and we averaged them. I have no idea if that's right. It could be way more. It could be way, way more. It could be less. But we thought that was fair. We've got confirmed views of 1.6 million people that saw this. We've got estimated views of 2.7 million that have seen this. And it could be far, far, far more. You heard Mr. Levine. Everyone that Mr. Young walks on the street of in Vienna, 40% of them could think he's a black market criminal as they watch CNN's broadcast. The correction was seen by 942,000 people. But let's be honest. The correction didn't do anything. It doesn't matter. Man can't get hired. It doesn't matter how many people saw it. They issued a correction because they were trying to get out of a lawsuit. It didn't work. And no one saw the correction. It was up, it was off, and that was it. The segment aired multiple times, over and over. The segment was posted to their website to be seen over and over. The correction? Can't find it. And who cares? It did nothing. Which brings me to the conclusion. Corey, can you put up the verdict sheet? I want to thank you very much for your time for these past 2 weeks. I know it's been long. I know you've sacrificed your time to be a jurors on this case. As I hope you've seen, we've tried our best to present the evidence in an efficient way as possible. We even stopped the sidebars. Zach and all the attorneys on our team are deeply grateful for the time you've taken here today and these past few weeks. The deliberation that each of you are about to engage in is a rare moment and opportunity. It is rare that a media defendant goes to verdict in a defamation case. Objection.
Just say it.
As you've seen and heard through Zach's testimony, being a plaintiff in a defamation case isn't easy or fun. Your whole life is laid bare because defamation, unlike the kinds of cases, literally puts your entire reputation at issue. The verdict form that you're about to fill out is just over a page, but it has 5 very important questions that you have to answer. You must decide by the greater weight of the evidence that CNN committed defamation per se against plaintiff Zachary Young. If you think black market means criminal, if you agree with the dictionary, if you don't agree with the conspiracy of 7 people giving you a definition that makes no sense and is unsourced, and Judge Henry has told you the rest. Mr. Young did nothing illegal. He did nothing criminal. It's defamation per se. You should check yes. If you find by the greater weight of the evidence that defendant CNN committed defamation by implication against plaintiff Zachary Young, if you take CNN at their own words, what they said that the teasers meant, what their language said, that he was preying on desperate Afghans by taking money, a bad actor preying on them by taking money from them, you check yes. It's not a close call. Neither of these are a close call. Then you get told if your answers to 1 and 2 are no, if you find against us, if I haven't met my burden, check no and return your verdict sheet. But I've met my burden, I believe. And if I have, you need to move on. You need to move on. What is the total amount of damages that plaintiff Zachary Young has in lost earnings in the past? That's the number I showed you, the $21 million number that Balco gave you. There is no other number, unless you want to take CNN to 0. Put the $21 million number here. Do you find by clear and convincing evidence that punitive damages are warranted against CNN? Before I get to punitive damages, I want to go to number 4. What is the total amount of plaintiff Young's damages for pain and suffering, mental anguish, inconvenience, injury to reputation, lost capacity for the enjoyment of life that he sustained in the past and sustained in the future? It is easy for me to tell you the number from Mr. Balco. It's mathematics. Took his income from before, he multiplied it after. Science. That question's a real hard one. That question's a real hard one. Because there's no simple formula I can give you. Now, I urge you to consider the profound and irreversible impact CNN's actions have had on Zach's life. His reputation, once a cornerstone of his identity and his career, has been shattered. So it's not a fleeting mistake or a minor inconvenience. It was a calculated attack by CNN on his character that has inflicted deep and lasting wounds. Zach's ability to walk into the room with pride, to be seen as a professional with integrity, has been stripped away. His pain and suffering, the mental anguish of seeing his name dragged through the mud, the humiliation of being misjudged by his peers and the public, these are injuries that transcend monetary loss. They pierce the soul of who he is, who he was. And while economic damages are concrete, they just don't capture the true cost of this injustice. To Zach, the loss of who he was, the capacity to enjoy the life he worked so hard to build, and the humiliation he so publicly suffered is far more devastating to him than the financial setbacks. The scars of this humiliation, of this pain and suffering, they will never go away. You heard Dr. Vincent. They will continue to plague him. To this day, he remains in treatment and on medication to keep his panic attacks and depression somewhat at bay. This was a former Navy SEAL trainee, a CIA operative. He can't function anymore. And they did it. You saw him break down on the stand when he talked about his relationship with his wife, his inability to be intimate with her, and him speaking out loud for the first time that he's just not the same man she's married. And in his eyes and his voice, you could see the fear that she loves the old Zach more. No man or woman should have to endure that pain. And certainly not because they want clicks and views. There's no amount of money here that can make Zach whole. Trying to quantify the pain he's endured, the pain we witnessed, it's an impossible task. We can't put a number on it. What I can say is that while these damages can't be seen, you don't see them on his face, They appear far, far worse than the economic damages he's already sustained. They are worse by orders of magnitude. Of course, you are free to disagree. You can give less, you can give more. You are the arbiters of justice. And whatever your decision is, it'll be respected. But we submit it is far, far worse than the economic damages that he's sustained. Now, finally, if you get this far, I'm almost done, Judge. If you decide by clear and convincing evidence that punitive damages are warranted against CNN, if this case doesn't qualify for punitive damages, what does? There was a clear intent to harm Zach. There was clear knowledge that their report was false. CNN moved forward anyway. The previous questions on the verdict form, they make Zach whole. But make no mistake, this question is why the world is watching this case. This is the reason the press has lined the back of the courthouse for the last 2 weeks. This is what makes this case historic. Punitive damages. A media company has to face an American jury with the power to punish. That is not a frequent event. Do you believe CNN should be punished? Do you believe they need to send a message to other media companies to avoid this misconduct? Only you can answer this question. But I respectfully submit to you that CNN deserves punishment. Look at what they did. Look at what they caused. They did it on purpose. Do not let them get away. Media executives around the country are waiting by their phones to see what you do. CNN's executives are waiting in their boardroom in Georgia to see what you decide. Make the phone rings in Georgia. Send a message. This is not acceptable. This is not American journalism. This is madness. This is not right. Do not let it stand unanswered. Thank you very much.
All right, ladies and gentlemen of the jury, obviously the defense has a closing argument, and y'all need to take a break at this point in time between the amount of time since we took our last break. So we're going to take a lunch break. We got lunch here for you. You know, normally we've been doing 30 minutes for lunch, but obviously we want to get back and finish closing arguments. So I've got a few more instructions and then get you out deliberating. Y'all want 30 minutes, or how long do you think y'all need to take a break, grab something to eat real quick, and we can get back in here? We're more than happy to do 30 if you want 30, but if you think we can do any shorter than that, y'all have any feelings, preferences, one way or the other?
I could do 20.
Everybody good?
Let the bailiff know when we're all.
You guys good with about 20 minutes? The sandwiches or whatever they got for lunch is out there in the jury lounge. All right, well, let's shoot for about 20 minutes, and we'll see how you guys are doing, and try to get you back here at, I got to do math, a quarter till. Let me give you the instruction one last time that we're going to take our lunch recess. Remember, all the rules I've given you apply even when we're outside the courtroom, such as at recess. Remember the basic rule: do not talk to anyone, including your fellow jurors, friends, family, or coworkers, about anything having to do with this trial, except to speak to court staff. This means no emailing, text messaging, tweeting, blogging, or other form of communication. You cannot do any research about the case or look up any information about the case. Remember to observe during our recess the other rules I gave you. If you become aware of any violation of the rules at all, please notify court personnel. And if you do use your phones during lunch, just make sure they're turned off before we come back in the courtroom. But we'll try to get you back in here about a quarter till. All right. But don't gobble something down and get indigestion or anything like that. Take your time, but let's see if we can do it in about 10 minutes. All right. We'll be in recess. Y'all be seated. Jurors are out of the courtroom. And before anybody says anything, I'll change the style of case on the verdict form.
Oh, I didn't notice.
It still had Nemex's name on it.
Yeah.
And I don't know that that's a big issue since it came up in a couple various contexts during testimony in this case, but I saw that. And of course, we always see it in closings. You got, Mr. Friedman, you got 13 minutes left for rebuttal now.
Thank you, Your Honor.
Anything else from the plaintiff or defense?
No, Your Honor.
Your Honor.
Okay. Then let's get back in here at quarter till. We'll see how they're doing, and if they're done eating, we'll start back up then.
Thank you.
right, y'all be seated when you get back to your chairs. I appreciate it. Trying to do it on a quick turnaround.
We're getting overtime, right?
Sure. Time and a half of 0. All right, I'll let y'all settle in, but we'll proceed now to the defense closing argument. Mr. Axelrod.
Thank you, Your Honor. So I haven't had a chance to talk to you since 9 days ago. And it's funny, I mean, we did voir dire and we kind of talked about who was on juries, but when you're lawyers sitting in court, you're constantly watching the jurors. What can I see? What can I read in a look? What can I read in a smile? And then we get the questions. The questions help. But one thing that we can tell is that you all have been incredibly diligent, which when you're a trial lawyer, of course you want to win your case. Of course. Mr. Friedman wants to win. His partners want to win. We want to win. No doubt about that. But one thing we really hope we get is a jury that cares and a jury that's going to spend their time looking through the evidence and doing the right thing. And I think that we all can agree that you are that jury. I'm going to repeat a phrase probably 35 times during my closing. And I'm going to apologize ahead of time. But it's a phrase that it's not black market. You won't have to hear it. You'll hear that a lot. But it won't be, this is going to be more. It's the phrase common sense. Because you all were selected to be put on this jury because of your common sense. It's what we all want. And it's in the instructions. I forget what page it's on. But when you go back and look at the instructions, it says, use your common sense to figure out the case. And I cannot ask you to do that more. Use your common sense and your life experiences. When you all get together and talk about the case, when you look at the video, when you read the article, when you look at some of the communications, use your common sense and ask yourself, just right off the bat, are you seeing a conspiracy? Or are you seeing people try to do their best? I submit it's the latter. Mr. Friedman obviously thinks it's the former. But that's why you're there. Because you all you've lived your lives. Like you've gone to work, right? You've talked to your friends. You know how people think. You know when somebody writes a really stupid offhand comment, it doesn't mean they hate someone. It doesn't mean when they want to destroy their lives. Maybe they're reacting to something really, really bad that they just saw. But what we're asking is that when you look at those things, you use your common sense. Because that's how you figure out what the truth is. And I'm not going to ask you today to send a message. I'm going to ask you to find the truth. I'm going to ask you whether CNN defamed Mr. Young. That's it. That's what this case is about. You all didn't come and sit in this jury to deliver a message to big media. You all came here, you took the oath that you would apply your common sense to the facts of this case. And that is all I'm asking. And I think when you do, you'll find that CNN did not defame Mr. Young. But let's get into it. So when I started, or when I opened, I should say that I was going to tell you that CNN's reporting was accurate, tough but fair. And I'm going to tell you that all day long. Sometimes stories get told, and they're true, but they're tough, right? They're tough because they tell the truth about someone, about what someone's doing. And obviously that person doesn't want to be talked about, but it happens. And you heard these various journalists, reporters. Katie Bowe-Lillis, she feels like she's got a duty to tell stories about people. Sometimes they're tough stories. Now, I don't think this is a tough story, actually. But it was a fair story. We're going to get into it, but Mr. Young, he didn't want to be reported on, no doubt about that. We see that in all those text messages. But he put himself in the middle of the story. He was out there. His advertisements to Afghans, as the court has already found, they were newsworthy. It was part of a big story. But I told you right in openings that I was going to talk about three things. And one is truth. Now, when you looked at Mr. Friedman, his closing, and when his partner Kyle Roach did the opening, they didn't want to show you the articles that this case is about. This is a defamation case. So the two most important things you all need to look at are the segment and the article. And I would say, look at them as many times as you can. Because they're accurate, and they're true, and they're fair. The second thing I'm going to talk about is no defamation. Now, The instructions talk about defamation. You'll see all the instructions. We're going to go through it. The story that you were told by Mr. Friedman and his client was that Mr. Young had this deep bench of people. People really trusted clients, colleagues, people he'd worked with. But at trial, none of the receipts showed up. There were no people who talked about what a great reputation he had before the CNN publications. None of those people came to court. There were no people who showed up and said that he was untouchable, that they wouldn't work with him. None of those people showed up. There was no evidence that he was harassed or humiliated after the CNN publications. And opposing counsel said they were so obvious, they called him a criminal, blah, blah, blah. If that were true, you would see that type of evidence. It just doesn't exist. Use your common sense. No reputational harm. And that's kind of similar to what I was talking about. There's not a single person who showed up to testify to you that they wouldn't hire Mr. Young. He had this contract with Momentum. We're going to talk about it. And it went for 1 year, from 2020 November to November of 2021. And it wasn't renewed, right? Mr. Young said he never called up Momentum to ask why it wasn't renewed. He also testified that documents came from Momentum and none of them mentioned CNN. Now, if Momentum had not renewed the contract because of CNN, that's a really easily knowable fact, right? Somebody would have said, wow, we watch CNN. We can't work with that guy. It would be really easy to prove that. But no one came to court. And it's a big deal. Mr. Friedman made a huge deal about what a big lawsuit this was and how this man's life has been destroyed. And maybe he's right. But if he is right, you surely would have expected them to come to court with receipts. We're almost 3 years from that March 17th letter when Mr. Young wrote CNN saying, you better correct this or I'm going to sue you. 3 years. 3 years to marshal the evidence to show how badly I've been harmed. And you all got bupkis, except for an expert witness who was paid. And we'll talk about that in a little bit. But it shouldn't have been that hard. If this really was a defamation case, if this really was an instance where a man was torn down, where a man lost his life, where a man lost his career, it should be really easily and apparent to bring that evidence to court. And you saw none of it. All you got was, I had this income one day, and I didn't have this income the next day. But if that were true, where were the witnesses? It should be really easy. Use your common sense. So, I want to talk about what the story is first. This is what the story was about. Mr. Marquardt told you this was an incredibly important moment in American history, and it was. 20 years of the U.S. being in Afghanistan, and then we blew it. The government blew it, and it was a major failure. And it was something CNN was reporting on a lot. This wasn't, as Mr. Marquardt said, this story wasn't a one-off, and it wasn't a hit piece. I started on a series of stories to highlight the efforts to try to get them out and get them to safety. This was a hugely important story in American history. And that's what he did. Now, Mr. Friedman put up kind of that fake banner about what the story could have been about Mr. Young. He said this could have been a feel-good story. I submit that that's not the case. Mr. Young wasn't just a bit rough around the edges. You saw him on LinkedIn where people would say, hey, what's this price for? And he would say, run for the border. He would tell a woman he didn't know, F off. That's not the kind of guy who is the feel-good story. It just isn't. So we shouldn't oversell it. But let's talk about what the reporting in this case showed. So the case got started, and there's no doubt, the story got started by Jill Cornetski saying, anyone interested in a story about an American mercenary charging people $13,000 per head. And how did she know about him? Because he was out there on LinkedIn, out in the open, advertising his services. And obviously it irritated her. Obviously she saw it as something wrong. And you'll see over these next 8 days, this is a timeline from October 20th to October 28th, Mr. Marquardt got all this information. And this is probably, thing's not working, it is working. This is probably the most important one. Do you have a sponsor able to pay evacuation costs? Not really, but can I pay them myself? And Mr. Young says $14,500 per person. And that caught Mr. Marquardt's eye. Because as the story that was actually published, it was about the pressure that Afghans were facing. It was about the prices that Afghans were being charged. And Mr. Young, right there, was charging the $14,500 per person. The court's found, and I know Mr. Friedman didn't like it, he didn't want to talk about it, but the court has already found that Mr. Young was directly advertising to Afghans, and we're going to show you a lot of them. But that's not all Mr. Marquardt saw. Mr. Marquardt and Ms. Lillis saw a man who, at a time when all of these veterans organizations were trying to fill this horrible void by the U.S. government, Mr. Young filled it by charging a lot of money to try to make money for himself. It was exploitation. And they saw his messages, run for the border and see how far they get. And they saw his prices. And it was newsworthy. It was something that was worthy of being reported on. So, Mr. Marquardt, he doesn't just run off and say, I'm going to get this guy, because he doesn't have that kind of power. CNN is a corporation, no doubt. But it's also a collection of individuals. And there's checks and there's balances. Mr. Marquardt couldn't just run off and say, I don't like this guy. I'm going to do this story. I'm going to get him. It doesn't work that way. He's got bosses. His boss has got bosses. It went through different levels of editing. Different people looked at it. But this is how it got kicked off. On October 28th, we saw this pitch. Extortion of desperate Afghans. And so what Mr. Marquardt's really talking about here is this situation, this vacuum that got created in Afghanistan, where the U.S. government, major policy failure, and people are going to die. I mean, you heard it from General Young. You heard it from Mr. Young. You heard it from CNN's witnesses. It was bad. It was worth reporting on. The pressure that those people who had no hope were facing. And here's Mr. Young at the same time. He's advertising all over LinkedIn. He's saying, if you or someone in your network needs help with Afghanistan air evacs, please reach out. And it's got that little globe. Some of them say sponsor, no doubt. A lot of them don't. We are having success, as recently as today, moving people overland into neighboring countries. And you would see these desperate pleas by Afghans reaching out. Hello, I'm an SIV holder, and I need your help to evacuate me from here. That's what the story was about. It was about the desperation of Afghans and how hopeless it was. Over and over and over again, Mr. Young was prominently advertising on LinkedIn his services. So, as we saw, Katie Bo-Lillis joins the reporting team with Alex Marquardt. And you saw Katie Bo-Lillis take the stand. I guess she's a co-conspirator now, but that's up for you to decide. And again, use your common sense when you evaluate the people who testified before you. But Katie Bo-Lillis, and this is what's really interesting about this case. Alex Marquardt learns about Zach Young about 10 days before this, and he starts looking into it. He doesn't share that information with Katie Bo-Lillis. But what happens? She finds out about it completely independent of Alex Marquardt. See attached text from one of these guys who is charging. His name is Zach, and he's literally advertising on LinkedIn. I've got a few shared connections, so I can do a little digging on who he is. He was so prominent in doing what he was doing that Miss Lillis, which randomly found him herself, which is crazy. I mean, it just shows how prominent he was doing this. The other thing is look at the content of the information that Miss Lillis got. $15,000 passports, $5,000 visas. I mean, these are crazy things that Mr. Young was offering. And you heard him testify. He never provided any of those. But he was still all over LinkedIn offering these services. Now, Mr. Friedman told you Zach Young only worked with corporations and NGOs because they had the sophisticated ways to settle people. They had the sophisticated ways of moving people through immigration. If that were true, why is Mr. Young advertising passports and visas? It's not true. He was sending these out to everyone, to any Afghan, over and over again. So, as this gets going, Mr. Marquardt sees the Bloomberg and Audible, and Mr. Friedman talked about it, and we talked about it a lot. Mr. Young himself testified that Mayor Bloomberg was involved in evacuating people from Afghanistan. It was early on in the trial, but you may recall it. Alex Marquardt just didn't sit on his hands and say, I'm not going to check this out. He reached out to Mayor Bloomberg's people to find out whether it was true. And we know that he probably got some traction because Mr. Young reached out to Katie Bill Willis and told her, I've heard CNN's been asking about me. So we know that Mr. Marquardt's reach out efforts were effective. Somebody was looking. Now, he never got confirmation from Bloomberg. But for some reason, Mr. Young contacted Katie Bill Willis out of the blue. Now, Audible, you heard. Mr. Marquardt didn't think that Audible would be in Afghanistan. But it wasn't like he was trying to bury it. You can see in his Slack messages between him and Katie Bill Willis, they talk about it. Audible? Question mark? Why would Audible be in Afghanistan? Now, if this was this big conspiracy from the beginning, would you see that in a Slack message between two people? Of course not. And really, just one point I'll make really quickly. Mr. Friedman and his team had all of these messages to ask people all of these questions. How did they have them? CNN didn't destroy any of these things. You got to see the truth. You got to see everything that was going on. Because CNN didn't destroy it. The only person who destroyed their messages before this trial was Mr. Young. But we'll talk about that in a little bit. So, as you know, Ms. Lillis starts texting with Mr. Young. And Mr. Young immediately starts kind of exaggerating. He said he gets requests from journalists on a daily basis. He's in full cell mode. Full cell mode. He's exaggerating about the sponsors. And remember his testimony when he said, oh, I meant sponsor, it was just a typo. But go look at his messages. They're all written in the plural form, and I know that there's been a lot of parsing of words. But you saw Mr. Young on the stand. He couldn't admit that he was exaggerating to Katie Bill Willis. And why is that important? I mean, I guess sponsors, that's not big a deal. But if you can't admit that you were exaggerating on the stand, how can you trust everything he's telling you? And a lot of their case relies on what Mr. Young tells you, because he doesn't have the receipts for his damages, for his reputation, for his destruction of evidence, for what he told his Austrian doctors. Ms. Lillis and Mr. Young go back and forth. And you can see, this is like the reporting. This is how the guts of reporting. And of course, Mr. Young didn't have to talk to her, but he kept doing it. And all Ms. Lillis was trying to do was to get information, because that would help the story. He says, Katie Bill Willis is flat out. I know that Mr. Friedman really pushed her and this idea that she wasn't being honest with him. But you see at the end of this conversation, that's part of what I hope to talk about, the price model. Our understanding is you're asking for $75K for a vehicle to Pakistan and around $15K for a single person to UAE. That seems exorbitant. She couldn't be more clear about what she was interested in. Young didn't have to respond. That is his right. You all ask questions about that. He absolutely didn't have to, but he kept responding and she kept asking more questions because she's a journalist. She's a reporter. She wanted to learn. She wanted to understand what he was doing. But he didn't ultimately give her the information. And that gives her less info to go by. And that gives CNN less info to go by. And at the end of the day, this is a case where Mr. Young says, well, you didn't include this about me. Well, Mr. Friedman said this is a case about choices. It is a choice. Mr. Young could have said, I've worked for Audible. I've worked for Bloomberg. I've worked for Civil Fleet. I've worked for Hero. Here were all the connections for those people. He could have said that. And they would have followed up. And maybe we wouldn't be here today. But Mr. Young didn't. Instead, he made up this kind of exaggeration that he aligns sponsors with Afghans and then provided no information about it. But what was pretty clear was at this time, Mr. Young was making a lot of money from these Afghan evacuations. And he didn't want it to become public. And that's fine. General Young said, it's a matter of opinion. You may like that he's charging a lot of money. You may not like it. You may think it's bad to war profiteer. You may think it's good to war profiteer. But it's a matter of opinion. Mr. Young had a right to make a 66% profit margin. Nobody's saying that. But we in America get to have opinions about these things. And some people don't think it's a good thing. Mr. Young didn't want to disclose it, but here are the numbers. This is what we learned in discovery. In about a 2.5-month period, he received $456,000 with a profit margin of 65.5%. That's the math that was very easy to do that he didn't want to share with Katie Bowe. Because he didn't want her to know. Because this would have been newsworthy. It would have been newsworthy that because of this vacuum in Afghanistan, that someone was coming in and filling the void with really high prices. You can see that this keeps going on. Mr. Young says, pricing always depends on local resource availability. Well, this wasn't true. The pricing was dependent on his profit margin. He then says, no Afghan is expected to pay for evac costs. None would ever be able. Rather, we're focused on aligning corporate sponsors. But ultimately, he agreed when he took the stand that his prices were exorbitant. He knew that. He just didn't want to share it. That's his right. But in a case about choices, you don't get to say, I'm not talking, when you know there's a story about you, and then say, you didn't include my information. Mr. Young never provided the information that he wanted to include. Again, Katie Bowe says, can you point me to some cases where you've successfully connected a sponsor and an evac case? And you heard Mr. Levine say that if they'd gotten that information, that would have gone into the story. Maybe it would have gone in a completely different direction. I mean, Mr. Young testified on the stand that CNN asked him. They asked him about his successful operations, but he never gave any examples. This court has already found that Mr. Young advertised directly to Afghans. And so Mr. Friedman's kind of bobbing and weaving about only needing sponsors, only advertising to sponsors just isn't true. I mean, we saw in the exchange with Joe Kornetsky, one of the very first advertisements, August 20th of 2021, Mr. Young reached out to Joe Kornetsky. Joe Kornetsky was not a corporate sponsor. The story just doesn't make sense. Mr. Young was advertising directly to Afghans. The court found he didn't take any money, but he was directly advertising to Afghans, and he was what the story was about. Really high prices to desperate people. Again, Katie Bowe asked, we're not in any rush. This is November 3rd. And as we get to the end of the call, the end of the exchange, Mr. Young throws out at Katie Bowe Lillis slander and libel. And this is November 3rd. And he admitted this is a really interesting exchange. Young admitted on the stand that there was nothing slanderous in the exchange. He was just suspicious that she was criticizing the private market for evacuations. It didn't make any sense. Because he knew when he threw around the word slander and libel on November 3rd, that CNN was looking into him. He had from November 3rd to November 11th to reach out to CNN and say, I'm going to share my information with you. I'm going to talk to you about the really good work I was doing. He could have done that. This is a case about choices, and he didn't. Alex Marquardt calls Mr. Young on November 3rd. And Mr. Friedman's made a big deal of this. He thinks it's a fake call that never happened. Here's Mr. Young's deposition testimony before this became part of this trial. Oops. Oops. How do I do this, Mr. DeMeza? Can you push play? Anyway, you saw it, and it says, did you have any reason to doubt that Mr. Marquardt called you? And the answer was no.
The next line is, we got Young's number and called, but he didn't pick up. Do you have any reason to doubt that Mr. Marquardt called you?
No.
That was Mr. Young's deposition testimony before this became a key part of the case, a key part of the theater theme. We give you back control. Yeah, there you go. So as you see, the story got greenlit on November 4th, and there was a full 7 days for Mr. Young to engage. He had contact information for Kitty Bowles. And at any point, he could have said, you all got it wrong. Here's what I'm going to tell you. He knew it was about him. He could have reached out at any point. Now, as I said, Mr. Marquardt, CNN is a company, but it's a company of people. And Mr. Marquardt couldn't just run with a story. Ms. Lillis couldn't just run with a story. There are processes and procedures in place to vet and make sure that stories are accurate. And that's the triad. And you heard from Buzz Hogan, and you heard from Emma Lacey Bordeaux. They were not involved in the reporting. They took an individual, independent look at everything. And that's really important, right? Because if there wasn't a system like that, if one person just wanted to run hog wild with a story, they could do so. And they could produce something like that. But that isn't the situation that CNN had. It had this triad in place where those triad members would look at the stories before they got out. And if you look here, look at DX 103, 105, and 107. They'll be in evidence when you get back to the room. Those are back and forth about the triad where they're asking questions. Mr. Marquardt's providing more information. This is not a rubber stamp. This is how you get to a factually accurate story and a fair story. I mean, you saw Emma Lacey Bordeaux take the stand. Of course, you have to decide, but does she strike you as someone who's going to be in a conspiracy to defame someone? Of course not. So then Mr. Marquardt texts Mr. Young on November 10th at 2:42. I guess it's 8:42 in Austria. Recall, though, at around this time, Mr. Young said he was up all night working on these evacuations. But he doesn't respond. He doesn't respond until about 22 hours later. And at that point, he says, "Hi, Alexander. Please provide a list of questions as well as the facts and assertions about me you intend to publish." And Mr. Marquardt does. Without knowing what the deadline is, Mr. Young says that's not a realistic deadline. He's just trying to push it off. Because here's the thing. Mr. Young talked about his network and this quiet professional network. He knew, whether the story was true or not, it was, that if a story named him, this quiet professional thing would be done. Because in his world, people don't advertise on LinkedIn. They especially don't advertise big costs for evacuations from Afghanistan. So he didn't want that to get out. That's fine. But that doesn't mean that CNN defamed him. And he was pushing back. He was trying to stall. He didn't want the story to come out. Mr. Marquardt writes back, and then he sends all of the information to Mr. Young. Young cautions Marquardt to get his facts and assertions right. But when asked which are not accurate, Young never replied, because none of the facts and assertions were false. They were all true. I mean, Mr. Marquardt, in his own words, said all of the facts on LinkedIn and the statements to other people, that's what he was using. He said, tell me what's not true. Mr. Young couldn't do it because none of it was true. He just didn't want to be in a story because he was a quiet professional, and he knew that advertising on LinkedIn was not being a quiet professional. I mean, at the end of the day, it may be very well that his professional contacts don't talk to him. We don't know, because you never saw the evidence. But it could be they don't want to talk to him because in his world, you don't advertise on LinkedIn evacuations to Afghanistan. That is not being a quiet professional. But again, we don't know because none of those witnesses came to court. Mr. Marquardt testified, and the documents support it, that when Mr. Young wrote back to him on the day of the 11th, Mr. Marquardt thought there could be more re-engagement. He thought he could get information. He said basically, stop the presses. If he gave responses that changed the story or added a fuller explanation of the story, we would have included that in the piece. It was important. And you'll see when you get back in the room, Mr. Marquardt was working on this way up until the story ran at 4:30. He kept sending more information back to the triad. And he testified that if Young had come back with more information, they would have gone back to the triad on it. Without question, we would have reworked the piece up until the final moments to include what he had to say. And you see Michael Callahan's email. Please see another tweak in yellow per triad. Fair warning, our Zachary Young guy has reemerged on text with Alex, so may need to tweak if he addresses our questions. If it's a hit piece, if they all hate him, why would they be taking time to email to adjust the piece if Mr. Young writes back? They wouldn't. They're doing reporting. This is what happens. So the segment airs at 5:38 p.m. It is just over 5 minutes long. Mr. Young is not mentioned until 3 minutes into the story. And I implore you to go watch it again with fresh eyes after you've seen everything. It never says Mr. Young committed fraud. It never says Mr. Young committed a crime. The segment says that Mr. Young's charging $14,000 per person. And then, this is really important at the very end. You saw this what we did with Adam Levine. It says he only takes money from sponsors. Those were his own words, and they were included in the story. If this were a hit piece, if this was trying to harm Mr. Young because they hate him, why would they include his own words in his own defense? And this is what I was talking about. When you look at that 1 minute time period of the story, from like 3 to 4 minutes, all they are is information from Mr. Young himself. And this is the most important one. If someone reaches out, we need to understand if they have a sponsor behind them to be able to pay evacuation costs. And Mr. Young himself testified that that was clear as day, that he was only taking money from sponsors. CNN put that in the story. Because while the story was about the high prices that people were charging Afghans, they wanted to share what Mr. Young had told them, the very few pieces that Mr. Young had told them. And those pieces demonstrated that Mr. Young was saying, sponsors only. If you hate Mr. Young, if you want to defame him, if you want to make fake news, you don't put that stuff in. You also don't wait till the 3rd minute of a 5-minute story to run this hit piece. That also doesn't make sense, but we'll get to that in a little bit. So black market. Mr. Friedman made a big deal of going up to all these people and saying, what's your definition? They would say, oh, unregulated. It was the wrong question. How do we understand words, right? When we're in our normal life, we don't go to a dictionary. We understand words in context. And in fact, that's what the instructions say. The instructions that the court gives you say, look at the words in context. And in context is a fancy way for saying, look at the way the words are used. And the word black market was used in an accurate way to describe the situation in Afghanistan. Everyone agreed. General Young, too. It's the wild, wild west. Some people were taken out and killed. People were using safe houses. People were flying under the radar. People were avoiding the Taliban. You couldn't just go to the airport. Black market was a perfect way to describe that. That's what it was used for. And that's the way it was understood. Now, could black market mean criminal in a different context? Yeah, sure. If this was a story about running guns to Syria and the word black market was used, yeah. Black market would probably make sense as a criminal word. That isn't this. If black market was used to talk about the secondary market for Taylor Swift tickets, would anybody say that was criminal? No, of course they wouldn't. But they definitely wouldn't in this situation. It perfectly fit the bill. All right, so let's talk about the digital article. Now, Mr. Lumley takes the stand, and you all saw him, and I'm going to ask you to use your common sense. Does anyone have anyone in their lives who just likes to kind of complain a lot and they never really stop? That may have been Mr. Lumley. And you saw that. He had this fundamental question. And that fundamental question had nothing to do with Zachary Young. All of his complaining, it's a half story. It's got holes like Swiss cheese. I don't like it. It's a mediocre story. His complaints were that he wanted more information about what happened to the Afghans that paid. That was his complaint. He never said in any of those documents that Mr. Friedman showed him, I hate how we treat Zachary Young. He never said that because it wasn't true. Mr. Lumley had a beef. He had a beef with the story. He wanted to go further. He's a print editor. He wanted to tell more of the story. If you think about it, if this was chapter 1, he wanted to chapter 2. He wanted to know if there were people who paid and got out, and what happened to them. Or if it was all just hopeless and people couldn't get out. But that wasn't part of the story. And you heard Mr. Levine, and you heard Mr. Marquardt testify, that sometimes that happens. You know, this isn't an encyclopedia. CNN isn't writing long-form pieces, not all the time, like this. And they're not writing encyclopedic pieces. Sometimes articles are short. Sometimes they're long. Sometimes they report certain pieces. That's what this one did. But Mr. Lumley made extensive changes to the story. And Mr. Friedman brought up the Nicole Guyette email where she talked about the inference running through it. That was a complaint about an earlier draft. The draft that ultimately gets published on November 13th is far different because you see all that red line. I took Mr. Lumley through all of that and all of the changes that he made. And they were extensive. But you know what? At the end of the day, he said, I still don't like it. And Mr. Friedman and his team think that that's a big deal. But it's actually the opposite. Because again, it shows CNN is not a rubber stamp. If Mr. Lumley was just a rubber stamp, if they were just processing articles, if Alex Marquardt could just say, I want to get this guy Zach Young, and that's it, that's what he would do, and Mr. Lumley wouldn't say boo. But that's not what happened. Mr. Lumley raised his hand. He said, I have a fundamental problem with the article, which is that we don't talk about what happens to people, and the story changed. And this is the final piece that was published 2 days later. I urge you to go read it. Again, it went through full triad review, and Mr. Lumley made numerous edits. Again, it is 30 paragraphs long, and Mr. Young is not mentioned until paragraph 22. And if you look at the headline, this is hardly sensationalized journalism. If they were going after Mr. Young, wouldn't they have said something like, ex-Navy SEAL, ex-CIA officer going after Afghans? Of course they would. Instead, they used a pretty, and I'm sorry to my friends at CNN, a pretty boring headline. It's pretty boring. And we know it's pretty boring because nobody clicked on the article, as Mr. Levine showed you. The numbers were like really bad. Nobody read the thing. The article never uses the term black market that Young claims defamed him. But most importantly, when you get to the end of the article, you see that sponsor's there again. It talks about Mr. Young and his sponsors. Because it was fair. It was the right thing to do. So, this is November 11th and November 13th. What happens for the rest of November? Nothing. No one says boo about these stories. What happens in December? No one says boo. There's no complaints about these stories. No one says, how could you write this about Mr. Young? Nobody says, how could you use the term black market? No one says anything until March 17th, 4 months later. That's how long it took. And this was after Mr. Young hired lawyers. This was after Mr. Young had destroyed messages that he thought wouldn't help his case. This is after Mr. Young had talked to 2 doctors in Austria and told them that he had been in Afghanistan for these evacuations. And he writes this letter. And the letter that he writes to CNN cites the use of black market, but Mr. Young doesn't complain about the use of the word preying or claim that the article suggests that I'm preying on Afghans. He claims CNN defamed him by stating he advertised to Afghans. But that's just what the judge found. But he does complain about the implication, he does not complain about the implication that he's a bad actor. And he does not complain that the article says that he's bilking people. But what's critical about this is that no one at CNN had heard any of these complaints for the 4-month period between November and March. So CNN ran the correction. And they ran the correction because CNN never intended to imply that black market meant criminal. And CNN never heard it. No one raised that assertion ever for 4 months. And the correction was seen by more viewers than the original show. And, listen, I know it's somewhat confusing that CNN ran a correction, but all the people who worked on the story don't agree with it. They're not CNN the company. They're reporters who worked on the story. But had this case never gone to trial, the correction would have been the only thing that people saw. That would have been CNN's message. But obviously, when you go to trial, Mr. Friedman asks people what their opinion of the correction is. They're not going to love it. Some people aren't going to love it. And these people thought the story was a good story. They thought black market was fair. Now, if they were all involved in a big conspiracy, wouldn't they have gone along with CNN? Wouldn't they have towed the company line and said, oh yeah, we stand by the correction? Their testimony is evidence that there is no conspiracy. So that's the timeline. I did that because evidence can come in really quickly in a trial. And I wanted to make sure that I at least tried to run through it again so you guys could all see the timeline and understand again what happened. But you'll have all these exhibits back with you. So let's talk about a couple different issues. Everything in the Afghanistan evacuation story was true. Young was advertising directly to Afghans. And he was exaggerating too. This is one of the most important ones. Still conducting emergency evac flights from Afghanistan. Please reach out if you require support. Still, Mr. Young never ran evacuation flights. It's very telling that he wrote that, because you got to see kind of the embellishment before we come to trial. But he was all over LinkedIn, advertising directed to Afghans. The CNN pieces used the word exorbitant. Mr. Young's prices were exorbitant. 66% profit margin. It was spot on. It was way more than any Afghan could ever afford. But it also showed, as Katie Bo-Willis suspected, was that Mr. Young was taking advantage of a horrible situation to enrich himself. And whether you hate it, or whether you don't mind it, or whether you love it, that is newsworthy. This is an incredibly important point. Afghanistan could not have been a bigger story in November of August to November of 2021. CNN just didn't go out looking for a villain. Mr. Young was out there advertising. Was it shocking that people found out about it? Of course it wasn't. These were just some of his advertisements on LinkedIn, where he's advertising all of these different things. Flights, passports, visas, all of these different things. And he was spotted by Ms. Kornetsky, by Katie Bo-Willis. Mr. Young put himself in the story, not CNN. This is not a case where a private citizen is just at home minding their own business. Mr. Young knew this was a big story. And he inserted himself into it. He inserted himself into it to make a buck. That's his right. But you don't have the expectation that someone isn't going to write about it or not necessarily right about it if you do so. It was reasonable. And so, as I said, Mr. Young's conduct was so brazen that people saw. Mr. Marquardt's sources saw. Katie Bo-Lillis' sources saw. Another issue, Mr. Young had plenty of time to respond to CNN. They reached out 8 days before the story ran. 8 days. And they reached out 8 days before because that's good journalistic practice. If you want to understand what someone's going to tell you about what they're doing, reach out early. That's what they did. And I know that Katie Bo-Lillis, could have come off a little bit persistent, but she wanted information and she wanted Mr. Young to have a full chance to respond. And so on, she asked him, tell me more. And he wouldn't do it. But you can't say that he didn't have enough time to respond to the story. You can't say that they were negligent in not talking to Mr. Young about what he was doing. There was no negligence here. Then Mr. Marquardt reached out, and they kept trying. And Mr. Young admitted it would not have taken him a lot of time to answer the questions, probably just a few minutes. And again, this is just basic journalism. Reaching out to sources and seeing if they'll give you more information. And here they did. Here they reached out to Mr. Young, gave him a chance to comment, and he didn't. That's his right. But the claim that he didn't have enough time to respond just isn't true. There's also some good reasons to reject kind of Mr. Young's testimony. And I'm just going to talk about a few. So, Mr. Young admitted he exaggerated when he told Ms. Lillis that he gets requests from journalists stuck every day. Some people would call that a white lie. I'm calling it an exaggeration, but it matters. Then there's the sponsor exaggeration that Mr. Young couldn't admit on the stand. Then there are the Austrian doctors. So Dr. Vincent came in and said that he reviewed the Austrian doctor records. When you saw that 2 different sets of doctors were reporting that Mr. Young had been in Afghanistan at the time of the CNN publications, didn't you say to yourself, this is a big red flag? No, he didn't. But it is. Because why would someone go and tell their doctors that they were in Afghanistan where they weren't? Because Mr. Young knew that he was bringing this lawsuit, and he knew that those doctors were going to come up with a diagnosis. And he wanted them to think that he had been in Afghanistan so they would write a more serious diagnosis. That's why he did it. There was no other reason to embellish whether he was in Afghanistan or Austria. But it's a big red flag for you all too. Because if Mr. Young was willing to exaggerate with Ms. Lillis, kind of make stuff up with his doctors, how can you trust him? You can't. Use your common sense. He exaggerated his capabilities. Again, air evacs. Still conducting emergency air evacs. If you need to get out of Afghanistan tomorrow, please reach out. Just exaggeration over and over again. And I know some of it's small. I get it. But the question remains, how can you trust him if this is what he was doing? So, at the end of the day, you need to look at all the evidence and decide whether it makes sense. And this is the big thing. Use your common sense. Because Mr. Young's story does not make sense. So first of all, no evidence anyone viewed the story the way Mr. Young did. This is a big deal. Because defamation is called defamation because it hurts someone. So if it was obvious that the story labeled Mr. Young a criminal, if it was obvious that the story labeled Mr. Young a bad actor preying on Afghans by taking their money, wouldn't somebody have saw that and said so? Wouldn't Mr. Young's contacts come into court and say, we can't touch him because of what CNN said? Yeah, they would have. But there are no witnesses to support that. Not a single one. Mr. Friedman told you that CNN goes out to millions of homes, and he showed you the numbers. Wouldn't there be someone who could come in and tell you that they saw the story the same way Mr. Young did? Wouldn't it be easy? Wouldn't that be the kind of evidence that you would want to see? before you write a check for CNN? Of course it is. Use your common sense. But not just other people. We didn't even get testimony from any of his family or associates. Where were those people? It would have been very easy for them to say, man, as soon as I saw the story, I was floored. They called my brother. They called my cousin. They called my son a criminal. They called my colleague that I've known for 20 years. Where were those people? There's no evidence that the story made anyone think less of Mr. Young. I mean, again, Mr. Young said that he had all these contacts, all these colleagues, and they were really impressive people. Leon Panetta was head of the CIA, head of the Department of Defense. Where were those people? Why didn't they come and say that Mr. Young was untouchable then? Why not? The only person you heard on that entire list who was asked whether they knew Mr. Young was Alex Marquardt testified, and Mr. Friedman didn't think he was going to say this, testified that he had contacted Jeremy Bash, who was on that list. And Jeremy Bash had said he'd never heard of Zachary Young. It's a big deal. Because when you get on the stand, you can kind of say whatever you want. But you've got to, if you have a case where you're asking for a lot of money, and you're trying to prove a case for defamation, bring witnesses. That's what you, the jury, deserve. Because otherwise, you're just guessing. You're just guessing about reputational harm. You're just guessing that Mr. Young's untouchable. No evidence, no one would work with Young. So he admits that he made no phone calls to find work. None of the Amentum documents mention CNN. After the report, he retained a security clearance for at least a year. And after the report, the only thing we know about Mr. Young being an untouchable was that he was touchable. The month after the report, he admits he signed a consulting security agreement with Helios Global. If no one would talk to him, if he was a pariah, why would this company, Helios Global, associate with him? It doesn't make any sense. Again, if no one wants to work with you, bring him in. He's got subpoena power. He can compel them to come. There's got to be someone. The reason there isn't is because no one thinks that. Otherwise, it would have been really easy for Mr. Young to show you that evidence. He can't show it to you because it doesn't exist. And you deserve more. Mr. Young's claims of emotional distress don't make sense. And listen, if you thought that I was downplaying mental illness, I apologize. I'm certainly not. I know that there are a lot of people with issues, and that it can be really terrible. And sometimes you can see a very healthy person, and they're dealing with a war inside. But in this case, it doesn't make any sense. Mr. Young told you that he went through Navy SEAL training. He went to Blackwater. He goes to conflict zones all over the world. He's tough as nails. He writes on his resume, I deal with stress all the time. The TV segment was 1 minute, buried in a 5-minute story that ran 5:38 on the Jake Tapper Show. It doesn't make any sense that 1 minute of that story would send Mr. Young into a funk that he could not overcome. And then you even saw evidence here. You, the jury, you asked him about his support system for his disability. And I don't know which of you did it. And Mr. Young thought you were talking about his back. He spoke at length about his back injury that he sustained in Navy training. That's a window into his soul. You all were asking about this mental distress, this emotional distress that he's dealing with. And he thought you were asking about a back injury. Young's own expert, who is a paid expert, he does this for a living, and he's very good at it. He was a pro. He knew there were problems. He admitted that there's a 40 to 50% malingering rate for cases with emotional distress in them. He administered a computer-scored test, which is important, not a subjective test, but he put all the data into a computer and it pumped out this result that suggested that Mr. Young was exaggerating his symptoms. And he turned his head on it. But the biggest red flag, the one I asked him about at the end, isn't one of the most significant red flags for exaggeration not following up on prescribed treatment? And in this case, Mr. Young was prescribed by his doctors in Austria to go to inpatient treatment. And he didn't do it. And that's fine. He can do that. He said he had to stay home and take care of his dog, and it's a good-looking dog. But if you are someone who is crippled with anxiety, with depression, with unspecified trauma, if you really have those things, don't you follow your doctor's orders? It's a huge red flag for this. And this, as Dr. Vincent testified, this is an area that's really susceptible to abuse. Dr. Vincent kind of didn't follow his own guidance. Dr. Vincent said that in cases like this, you have to interview a collateral source who's unbiased. And that's all fancy language for, let's go find someone and talk to them about how the patient really is. And the only person that Dr. Vincent talked to was Mr. Young's wife. And he admitted that she has an interest in this case. She's got a very big financial incentive in this case. Could you have conducted other collateral interviews? Yes. You did not. No. It's a huge red flag. Dr. Vincent didn't do the work that needed to do to confirm his opinion in this case. So, Mr. Young's deletion of evidence says it all. So, if this were a criminal case, it is certainly not. But if it was a criminal case and you had heard that the person that was at the heart of the case had deleted evidence when he was suspected that he was going to get arrested, you might be thinking, wow, that's a pretty good sign of what we call consciousness of guilt, which means that he thought he did something wrong. That's exactly what happened here. Mr. Young saw the story come out, and he knew that he was going to claim that he never engaged with Afghans, that he never directed his advertisements to them, that he never told them, hey, you better go find a sponsor and I'll make this happen. So he deleted all of his LinkedIn communications. So we have some of them. We have the one where Mr. Marquardt has the one with the guy where he says 14,500. But there were probably more. There were probably lots more. You saw all those individual Afghans who would respond to Mr. Young's post and say, please help me, I'm desperate. It is a reasonable assumption to believe that there are lots of LinkedIn messages between Mr. Young and those desperate Afghans, where Mr. Young is saying, I'll help you out, go get that money. I'll help you out, go raise some money. Now, he never took any money. That's the court's order. You got to follow that. But those communications would have showed that. And he knew it. And he deleted it. Because he knew he was going to sue CNN. And if there was this whole trove of communications where Mr. Young is talking to Afghans and saying, go get me some money, back and forth, he knew that would defeat his case. So he deleted it. The other really important thing is that, I keep going back to this, but Mr. Young named all these people, Matt Gunning, Akili, other people. He said he was really tight with all those people on the Amentum contract. He deleted all of his contacts. And he deleted all of his call logs with those that would have showed his communications with those people. Why is that important? Because if you're trying to establish that your reputation was harmed, you look at your communications before and you look at them after. All right? If there were no communications before, if Mr. Young didn't have a contact with Leon Panetta, and I strongly suggest that he did not, then having those records would be critical to show whether Mr. Young really said he had the contacts he did. If you don't have those contacts, you can't do anything. There's a reason why Mr. Young didn't show you any phone records, didn't show you any letters from these people, didn't show you any contact information for these people. Because if he had those things, CNN could have contacted those people. CNN could have looked at his call logs and said, oh wait, you said this guy Matt Gunning's your good friend? Well, you haven't talked to him in 2 years. You haven't talked to him in 3 years. You maybe never talked to him at all. Maybe you're making it all up. But you don't have those things because Mr. Young deleted them. And because of the judge's adverse inference, you can assume that those would have been unhelpful to him. All right, I got to get moving. All right. General Young was paid to give opinions that he wouldn't hire Mr. Young for evacuations. He was hired because there were no real witnesses that would talk about Mr. Young's hireability. Go ahead. 45 more minutes? Yeah, thank you. Mr. Bolko was paid to concoct a damages model because Mr. Young had no witnesses who would come in and say, I won't work with him on this contract. You heard Mr. Young talk about the Five Eyes guys who took his project and were running with it. Why not call those people to say, here's the contracts we got, we won't hire Mr. Young, but instead they hired an expert witness. And finally, Dr. Vincent. The evidence in this case was that Mr. Young had 2 Austrian doctors. Why didn't he bring them? Instead, he hired a forensic psychologist to testify about his 3-hour interview with Mr. Young. So let's talk about General Young first. General Young was very impressive, obviously a very great career, and his work on the Afghanistan evacuations was impressive. But why hire a General Young when you have the contacts that Mr. Young says he has? If you have those contacts, you don't need a General Young. Why hire a witness who's going to say, I theoretically wouldn't have hired Mr. Young to do evacuations for me for AA-21, if you have witnesses from these defense contractors who would say, we can't hire Mr. Young, he's an untouchable. You don't need a General Young if you actually have real evidence about damages. And the really important thing is that in contrast to General Young, who said, I wouldn't hire him for evacuations because of reputational risk, we know that Helios had no fear of reputational risk. 1 month after the CNN publications, they signed him on. I just asked Mr. Young about it. Why would a company affiliate with Mr. Young 1 month after the CNN publications if they actually meant something? I submit to you they did not. Mr. Bolko, the paid economic testimony. The Amentum contract ended on November 15th. And you may recall there was an email in the middle of the summer where Mr. Young was saying, I'll come back on as an employee, or you can just pay me for non-compete. And they said, oh, we'll decide about it in a little bit, and then they never got back to him. But what's really important about this is his work with Amentum had dried up in May. You'll take a look at the invoices. He hadn't done any work for Amentum since April of 2021. That work had dried up. Mr. Bolko testified on cross-examination that he had no idea whether Mr. Young had any work lined up in 2022. And remember, the Afghan evacuation work had dried up too. Mr. Young hadn't done an evacuation since October. So he had no work lined up. So he needed to bring in someone like Mr. Bolko, who can put together what I will politely call a ridiculous economics damages model. But it would be really easy, again, to bring in witnesses to talk about why Mr. Young didn't have work. Really easy. And he just didn't do it. Again, I talked about this before. No testimony from the Austrian doctors. No friends or family who would testify about how Mr. Young was before the segments versus how he is now. Only Dr. Vincent. All right, so I'm going to talk to you about the law for a quick few minutes. This court's already found that Mr. Young directly advertised to Afghans. This court's already found that defendants' use of the words exorbitant and exploit to refer to Mr. Young's businesses or practices are not by themselves actionable because they are statements of opinion, which are really important. And then third, this court has already found that the defendant did not publish any statement that called plaintiff a scam artist, that said that he was operating a scam. So I'm going to talk about the law for a minute, and I've kind of cribbed a lot of what the court has put into instructions. If you see different instructions when you go back there than the ones that I put together, I mean, they're very similar. I just kind of cut out some sentences. The court's instructions apply. But I wanted to walk you through kind of the way CNN sees it when you go back in the room. So there are two claims. Defamation per se, which is the black market meant criminal activity claim, and defamation by implication, which is that Mr. Young's claim that the publications implied he was preying on Afghans by taking money directly from Afghans. Two claims. You got to look at them separately. But the issues for determination are the same for each of the claims. There's 6. I'm only focused on the last 4. Don't worry about 1 or 2. So let's talk about these. So how statements are to be construed. Plaintiff must prove that persons who viewed and read the segment and article understood them the way he claims. That is implying that he was engaged in criminal activity or that he was preying on Afghans by taking money directly from Afghans. So again, he had to bring in evidence to show that people actually saw the statements the way that he claims. The meaning of a challenge statement must be determined by its natural and probable effect on the mind of an average viewer or reader. But this is the one that's really important. To determine whether a statement is actionable, you must examine the statement in its totality in the context in which it was uttered or published. So you got to look at the words in the context of the story. You don't necessarily go to a dictionary, you look at how they're used. You must consider all the words used, not merely a particular phrase or sentence. Okay, so that's how you construe statements. That's what the instructions say. Black market did not mean illegal. So words are interpreted in their context. So when we're talking about the per se defamation claim, the first thing you have to decide is whether the statements were materially false. And this is what you have to do. And there's a lot of words. But a statement is materially false if the substance or gist of the statement conveys a materially different meaning than the truth would have conveyed. A statement is also materially false if it creates a false impression or implication. Again, to determine whether a statement is materially false, you should consider the context in which the statement was made. So let's talk about black market first. In the context of the reporting, black market referred to the chaotic and lawless conditions in Afghanistan. You have to use the context to understand that. The report did not describe any illegal activity. Like nowhere in the report does it talk about illegal activity. And I know that opposing counsel wants you to go back and look at some of the early documents where they're talking about scams or whatever, but that wasn't actually in what was published. It's clear from the banners that black market applies to Afghanistan and the chaotic and lawless nature. The whole point of this segment was there was tremendous demand for evacuation services because Afghans could not buy their escape on an ordinary market. That's it. Black market makes total sense in that situation, and it does not imply illegality. Okay. The statements were not materially false. General Young, again, agreed. Kill lists, safe houses, operational security, chaos, lawlessness. A reasonable viewer would not construe black market as criminal. The fourth element you have to consider is whether the statements were defamatory. And this is what I've been talking about through this entire presentation. A statement is defamatory if it tends to harm plaintiff's reputation, tends to lower him in the estimation of community, tends to expose him to hatred, ridicule, or contempt. There is no evidence that the statements in the CNN in the segment, the black market portion, expose plaintiff to anything. Nothing. No nasty emails. No witnesses who say, we hate Zach Young. No people on the Austrian streets coming up to him and saying, hey, I saw you on CNN, you're terrible. None of that. There's no evidence that the statements were defamatory. There just isn't. Now, there's a big difference in this case between what was published in the segment and was published in the article and kind of the emails in the background. When you all look at these statements, you're just looking what's in the segment and the article. You're not worried about the email. There is nothing in the TV segment that anyone here has told you, we don't like Zach Young because of that statement. It just isn't in the evidence in front of you. No one came forward to testify about Mr. Young's view of the black market. No one at CNN shared Mr. Young's interpretation. No one else told CNN they viewed black market as meaning criminal. No evidence that anyone felt that way. All you have is Mr. Young's claim that it was obvious. It was obvious everyone felt that way. But if it was obvious, people would have come to testify that they agreed with Mr. Young, and they wouldn't deal with him. And nobody showed up. Where are the witnesses? Use your common sense. Mr. Young may be unhappy about the article because it called him out for advertising Afghan services. But if people really thought and felt the same way that Mr. Young did about the stories, wouldn't they come and tell you that? Of course they would. The fifth element is whether CNN was negligent. So to recover on his claims, he must prove that CNN was at least negligent in publishing the statements in this case. Negligence is the failure to use reasonable care. So really what this means is, did CNN do a good enough job doing its reporting? And I submit to you that they did. When we talk about black market, we're talking about the lead-in banners, the lead and the banners. The lead-in and the banners were reviewed by the show. They were approved by the show. They were reviewed by Adam Levine. All CNN witnesses testified that black market was an appropriate way to describe the situation on the ground. Throughout the story, CNN relied only on Zach Young's own words, including his sponsor language. And CNN only reported on what it could substantiate. It only reported on what it could prove up. What CNN reported was true. And we know CNN was not negligent because they ran this whole story through the triad. They contacted Mr. Young. They contacted all kinds of witnesses. They reached out to Bloomberg. They ran it through the triad. CNN wasn't negligent. So that's the black market claim. The second claim is defamation by implication. And that is the much longer one that is a mouthful that implied that Mr. Young was taking money directly from Afghans. The entire story was about the prices Afghans were facing, not who was being paid. You all should go look at the language in the segment and in the story. CNN literally repeated the opposite, that Mr. Young was requiring sponsors. Now, I know that opposing counsel got up and said this was a desperation about preying on Afghans and all that. But look at what CNN actually reported. Multiple times in both the segment and in the article, they reported Mr. Young's own words that he needed sponsors. That is the direct opposite of what Mr. Young says the story implied about him. If CNN was meaning to imply that Mr. Young was taking money directly from Afghans, they wouldn't have included his language about sponsors. They just wouldn't have. It didn't make any sense. But they did because they wanted to use Mr. Young's own words to explain what he said, that I only take money from sponsors. And Mr. Young said his words were crystal clear. And CNN reported those words. The evidence is undisputed that Mr. Young was making money off of this desperation. And the story does not say that he was directly taking money from Afghans because of that sponsor language, and because that wasn't what the story was about. It was about the money that people like Mr. Young were charging Afghans. It wasn't about the money they were paying. And again, General Young said this is all a matter of opinion. Again, with the defamation by implication claim, much like the per se claim, you have to assess whether the statements were defamatory. And just like black market, where is the evidence? Where is the evidence that anyone besides Mr. Young interpreted the story this way? Again, I hate repeating myself, but use your common sense. If everyone viewed it the way Mr. Young claims it, they would tell you so. They would have multiple witnesses. They would have Mr. Young's colleagues who would testify, man, as soon as I saw that story, the way Mr. Young was preying on those Afghans, I couldn't work with him. But nobody came here and said that. Because no one saw it that way. Use your common sense. And also remember, Mr. Young's retraction letter didn't mention preying or bilking. It talked about black market, extortion, and exploitation. Remember, when you think about defamatory meaning, for Mr. Young to prevail, he has to show you that when somebody read that and they saw that, and they saw that Mr. Young was taking money from desperate Afghans, they would say, "Whoa, that's terrible." General Young admitted on the stand, Mr. Young's own expert, that taking money from an Afghan wasn't necessarily a bad thing. If you have to get out, you have to get out. And if you read the story and understand the desperation that Afghans were facing, it doesn't necessarily mean that Mr. Young was doing anything wrong, even if he took money from Afghans. He considers himself a hero. He told you that. And General Young agreed. But that means you don't have a claim for defamation if what you say the story implied was actually a good thing. Again, much like with the TV segment we talked about before, Mr. Young must prove that CNN was negligent. The TV segment went through multiple rounds of review. Look at the exhibits. Lacey Bordeaux and Hogan asked repeated questions. Took out content to be fair to Young, and we'll talk about that in a little bit. The article went through multiple rounds of review. This wasn't just a slapdash, one person, let's get this thing filed. Multiple people looked at all of these things because they wanted to get it right. Finally, number 6 is Mr. Young must prove to you all that he suffered economic damages. But when we talk about economic damages, Mr. Young testified he made no calls for work. He testified that no one at Amentum said the contract wasn't renewed because of CNN. No one testified they wouldn't hire Young. And Volko wouldn't testify about causation. There's just no evidence of economic damages. There's no evidence of reputational harm either. And there's too much uncertainty with the emotional damages because of all the red flags. If there was economic harm, it would have been very easy to prove. Just would have. The Amentum people would have come and talked about it, and Mr. Young's other contacts would have talked about it. We've already talked about this. And again, if there was real emotional distress in this case, wouldn't you have wanted to hear from the Austrian doctors? Mr. Young is super sophisticated. You all saw that. He trained spies. He's a trained spy, and he trains spies to do the same. Unfortunately, because of that, he is someone who could potentially use this system to exaggerate how he felt. And it's a real problem. And Dr. Vincent admitted it. So you need to be really skeptical of that. So that's the first claim, which is about compensatory damages. The second is about punitive damages. And this is very different. And I submit to you, this is not a case, not even a close case, about whether punitive damages should apply. So first of all, you use a different standard for punitives than you use for the first one. It's clear and convincing evidence. And you're going to decide this in the first part, you're going to decide whether punitive damages are warranted. And if you decide they are, we're going to come back and do some more work, and you're going to have to decide what the number for punitive damages are. But I submit to you that there's no basis to find that punitive damages are warranted. And we're going to talk about that. Punitive damages are only awarded if you find by clear and convincing evidence that CNN acted with express malice and actual malice. And this is really important. Clear and convincing evidence differs from the greater weight of the evidence in that it is more compelling and persuasive. So with the first claim, whether CNN defamed Mr. Young, plaintiff has to prove that it's more likely than not. It's 50.1% to prevail. All of the burden's on them. But to prevail on punitive damages, they have to meet the clear and convincing bar. Clear and convincing evidence is evidence that's precise, explicit, lacking in confusion. And so it's a much higher bar. And plaintiffs simply can't get anywhere close to that. So there's two things you have to find to determine whether punitive damages are warranted. First, you have to find actual malice. Actual malice means that CNN either knew the statements were false or published them with reckless disregard. So that means that with Black Market, CNN knew at the time that Black Market didn't work for this story and published it anyway, or was reckless in doing so. Or it means with the other two stories that they knew that Mr. Young hadn't taken any money from Afghans and had done so anyway, even though they knew it, which also we'll get into in a second. And then express malice means that CNN acted with a primary motive to injure Zachary Young, had ill will, hostility, or evil intention. So let's talk about these really quickly. So actual malice means that CNN either knew the statements were false or entertained serious doubts as to their truth. There's no evidence in the record at all that CNN believed Black Market was false in the context of the story. Every single witness who talked about Black Market said that it was consistent with the story. And there's no evidence in the record at all, in all of those emails, that anyone thought that Black Market was inappropriate for the Afghan story. The evidence doesn't exist. You can't even get close to the clear and convincing burden that Mr. Young has to face. In fact, and when you talk about the other issue, about whether Mr. Young was preying on desperate Afghans by taking money from them, Kitty Bowe-Willis and Alex Marquardt tried to get more information from Mr. Young. They repeatedly asked him, show me the people you got out. Tell me people. They never had that information. So because they never had that information, they certainly couldn't know that the stories were false at the time they wrote them. So that tells you that Mr. Young can't even get close to the clear and convincing on actual malice. The other thing that you really need to look at is by using Mr. Young's own statements about meeting sponsors, they were telling the world, this is what he said. We don't want to report false information about you, so we're including his own statement to you. This shows there was no actual malice. This shows that CNN didn't know that the statements were false at the time they were reported. Express malice is something different, and this is the primary motive to injure Zachary Young. And for this, go look at the publications. There's no evidence that the primary intention was to injure Zachary Young or that there was ill will towards him. Look at the stories themselves. So look at the segment. They don't even talk about Zachary Young until the third minute of the TV story and the 20-something paragraph of the article. There's no spiteful B included in the segment of the story. There's no F off. There's no run for the border. There's no mercenary, etc. All that stuff's taken out. It's not in there. Most of it was never in there. If CNN was trying to harm Zachary Young, wouldn't that have been the content that they would have put in that story? Wouldn't the headline have been, mercenary tells people to F off, run for the border? That's what they would have done. But none of that is in the stories. Trust Emma Lacey Bordeaux. She reviewed the segment and she told you that she put herself in Mr. Young's position. She was trying to be fair. Again, if you were really trying to hurt Zachary Young, would you use his own statements about sponsors in the stories? Of course not. That made it clear, as he said in his own words, that he only took money from sponsors. And then finally, the correction. If CNN didn't care about Zachary Young, would they have told the world, we apologize? We shouldn't have used Black Market? Of course not. This is another instruction you're going to get. It's about corporate responsibility. Now, you all saw some text messages or slacks between various people in this case. And Mr. Friedman kind of took them out of context. But as you all saw through this trial, that when Katie Bowe-Willis or Mr. Marquardt wrote things about Mr. Young. It wasn't just they were writing them like, he's a terrible guy. Kitty Mulvilla said she was responding to the screenshots that Alex Marquardt sent. It was in context. Even Alex Marquardt's statement, we're going to nail this MFer, 2 lines later he says, or it'll slip away. It was an offhand comment that he immediately said, this is going to happen or this isn't going to happen. All of those things, though, were in response to what Mr. Young was saying. But to hold CNN responsible for those comments, you have to find that CNN was involved in it, knew about it, endorsed it. There's no evidence CNN did it. CNN had the triad process in place to make sure that the statements were fair, to make sure that the stories were accurate. And as you heard Mr. Levine and Emma Lacey Bordeaux, they never saw any signs of bias in the stories. So no corporate responsibility. Again, you heard my story on plaintiff destroying evidence. We think it's incredibly important, and it shows. And if we had that information in this case, all of it would have shown that Mr. Young was doing exactly what the stories repeated he was doing, which was talking to Afghans, giving them his prices. And if we had his communications, it would show that he had no reputational or economic harm. What did Mr. Young do? Actions speak louder than words. We're almost done. He deleted any messages or documents he thought he would hurt his case. And he told you this story that he did it because he thought the Austrian police would come after him. By this point, he had been living in Austria for like 15 years. And he claimed not to understand the law. But he never left Austria. If you thought the Austrian police were coming after you, wouldn't you just leave? Instead, he deleted that evidence. Actions speak louder than words. This case is all about reputation. It's all about reputation at the end of the day. And Mr. Young has brought forth no witnesses who will talk about his reputation. Actions speak louder than words. Now, if you decide that Mr. Young has met his burden of establishing defamation, you can award him economic damages. But Mr. Bolko's analysis is bogus. $21 million is pure speculation. So that's the number. $280,000 was the number that he made in 2021. Even if he made that same amount for the next 10 years, that's $2.8 million. If he made that for the next 20 years, that's $5.6 million. If he made that for the next 30 years, that's $8.4 million. There's simply no way you can get to Mr. Bolko's analysis without just throwing up your hands and saying, okay, let's guess. Because that's essentially what Mr. Bolko did. You heard Mr. Buss testify, who's done this for a very long time, that Mr. Bolko's assumptions made no sense. On top of that, you know that you can reduce the amount of money that you award to Mr. Young by the fact that he failed to seek comparable employment. And that instruction, Mr. Young, that instruction is in the book that the court will give you. You heard Mr. Humphreys testify that Mr. Young would be qualified for a bunch of jobs, offering a salary between $150,000 and $300,000. Humphreys testified that Young didn't even need a security clearance for Amentum. And you saw how much he made when he was working for Amentum. Mr. Young admits he made no calls to obtain work. And there's no evidence in the record that Mr. Young cannot work. So if you decide that Mr. Young does have economic damages, you can reduce that number by $150,000 to $300,000 a year. Because that's what Mr. Young could have made had he gone out and sought work. So I'm almost wrapping up. But I know that throughout this trial, we've talked about CNN. CNN's a corporation. And I know a lot of people don't have love for corporations. They're kind of heartless. You can't put your arms around them. But CNN isn't just a corporation. In this case, it's Alex Marquardt. It's Emma Lacey Bordeaux. It's Adam Levine. It's Tom Blumley. It's Katie Bo Lillis. It's Fuzz Hogan. And why does that matter? It matters because your decision just doesn't impact CNN. It impacts these people. All of these people, whether you like them, you love them, you hated them, they were trying to do their level best. And if you determine that there's defamation here, it impacts these people. It just doesn't impact CNN. They'll wear that Scarlet D.
And you have 15.
Oh, thank you. These are people who are trying to do their level best. So this isn't just about CNN. It's about these hardworking people who came and testified to you what they thought, what they were trying to do. They all testified. They didn't hate Mr. Young. They were publishing a story that they thought was important. A story about Afghans. A story about the Biden administration falling down. This isn't just about a nameless corporation. It's about 6 people, even more, who are trying to do the right thing. And I submit to you that they did do the right thing. So, I'm going to say, I have 2 last words. You all, I'm sure, have friends, spouses, family members, and we all at times get into arguments with those people. And when we get into arguments with those people, we always want to have the last word. Because when you have the last word, you can make the last argument. It's the best argument. You can respond to everything. In this case, I don't get to have the last word. Plaintiff brings this case, so they get to come up and talk to you last after I sit down. So I don't get to speak to you again. But what I'd ask you to do is if you hear something that doesn't make sense to you, if it doesn't ring with your common sense, ask yourself, what would CNN's lawyers tell you if they had the last word? If Mr. Friedman says something that just isn't quite right, doesn't make sense given the evidence, ask yourself, didn't we see something before? Is there something else that Mr. Axelrod and his team would have shown to us? You all know the record really well. You've been incredibly diligent in this case. So ask yourself, what would we have said if we got to say the last word? Finally, lawyers can get very excited during trials. It's stressful, it's emotional. They want to win, we want to win. Sometimes I irritate myself. A lot of times I irritate my wife. If I did anything at this point to irritate you during this trial, take it out on me. Don't take it out on my client. Because you all have seen all the evidence. We know you're going to do a really comprehensive job of looking at all the evidence and using your common sense. And of course, as Honor is going to tell you, sympathy, those types of feelings shouldn't come into your deliberations. So if I annoyed you, I'm sorry. Don't take it on my client. I'm going to end where I started. This case is really about 3 things from our perspective. The segment and the article were true. Read them. Look at them. Look at the way they describe Zachary Young. Look at the way they use his own words. There's nothing false in the stories. They used his own words multiple times, even the quotes he gave to CNN. Second, there's no defamation. There's simply no evidence in front of you for you to find that Mr. Young was defamed by CNN. Doesn't exist. And then third, there's no reputational harm. You have no evidence of Mr. Young's reputational harm besides what he told you beforehand, and you have no evidence of Mr. Young's reputational harm afterwards. The only thing you know from a reputational perspective is that 1 month after the CNN publications, Helios was willing to affiliate with him. That's it. So, when you look at this case, when you go through all the documents, when you look at all the witnesses, when you all sit together and apply your common sense, you say, where's the evidence? you can really only reach one conclusion, and that's that CNN did not defame Zachary Young either by per se or defamation by implication. You certainly will find that there is no reason to come back again and talk about punitive damages. This case is about the truth of this case. It's not about sending a message. Thank you all for your time.
Mr. Friedman, rebuttal argument?
Sure.
And you got 13 left, so 242.
Sounds good. Can't believe I'm saying this, but I agree with CNN's lawyers. Use your common sense. Think about that for a second. Use your common sense, but ignore the fact that CNN's lawyers knew black market meant illegality and therefore made the corporation apologize immediately. Use your common sense, but ignore all the pre-litigation admissions they made before they were here to see you guys. Use your common sense, but ignore 7 witnesses all testifying to a uniform non-dictionary definition of an English language. Use your common sense, but you need lines of witnesses to tell you what the words in English mean, and we're at fault for not bringing you a line of people to tell you what English means. Use your common sense, but don't rely on a dictionary. Use your common sense, but ignore a 2-star general. Use your common sense, but trust Mr. Axelrod instead of the only psychiatrist you heard from in the entire trial. Use your common sense, but ignore the fact that CNN had no doctor come tell you that Mr. Young's mental health issues were fake. You only had a lawyer telling you that. Use your common sense, ignore the fact that the Helios contract had no money exchange. You have all of his bank records in there in evidence, but you can bet your bottom dollar if there was a payment from Helios, they would have showed it to you because they have them too. Use your common sense, but ignore that. Use your common sense, but trust CNN's expert who has no opinion on whether all the efforts of updating, linking, and going on Monster.com will actually work. He says no opinion on whether it'll actually work. Use your common sense, but ignore the fact that the 2-star general told you it wouldn't work. Use your common sense, but ignore the fact that the CPA came up and calculated what lost profits are. Use your common sense, but trust the lawyer who can't do math without a calculator. Use your common sense, but trust our expert who isn't giving an opinion on any money at all, right? Mr. Buss didn't offer opinion on damages. Use your common sense, but trust witnesses. But use your common sense, but think about this. CNN had the compulsory power to bring witnesses here too. Mr. Young told you why he didn't bring his network of people. They're quiet professionals. His life and reputation has been ruined by being forced into the limelight like this. So what Mr. Axelrod is saying is he should have pulled all of his friends and used this court's compulsory power to bring them here, broadcast them across the internet, and destroy their careers too. Now, to be clear, CNN could have brought you those people. You think it's hard to find Leon Panetta? You think it's hard to find Mike Morrell? They had compulsory power. They didn't bring them. Ask yourself, use your common sense. If Leon Panetta was going to say bad things about Mr. Young, if Mike Morrell was going to say bad things about Mr. Young, why didn't CNN bring him? We told you why we didn't bring him. It makes sense. He's not going to ruin their careers too. We don't need it. We have all the receipts. Use your common sense, he says, tell you to bring all these witnesses to tell you what English means, what words mean, when we have all of their internal documents. So use your common sense, but ignore the fact that this man was making hundreds of thousands of dollars a year, year after year after year. The CNN broadcast comes out and his income goes to zero. It's undisputed. Use your common sense, but they're not responsible for it. Use your common sense, but assume that lost LinkedIn messages were relevant to this case when the court has told you he did nothing illegal, and you have to decide whether he did something illegal and whether black market means anything illegal. Use your common sense, but ignore. But lost LinkedIn messages make a difference when what you're looking at is what CNN published, not what he said. We know that he did not
take money from Afghans because the court told you that. So, yes, use your common sense. Use your common sense, but trust the liar Alexander Marquardt on the stand, who lied to us over and over and over. Use your common sense, but ignore the fact that Fuzz Hogan, one of CNN's triad members, told you he approved a story that was 3/4 true. Use your common sense, he says, but let this madness continue. Use your common sense, but ignore the fact that the explanation for the issues with the Austrian medical records is translation issues. Use your common sense, but ignore the fact that Dr. Vincent told you that he's unconcerned about it because it's a translation issue. So please, use your common sense. I wanted to touch on some other things that Mr. Axelrod talked about. Mr. Young isn't running from responsibility. He absolutely advertised to Afghans as a technical matter. But he's explained why that was. It's just a public post on the internet. The court found as a technical matter he did advertise to Afghans. That's true. That's not his target audience. We've covered that. Mr. Axelrod told you that Mr. Young's advertisements were so large that Katie Bolillis found him. But Katie Bolillis testified that she and Mr. Young had connections in common. You know how social networks work. The fact that you have shared connections means your post will get posted to the friends of your friends. It wasn't that he was so prolific, it was that they were connected. You know, Mr. Axelrod talked about how it is about choices. He says Zachary Young could have chosen to speak to CNN, could have spoken, could have chosen to talk to them. But again, this is this guilty until proven innocent. Mr. Young had no obligation to talk to CNN. You know who had an obligation? CNN had an obligation not to go to press with falsehoods and lies and defamation. They're the news agency that broadcasts into 70 million homes. They're the ones with the responsibility, not us. If they couldn't confirm their story, they can't go to press. They can't then just pass the buck and say, oh, he could have corrected us if he wanted to. Mr. Young is not on trial here for running a profitable business from corporations that were happy to pay. CNN is on trial here because they published falsehoods and destroyed a man's life. I wanted to hit on something else, this idea that Mr. Young isn't mentioned until 3 minutes into the video. Mr. Axelrod hangs his hat on it like it's a big deal, but anybody who knows how to tell a story, you build up for a suspense. I mean, think about the punchline of a joke. It's the last word of the joke, but it is the entire point of the joke. It doesn't matter where in time Mr. Young appears. It matters. The substance is what matters. And he was the punchline of this joke. You know, Mr. Axelrod talked about how Nicole Guyette, the internal reporter who said the inference running through this thing is really not fair. So that was an early version. But remember when I had Thomas Lumley on the stand, Mr. Axelrod put up a page that had a lot of red ink on it. And we zoomed in on that. We went through each and every edit. That story didn't really change. In fact, it got worse. They put in worse things into that story. And Mr. Axelrod says that this case isn't about sending a message. That's not true. If that were true, the law wouldn't allow you to award punitive damages. It does, and it does for a reason. Because there are times when companies like this need to be told to stop. And there's one way to get to a company like this, and it's to follow the money. That is the way you change the behavior of a company. You tell them that when they do something wrong, we will take it out of your bank account. When you do that, you send a message. And that's why punitive damages are here, to help you punish and to deter. When my child does something wrong, you need to punish them to stop them from doing that in the future. You send a message. This case is about sending a message. If it wasn't, you wouldn't have a packed courtroom. You wouldn't have the press in the back. CNN wouldn't be monitoring this case to see what you do. It is about sending a message. Make no mistake. It's about making him right. He suffered wrongfully, and he shouldn't have, economically and emotionally. But it's also about sending a message. And we ask you to send that message loud and clear. End this madness. Bring American journalism back to the center. Bring Walter Cronkite back. We used to turn on our news and we could rely on what was there. We can't anymore. You have the ability to fix it. You have the ability to send a message. Please do it.
All right, members of the jury, you have now heard all the evidence, my instructions on the law that you must apply in reaching your verdict, and the closing arguments of the attorneys. You will shortly retire to the jury room to decide this case. Before you do so, I have a few last instructions for you. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You will have in the jury room all the evidence that was received during the trial. In reaching your decision, do not do any research on your own or as a group. Do not use dictionaries, other than the ones admitted into evidence in this case, the internet, or any other reference materials. Do not investigate the case or conduct any experiments. Do not visit or view the scene of any event involved in this case or look at maps or pictures on the internet. If you happen to pass by the scene, do not stop or investigate. All jurors must see and hear the same evidence at the same time. Do not read, listen to, or watch any news accounts of this trial. You are not to communicate with any person outside the jury room about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you, such as a family accountant, doctor, or lawyer. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Any notes you have taken during the trial may be taken to the jury room for use during your discussions. Your notes are simply an aid to your own memory, and neither your notes nor those of any other juror are binding or conclusive. Your notes are not a substitute for your own memory or that of other jurors. Instead, your verdict must result from the collective memory and judgment of all jurors based on the evidence and testimony presented during the trial. At the conclusion of the trial, the bailiff will collect your notes, which will be immediately destroyed. No one will ever read your notes. In reaching your verdict, do not let bias, sympathy, prejudice, public opinion, or any other sentiment for or against any party influence your decision. Your verdict must be based on the evidence that has been received and the law on which I have instructed you. Reaching a verdict is exclusively your job. I cannot participate in that decision in any way, and you should not guess what I think your verdict should be from something I may have said or done. You should not think that I prefer one verdict over another. Therefore, in reaching your verdict, you should not consider anything that I have said or done except for my specific instructions to you. Pay careful attention to all the instructions that I gave you, for that is the law that you must follow. You will have a copy of my instructions with you when you go to the jury room to deliberate. All of the instructions are important, and you must consider all of them together. There are no other laws that apply to this case, and even if you don't agree with these laws, you must use them in reaching your decision in this case. When you go to the jury room, the first thing you should do is choose a presiding juror to act as a foreperson for your deliberations. The foreperson should see to it that your discussions are orderly and that everyone has a fair chance to be heard. It is your duty to talk with one another in the jury room and to consider the views of all the jurors. Each of you must decide the case for yourself, but only after you've considered the evidence with the other members of the jury. Feel free to change your mind if you are convinced that your position should be different. You should all try to agree, but do not give up your honest beliefs just because the others think differently. Keep an open mind so that you and your fellow jurors can easily share ideas about the case. I will give you a verdict form with questions you must answer. I've already instructed you on the law that you are to use in answering these questions. You must follow my instructions and the form carefully. You must consider each question separately. Please answer the questions in the order they appear. After you answer a question, the form tells you what to do next. And I will now read the verdict form to you. It's 2 pages long. At the top of the case, at the top of the first page, it has what we call the style of the case, which says in the Circuit Court of the 14th Judicial Circuit in and for Bay County, Florida, Zachary Young plaintiff versus Cable News Network Inc. defendant, case number 03-2022-CA-000608. And it says verdict form. Number 1, do you find by the greater weight of the evidence that defendant CNN committed defamation per se against plaintiff Zachary Young? Question mark. And underneath there are 2 lines, either yes or no for you to check. And underneath that it says, please answer question 2. 2, do you find by the greater weight of the evidence that defendant CNN committed defamation by implication against plaintiff Zachary Young? And again, 2 lines underneath there for yes or no for you to check one or the other. Then under that it has an instruction. If your answers to questions 1 and 2 are no, just sign and date the verdict at the bottom and return it to the courtroom. If you answered yes to either question 1 or question 2, answer questions 3 and 4. And under that, number 3, what is the total amount of plaintiff Zachary Young's damages for both lost earnings in the past and for the loss of his earning capacity in the future, reduced by the amount that plaintiff could have earned from comparable employment? And underneath there's a $ with a line blank. Question 4 on the second page, what is the total amount of plaintiff Zachary Young's damages for pain and suffering, mental anguish, inconvenience, injury to reputation, and loss of capacity for the enjoyment of life that he sustained in the past and that he has sustained in the future? And underneath that, there's a $ with a line. And underneath that, it has an instruction. Please answer question 5. 5, do you find by clear and convincing evidence that punitive damages are warranted against defendant CNN? Question mark. And then underneath that, there's 2 blanks for either yes or no to be checked. And underneath there's an instruction that says, please date and sign the verdict at the bottom and return it to the courtroom. It says dated with a blank for you to fill in the date and a signature line for the foreperson. Your verdict must be unanimous. That is, your verdict must be agreed to by each of you. When you have agreed on your verdict, your foreperson must write the date and sign it at the bottom and return the verdict to the bailiff. If any of you need to communicate with me for any reason, write a note and give it to the bailiff. In your note, do not disclose any vote or split. Any other instructions from the plaintiffs at this point?
No, Your Honor.
Defense?
No, Your Honor.
All right, at this point in time, you may now retire to decide your verdict. We're going to get the evidence binders and everything put back there for you in a moment. And we'll give you copies of the jury instructions and the verdict form to go back there with you. However, Ms. Densick, you're going to remain here with me, or with the rest of us. Okay? So you're not going to retire back to the jury deliberation room. You can take your notes with you. However, if you do have cell phones, you need to leave them here in the courtroom. The bailiff will take a hold of those and give them back to you after we get a verdict in the case. Any questions for the other 6 of y'all? Yeah, what that is.
Do we have water in here, or do I need to go back to the jury lounge to get water?
Yeah, we'll get some water brought back there. The bailiff will bring that back to you. And I know one of y'all had part of your lunch that you didn't get to eat. We'll get that brought back for you as well. She knows where that is from the jury lounge. And I guess if there's, I don't know if there's some snacks or whatever, but we'll round some of that up and get that brought back for you. Okay? There is also a restroom back there in the deliberation room. So if we've been going now for 2 hours or so since we came back, so if you need that, that'll be back there. All right? But otherwise, we'll have you retire to deliberate. All right, jurors are out of the courtroom. Gary, can we address y'all be seated, sorry. Can we address my boo-boo a moment ago, like we did the other ones? All right, let me deal with you were our alternate juror in this case. As we saw what happened on Monday, alternate jurors are important, especially when we have a trial like this that lasts more than just a couple of days. So obviously you served a very valuable role of being here in case somebody else got sick or something happened. At this point in time, you are released from your jury service. I have one instruction. We always have instructions on everything, and I'll read that to you in just a moment. But I'm just going to tell you that you can stay, see what the outcome is. Otherwise, you would be free to go. Your notes, my bailiff will take those and destroy those. To answer your question, yes. All right, ma'am. Some of this may not 100% apply because you didn't participate in deliberations, but obviously your impressions of, and opinions of the evidence and testimony in this case, it would be applicable here. But on behalf of the parties, the lawyers, and the people of the state of Florida, I want to thank you for your time and consideration in this case. And obviously, you spent the better part of 2 weeks here with us, and we know how valuable your time is that you took away from the rest of your life and what you have on a daily basis going on. I want to advise you of some special privileges you do enjoy as a juror. No juror can be required to talk about, and this doesn't necessarily apply to the first part here, about the discussions that occurred in the jury room except by court order. By the same token, whatever your mental impressions were of the evidence and testimony, the arguments in this case, no one can compel you to disclose those except by court order. For many centuries, our societies relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about your jury work. The lawyers and their representatives are not permitted to initiate any communication with you about the trial. However, you may speak to the lawyers or anyone else about the trial. You also have the right to refuse to speak with anyone. A request may come from those who are simply curious or from those who might seek to find fault with you. It will be up to you to decide whether to preserve your privacy as a juror. But I do want to, I know this is always the worst part for me to tell someone they're the alternate, and after they've given their time and attention and paid such close attention, especially with the amount of time we've been in trial here, I always feel bad to say, hey, you're not going to go back there and deliberate. But like I said, at this point in time, you're discharged from your service as a juror. You will get from the clerk a get out of jury service card, such that if you do get summoned in the next year, you can contact the clerk's office and just say, hey, I served in January of 2025, and I shouldn't be back or called back, and I should be excused at this point. So you do get at least that souvenir. Your juror tag, unfortunately, I can't give you as a souvenir. But you got any questions?
I do not.
All right. Well, again, I do appreciate it, and I always hate this part of the trial of telling an alternate juror they're not going to go back and deliberate. And as I said, you're free to go. You can hang out. It's entirely up to you, as well as whether you want to tell anybody or talk about it. And with friends and family, you're more than free to talk with them about you are discharged from all those instructions I gave you at every break we took in this case. All right?
Thank you.
I appreciate it. Thank you, ma'am.
Yes.
Yeah, why don't y'all come up and just flip through the binders that are back there, because we need to get that back to them. I've got the verdict form and the 6 sets of instructions that are going to go back with them. Joe? The jurors would like to watch the CNN broadcast again. So.
Which one?
Maybe we'll have to ask that question when they come back. All right, so we'll bring them back out. And who wants to volunteer to cue it? Well, I guess we got to ask which. I'm presuming it's the main segment, but we'll ask that question. But who's willing to cue that up? You volunteered? Thanks. All right, we'll get the jurors back in. Here you go. For you. What?
Jurors entering?
Right there.
We're supposed to bring our notepads.
Well, if you wanted to take notes, you could. Okay. Does anybody need their notepad that didn't bring it?
Or are we watching the video now? Okay.
Yeah, y'all be seated. I understand y'all wanted to watch the video.
Yes.
And I guess the question I had was which one? The main
segment.
The main segment? Okay.
What? Second. Which segment?
I said the video segment.
Oh, the main event, yes.
You know where they want to start?
You want to watch the whole segment, right?
Because it starts as a commercial. Do we want to skip commercials before commercials?
Do the lead in also.
Before the commercial?
Teasers?
The teasers, whatever it's
Just
called.
cut the commercial.
So start the meeting.
Desperate Afghans still trying to escape the country, being preyed on by folks demanding that they pay up big time to get out. They say they will help Afghans escape the country, but only for a price, a steep price. How desperate Afghans are being preyed upon. That's next. In our worldly today, the U.S. government, the Biden administration, says that as of last week, it had assisted in the departure of at least 377 U.S. citizens and 279 lawful permanent residents of the U.S. from Afghanistan since August 31st. Still, many Afghans who desperately want to flee Taliban rule, and Afghans who say their lives are at stake, they remain behind, as CNN's Alex Marquardt has discovered. Afghans trying to get out of the country face a black market full of promises, demands of exorbitant fees, and no guarantee of safety or success.
These are the heavy steps of a young man trying to save his family. He's just 26 years old and lives in California. We can't show his face for the safety of his family in Afghanistan.
I'm desperate, the danger is imminent.
Since the chaotic international withdrawal from Afghanistan, his parents, siblings, and wife have been in hiding from the Taliban, who in the past, the young man says, have violently beaten his father, a doctor, and been angry with his mother, a women's rights activist who worked for the U.S.
Taliban left announcement to my parents that anybody who helped them find my parents or my family that ends up with their execution will gain a prize.
They put a bounty on your family's head.
Exactly. This is really serious. They went to our house. They destroyed every single thing.
Desperate, he turned to Facebook, finding people offering ways to get Afghans out of the country for a price.
That person came up to me and told me, hey, you know what, you got to pay $10,000 per person in order to be evacuated then.
Per person?
9, 10 people. It would be like $100,000, and I cannot provide $100,000 in cash. In a way, like even if I provide that money, there is no guarantee that they will be evacuated.
According to Afghans and activists we've spoken with, desperate Afghans are now being exploited, like that young man, told that they can get them or their families out if they pay exorbitant, often impossible amounts.
For only one family, $50,000?
We Skyped with a father of 3 in Kabul who had just met with a man offering to get them on an evacuation flight list.
You want to leave the country? If you say yes, they're going to say, okay, pay first. I said, how we can pay that much money right now? It's only business matters. People are making $100,000 per day.
This man, whose identity we also need to hide, worked as a contractor for USAID. He's a special interest visa applicant for the U.S. The kind of Afghan citizen the Biden administration says they're working to evacuate. What is the U.S. doing that you know of to try to get you and your family out?
Unfortunately, they are not doing now anything. Up to 31st, they said everything is closed and it's finished. We did not receive anything back from the U.S. Embassy or from any other organization.
So he went online, where he found a man named Zachary Young, who is one of many advertising evacuations from Afghanistan, posting just this week, "We can deliver." One LinkedIn user posted messages with Young, where Young said it would be $75,000 for a car to Pakistan. He told another it would be $14,500 per person to get to the United Arab Emirates, or Albania for another $4,000. Prices well beyond the reach of most Afghans. We got Young's number and called, but he didn't pick up. In a text message, he told CNN that Afghans trying to leave are expected to have sponsors pay for them. If someone reaches out, we need to understand if they have a sponsor behind them to be able to pay evacuation costs, which Young says are highly volatile and based on environmental realities. Young repeatedly declined to break down the costs or say if he's making money. Back in California, the young Afghan American tells us even though he can't pay, he's still pleading to get his family out.
I have sent tons of texts asking these people, begging them to evacuate my family. If I don't be able to evacuate them within the next 2 weeks, I think I will lose them all. I think I will lose them all, my family.
And just moments ago, that young man told me that the Taliban has now issued summons for his family in hiding, indicating his father believes that the Taliban really is after them. Now, the Biden administration continues to work on evacuating people, but as you can see there are just so many more Afghans who want to get out of the country, and that just drives prices higher and higher. In another message, that person offering those evacuations, Zachary Young, he wrote, "Availability is extremely limited and demand is high." Jake, he goes on to say, that's how economics works, unfortunately.
Unfortunately. Alex Marquardt, thanks so much for that important report.
That what y'all want?
That's all.
All right.
Thank you very much.
I'll have the jurors go back to retire to deliberate or continue deliberations. All right. Y'all be seated. Jurors are out of the courtroom. Anything else we need to talk about on the record?
Not from plaintiff.
All right. We'll go off the record. All right, so y'all been working on the phase 2 jury instructions, and at what stage do we have a disagreement?
So if we can, I handed the court the defendant's proposed instructions. By agreement, we're going to work off of those. We're in agreement as to instruction number 1, Your Honor. Is that right?
That's
correct.
All right.
As to instruction number 2, we're in agreement to cut the last sentence, which starts with "you should impose punitive damages only." All right. We are in disagreement. The plaintiff would like to cut little I and little double I, whether the wrongful conduct was motivated solely by unreasonable financial gain, whether the unreasonably dangerous nature of the conduct, together with the high likelihood of injury resulting from the conduct, was actually known to the defendant. Your Honor, those come out of the standard jury instructions. It's actually not what's reflected here. It's 503 C2. The plaintiff would like to cut those, and the defendant would like to stay with the standard jury instruction.
Is there supposed to be, between each of the little Roman numeral I's, I1, I2, or 1I, 2I, 3I, and then also between A and B, there is an and at the end of 3, so I guess you need A and B, but is there supposed to be an and or an or between 1I, 2 I's, and 3 I's?
If I may, Your Honor?
There is not, according to my...
Yeah, I don't think there is. The purpose of this relates to the statutory caps on punitive damages. So, I and double I kind of go together. If you get both of those findings, it increases the cap from 3x to 4x. And then the third finding stands alone, and that's the specific intent finding, and then that lifts the cap entirely. So we don't think, on the facts of this case, that the first two findings are really applicable, and we're waiving our opportunity to lift the cap from 3x to 4x by taking them out of the instruction. So we're not really sure how defendant is prejudiced by the modification, but we just don't think it's very applicable to the facts of the case.
All right, Mr. Tobin, and y'all can keep your seats. I appreciate it. I can see. Yeah, I'll sit up. Yes.
We'll both do that. Your Honor, they're in the instructions for a reason, for fairness and balance, if I can coin a term, for the parties' benefit, both parties' benefit. We think that they do speak to some of the arguments made specifically in this case, and so we would be uncomfortable taking them out. We think it would be prejudicial.
Do you agree that the only reason for 1 and 2 are because of changing a cap number under the statute, or?
I haven't really looked into that, Your Honor, so I'm not comfortable speaking to that.
What's the State Farm case talk about? I mean, or is that just cited at the end of the standard instruction?
I believe that's right, Your Honor.
Okay.
But really, it is just a copy of what's in the jury instruction.
Okay. All right. Let me go look at that issue to see if those are only in there for a cap reason, or if there's something else that the case law talks about.
We do think that it speaks to some of the issues that plaintiff has raised in the arguments Mr. Friedman made to the jury.
Right. Okay. All right. Any other differences?
Yes, Your Honor. We would like to give the court to give instruction number 3. Plaintiffs do not want that instruction given. And our authority for that is Philip Morris versus Williams, which is out of the U.S. Supreme Court. The site is 549 U.S. 346. And the proposition in that case, it was a case out of Oregon, but of course the Supreme Court took it on constitutional grounds. And the issue was whether the argument of counsel to punish the defendant for having caused injury to others warranted an instruction like we put in number 3. And here, obviously, they've argued both that and the converse. Send CNN a message not to do this again, to punish others, and send the mainstream media a message not to punish others. And so we think that in this instance, this is almost like a curative or a limiting instruction based on the way Mr. Friedman has argued the case to the jury, and that it's necessary to make clear that they're punishing CNN if they're going to award punitive damages for CNN's conduct.
I know that the normal boundaries of it is to punish them for this and also deter others from doing it. Is the only, in the first sentence, kind of misplaced, potentially, where it should be to punish only the defendant for the specific conduct you've...
That's a good edit, Your Honor, yes. Thank you.
Because, I mean, it's supposed to have some deterrent effect to others, but you're not being punished for what others did.
Right.
But it should have a deterrent effect. I mean, I don't know. That may, this is a first read through, so I'm just spitballing here because, I mean, there is a deterrent effect on others by what happens to CNN, but
not for the conduct of the mainstream.
But not for conduct of others, right? Yeah.
Which was the argument Mr. Friedman made.
Your Honor, I think that the standard instruction captures what the kind of boundaries of what punitive damages are supposed to do which is punish the defendant and serve as a deterrent to the defendant and others. I think that the case here, Philip Morris, is just not very on point. In that case, you had closing argument where it's like, think about all the non-party smokers who Philip Morris has hurt. You should punish them for hurting these non-parties to the case, right? And I think Mr. Friedman's argument just went to the proper deterrent purpose of punitive damages, which is you should send a message to the media that they shouldn't do things like this. It's not saying you should punish CNN for things CNN did to other people. It's not saying you should punish CNN for things that the mainstream media did to other people or did a defendant. It's just saying you should punish CNN to send a deterrent message to other media companies as well as CNN. And so I haven't read the case in enough detail. I know that in a lot of the tobacco litigation, you also have a phenomenon where you have expert witness come in and talk about like a whole history of the tobacco industry and kind of how terrible it is and like all the people that it's hurt. And so it makes sense, I think, in that context to be more aggressive in giving an instruction like this and telling the jury what the bounds of what they consider and not consider. But in this case, we don't have any evidence that plaintiffs have put in trying to argue about other people being hurt by CNN. We don't have any evidence we put in about misconduct by other media companies. So I just think that it creates a greater risk of confusion than it does of solving anything.
Your Honor, the argument I heard was the mainstream media is out of control. This is your chance to reset the clock, reset the mainstream media. And so it was a direct invitation to the jury to look beyond the defendant's conduct. And this instruction will hopefully cue that back in.
Yeah, and I don't disagree to some extent of Mr. Delitz's argument about how the tobacco industry worked and that type of thing. And maybe media does too. I don't know, but I think there's a lesser of an argument just because of the nature of how they were processing tobacco and those sorts of things. But I think it kind of gets to. I understand the argument based on what Mr. Friedman said, and let me look at the tobacco case, and maybe more of the wording that we have here would need to be tweaked a little bit along the lines like what I'm saying is, CNN's being punished here, even though it's sending a deterrent message to others. But CNN shouldn't be paying for what any other media did for any other occasion or for any other instance other than as it relates to this segment in the article with Mr. Young. So maybe more of a matter of reworking to get to what you're suggesting within the bounds of, you know, the understanding this is different than the Philip Morris situation, but let me look at the case and see if there's a way that it fitting in with the arguments being made that we're correctly advising them what they're supposed to be doing here.
Thank you. And then we are in disagreement as to whether we would like the court to give instruction number 4, and that's just the reasonable relationship, the proportionality instruction. Usually that's dealt with on appeal. I recognize that, Your Honor. But we think it would be helpful and save a lot of work and give proper guidance if we have it in the actual instructions.
All right, and plaintiff's objection to number 4?
Yes, we do, Your Honor.
Okay.
And then we have I'm sorry.
And what's the basis of the objection?
I mean, it's not in the standard instructions for one, and we favor the standard instructions here. But I also don't think, you know, punitives are harder for a jury in some ways. I mean, we're going to have a financial expert in here to kind of talk about the resources available to CNN, its ability to pay. You know, I think the standard instruction talks about financial destruction of CNN, and I think, you know, in terms of the jury trying to figure out what is, you know, what they need to be trying to figure out is what's an amount that's going to be an effective deterrent without and an effective punishment without financially destroying CNN. And I think, you know, as Mr. Tobin said, this is usually handled not by the jury, but on appeal or, you know, maybe on a remitter motion. And it just seems to introduce an extra consideration for the jury that I don't think is really appropriate in the phase 2 of the punitive damages.
It is the law, Your Honor, and Mr. Friedman in voir dire planted suggestions of $100 billion, $10 billion, and we think that there's no harm in giving the instruction, no prejudice. In the light of the arguments made, it's appropriate.
Okay. That Engel case, that was, obviously it's an appeal, but
Florida Supreme Court.
Yeah, what were they dealing with?
Also proportionality in the tobacco.
Did they have any suggestion of how it should be addressed on the proportionality aspect of it?
Your Honor, I read the case 2 weeks ago, and I don't.
You don't have a vivid, acute recollection of it?
In the 10 minutes it took me to walk back and forth.
All right, let me look at Engel.
Can I just add one more thing here? I mean, I think reasonableness, you know, when we're talking about negligence and things like that in an ordinary person, I think that's really usually understandable to the average juror. Asking a juror to understand what a reasonable relationship of a punitive reward to compensatory, I don't know that anybody's going to have the experience to make an assessment like that. I mean, I don't know. Would we advise them on what constitutes reasonable in the context of punitive damages? I mean, I'm just not sure the average person has a frame of reference to make, really make use of this instruction.
No, reasonable is already all over the instructions, Your Honor. I don't think it really takes it any deeper than they're already going.
So to quote Mr. Axelrod, context matters. You know, I think it's a little different in this instruction.
We finally got you to agree to that, Mr. Dillon.
Can you make a common sense argument too out of this? All right, let me look at Engel. My initial inclination is a little bit that this is reading like a remitter type of motion, but let me see in the context that they were talking about. Is that a consideration to throw to the jury in deliberating the number, or is that for the court to look at, kind of post-trial sort of issue? But I'll look at that Engel case. All right, any other disagreements? Everything else good?
From the defendant?
Nothing on the instructions. I think we have one issue to clear up on the verdict form.
One question? Or do we have two?
Your Honor,
plaintiffs want two?
The plaintiffs want two.
You have a copy of Because I got defense one, but I'd left it downstairs.
Colleen, I did not print that out.
I think the issue here is just, we just want to make sure we get it right, Your Honor, and that we don't, do anything wrong in putting this together. And I think in looking at the model instruction, it has another, after the amount, it has the other component where it says by law you have to make following finding about whether there was specific intent. Frankly, we're not opposed to taking that off the verdict form and agreeing with defendants as long as it's consented to and we don't have any risk of error. I mean, in our view, and I think I don't want to speak for him, but I understand Mr. Tobin to agree, it's fairly redundant of the determination the jury is deliberating on right now in terms of deciding entitlement. So we're not really sure the purpose of it, but it comes from, I believe, the model instruction.
The standard.
Yeah, the standard verdict form is why we have that on there. But frankly, we're not opposed to removing it.
All right,
It consents to removing it.
Okay, so the defense proposed one just had a question is what is the total amount, if any, of punitive damages which you find by the greater weight of evidence should be assessed? What was the other question or interrogatory you had listed on yours?
Yeah, the other one was, did defendant have a specific intent to harm plaintiff, and did defendant's conduct harm plaintiff?
Okay.
So if we're on the record that the parties consent to remove the second one, we're fine with the defense version of the verdict form.
All right. You're not
seeing it as an agreement with what Mr. Delich just proposed.
Okay. Wait, of adding the second question, or that you guys are stipulating to one question that you aren't making an issue that
we are stipulating to one question.
Yes, Your Honor. Just
okay.
one question.
Okay. Just wanted to be somewhat clear on that stipulation.
Better safe than sorry.
Okay. All right, so we'll go with the one question, phase 2 verdict that defense had proposed. And let me go look at these cases on these couple other instructions. And I'll let you know what my thoughts are. All right.
Thank you, Your Honor.
Anything else we need to do on the record?
Not for plaintiff, Your Honor.
Not for the defendant.
All right. We'll be off the record.
Welcome.
Y'all see. No, actually, it says, may we stop for today. No, you can't leave until you're done. If they were to come back and we have to have phase 2, how long is, I mean, the instructions are fairly short, so I'm not going to be reading instructions for a half hour, the good part. How much evidence are you going to have to put on?
I think we'd have an expert witness. In all honesty, I don't know exactly how long, but I would guess maybe an hour or less. And then I think we would probably want to play some deposition testimony from Mr. Cohn. But we would probably have to figure that out and exchange objections and resolve them, I think, before we could play it, I assume. But hopefully that wouldn't take too long. And I wouldn't imagine we'd be playing a ton of it, but we would definitely want to play some of Mr. Cohn's deposition as well as call our expert.
I think the bigger issue is, last Friday I was willing to go out, but given what would be going on, we'd have to stop at like 4:30 or so. So we're going to run out of time real fast.
That's what I guess you need to call them in and say, or I guess the better option is to call them in and see if one of them really has an issue that they need to leave for. The problem is if they come back in the morning, start right after 8 o'clock, or as soon as we can get in the courtroom, they can get in the courthouse and get up here. We don't know how long they might be out, which then starts to push us back, even though the instructions are short. You say maybe an hour and some videos, so I'll say an hour and a half, and cross, and then I add the lawyer/contractor multiplier of double that. We're probably talking about 3 hours potentially. And then y'all got to do argument, which I guess we really hadn't talked about how long y'all want a closing argument on that. But obviously it's going to be a lot shorter, but I think probably 20 minutes, 30 minutes at worst.
Sounds right.
But that's another almost hour.
Probably openings too, right? Short also.
5 minutes.
That might be a bit short.
I don't know. Y'all put on any evidence or testimony, or
Your Honor, we have one expert witness.
you have one? How long would yours be?
Guessing an hour total.
Yeah.
That includes direct and cross. But I don't know how long the cross is. But
Yeah. So we're getting over. Add the closings and openings and 2 witnesses and the videos. We're talking 4 or 5 hours before they ever start deliberating. All right, why don't I call them back and just see if somebody's really got an issue that they need to break for today.
what do you think about sending them a note back and just asking, maybe they feel more comfortable in their room discussing it rather than an open court?
What are your thoughts on that?
So the idea is to send
A note is, does somebody have an issue that they really need to leave now?
I'm fine with
All right.
that. If you explain to them the problems of timing, then they stay a little late at night.
Well, and that's how much do I start putting in a note that I'm sending back to him, which is why I was thinking about calling him out here and saying, we were doing the math on this. And if there's a phase 2, we're concerned about the timing issues of getting stuff done. But what were you thinking, Mr. Tobin?
I'm sorry?
What were you thinking? You look like you want to say something, Mr. Tobin.
No, I think a simple note asking if there's
Okay.
My only concern why I'm proposing, Your Honors, like maybe they wouldn't be that comfortable doing it in open court if one person like has a child care issue or something, whatever it is. I don't know.
All right. I'm going to try to rate a legible note.
Yeah, they don't know what tomorrow. I think it's better. Judge, we agreed to bring them in.
Now everybody agrees to bring them in.
I withdraw my objection.
All right. That was my biggest concern. All right, go ahead and bring it back in.
Jurors entering.
Doors open. Come on. The rest of them.
Hey, y'all be seated. All right. We got a note that asked if y'all could stop deliberating for the day. And let me preface, I guess, my question with two things. One of them is obviously, and I've said this a couple times, we certainly appreciate and respect y'all's time being here with us for the better part of the last 2 weeks and getting away from your normal lives and stuff like that. One concern I've got is if we have to have the, I described in the jury instructions, there's a second phase if there's a determination of entitlement to punitives. We need to do that tomorrow. It's just the timing of what we would need to, in terms of the testimony and evidence to present to you, the instructions and argument of counsel and stuff, and getting the ability for y'all to deliberate tomorrow. The question that we wanted to ask is, does somebody need to, because of child care, family, something of that nature, does somebody need to leave now, or are you just tired, or is there the ability to go or try to go a little bit longer today just to see? And I don't want to know any discussions, determinations, or things that y'all are contemplating. But we're a little worried about timing tomorrow if we come back tomorrow on getting things done that we need to get done. So that was just our concern, and I won't put any blame on any of them. Primarily, my concern was that if we cut off for today, and we can get in here at 8 o'clock and y'all can start deliberating, but obviously we don't know how long that would be, and then running into a time problem tomorrow if we have to do the second phase of the trial. So can you all go a little bit longer today?
When will you kick us out? How long shall we go?
Bailiffs will never kick you out. From my perspective, I don't have a cutoff time per se. It sort of just depends on, from y'all's perspective, are you making headway, and do y'all want to continue? I have not had trials go that late. Other judges have had jurors deliberating because they wanted to continue deliberating. They got done at 2 o'clock in the morning one time.
Are we all right?
I'm not guessing that, but that was the jurors wanted to do that.
Right. Oh my God.
Yeah, so we won't kick you out.
I think it's more so we reached a good stopping point because we've had productivity in there and thought it'd be productive to get enough rest as well. So we asked if we could call it.
All right. Counsel, come to the sidebar. Just.
Sorry.
All right. I still have some concerns, potentially in the morning. Can you all do me a favor? Maybe go about another hour or so and see where you're going. Would that be a problem of continuing tonight and see how it's going? I'd rather, y'all try to have as much discussions as you can today, just because, like I said, I'm concerned about timing on stuff for tomorrow purposes. And I don't want y'all to have to come back next week.
Can we take like a 5-minute break so we can notify family or work that we're not going to be in?
For tonight?
For tonight?
Yeah. Yeah, I'm fine with doing that. I think, are your cell phones still?
They're often in here, I think.
No, mine's in the room.
Oh, you left it in the jury lounge? Okay.
No, the main one.
Okay. All right.
You can go get my purse. It's in there.
Well, I'll let you step back out there and go use it out there, because I don't want. You don't need to come in the courtroom and use the phone, and I don't want you to take it back to the jury room.
Okay.
All right, we'll take 5 minutes if you need to make a phone call. If you don't need to make a phone call, y'all can go back in the deliberation rooms, but wait till everybody's back in there before you continue discussions about the case. If you're using your phone to make a phone call, don't do any research about the case, don't look up any information about the case, and don't talk to anyone specifically about the case. Okay?
Okay, sir. And we're still on overtime, right?
Yes. Same rate of pay.
Same rate, okay.
To go out there with them? Okay. And on number 2, Mr. Tobin, you listening?
Yes.
Yeah, I mean, yeah, you can remain back there or come up, whichever way. Under A, 1 little I and 2 little I, that comports with what's in 768.73 1B, where you go from the regular cap of 3 times compensatory or $500,000 to 4 times compensatory or $2 million. But what you left, what the plaintiffs just want left in, or plaintiff just wants left in here under 3 little I, is what's in 1C of that statute, where there's no cap. And I had some concern, because basically what the statute says is where the finder of fact determines at the time of injury the defendant has specific intent to harm the claimant and determines the defendant's conduct did in fact harm the claimant, there shall be no cap. We don't have an interrogatory on phase 2 with that provision of a finding of fact, those specific findings of fact. Or are you saying that, how do we go from A, 1A, where there's a cap of 3 times or $500,000, to C, where there's no cap if we're including only one of the provisions of what they should consider? You understand what
I think so, Your Honor. My understanding is it's not like a progressive stacking of requirements. There's just the baseline 3 times cap. If you get the first 2 findings, those go together. That causes a 4x cap. But then, just independently of that, if you just have the specific intent to harm, there's no cap. So it's not to lift the cap entirely. It's not that you need unreasonable financial gain, unreasonably dangerous conduct, and specific intent to harm. You just need specific intent to harm to lift the cap, is my understanding of the statute.
Right, but my question is, where do we trigger going from the 3 times or $500,000 cap to no cap, where we only have one interrogatory verdict that says what's the amount?
So, I mean, I think perhaps this was why our original verdict form had a second question on it, which was, did you find that the defendant had a specific intent to harm the plaintiff? Perhaps that's why it's in the model verdict form.
Or do we make this instruction 2, you must find that they had the specific intent, instead of saying you should consider?
Well, I mean, I don't think it should say you must find specific intent, because that just lifts the cap, right? So the other rationale, right, is the nature of the defamation case has the express malice requirement, and that seems to sort of subsume the intent, the specific intent to harm. So, I mean, there's also the finding that would be made in the entitlement phase that would seem to be the same finding of, a specific intent to harm the plaintiff and did cause harm. So it seems like it's making the same finding twice, once in the entitlement phase and then again in phase 2. And so, I mean, to the extent the defense is consenting to removing that off the verdict form, and we can rely on the specific intent finding that's inherent in the malice finding in the entitlement phase. It seems like we could, I don't see any reason why we couldn't rely on the phase 1 factual finding.
Yeah, I mean, there's like an incongruity here, because what's in this instruction is what's in 503C2, but then the model verdict just has one line of what's the number. So it's like, it doesn't have a fine. I mean, they don't break it out. Are they ready? All right, let's bring the jurors back so we can get them back going. We can pick this back up.
Jurors entering.
All right, and as long as y'all don't have cell phones or anything with you, if you need to, you drop them off, but otherwise, we can go back in the deliberation room. I appreciate it.
You got it.
Thank you. All right, jurors are out of the courtroom. Y'all be seated. Oh, one of them had their purse. Can you?
I have her phone.
No. Did she have anything else in her purse? That's. Just make sure.
Do you want me to grab them and bring them out here?
Are you all right if they have a purse as long as they've got nothing that can connect, add, subtract, do anything else beyond the calculator we gave them, or calculators we sent there?
Yes. Oh, that's
Okay, yeah, I'm normally okay with purses as long as they make sure they don't have anything that can communicate in any way, shape, or form with the outside world. So anyway, getting back to that instruction. I mean, I think if you're looking at eliminating the cap, the instruction, if you want, and you want to remove 1 and 2, we almost need to have, they must find this, or something along those lines. Another note?
And then with the box of snacks.
That's fine, that's cheaper than buying them dinner.
really happy to buy them there. Really.
All right, the question was, where is 80%, 20% quote located in the binders? Can we answer that? Or I think they need to do the best that they can.
Yes, Your Honor.
Don't get a second in closing.
I don't know that you're not allowed to tell them where evidence is, and you just handed them binders. I mean, you can't tell them an exhibit.
I'm leery of pointing them to a specific direction.
I mean, they came out and asked to see the video, and we showed it to them.
Because we can't send the video back with them.
It's PX 217. If the court doesn't want to tell them where it is, the court doesn't want to tell them where it is.
Do your best, but it may be somewhere between PX 216 and 218.
For the record, I don't think it's picking up the sarcasm in the courtroom, but yes, I agree with that.
I mean, I don't think we can. I think that's almost like a. And whether I'm not saying it would benefit one side or the other necessarily, but and the same thing may apply of question the other way. I think it's almost a second closing. I'm not going to bring them out. Before you go back there, are you okay with me sending him a note back that just says we can't instruct them or something, words to that effect?
And we know what the words are.
Well, yeah, well, that's what I'm saying is you have better words than mine.
Court's not allowed to assist you in finding the evidence.
Yeah. Please use your best recollection.
P.S. It's at 217.
I'll write that on the back. I'm joking.
Mr. Sandberg would like to see the note, Your Honor.
All right, I wrote as legibly as I can. The court cannot assist you with locating the exhibit. Use your best recollection. If y'all want to see it.
Yes, Your Honor. I do not.
Thank you, Your Honor.
Both sides. Assuming that's all that's on the piece of paper as I'm representing. Are both sides good with that?
And just don't get us the back.
It was a joke. It's a tone joke.
Y'all what? You want to look at it? Hang on.
No, we're fine.
You're good. All right.
Thank you.
I gotta feel bad for them. They're like, you want us to stay and work through it.
And now I'm not helping. They're gonna. I was thinking to myself as I'm writing this, they're just gonna hate me by the end of this. Y'all get to go and leave town. I got to stick around. Getting back to the instruction, I get, I mean, I understand why you're saying we want all or nothing sort of thing by limiting that, and that may be appropriate, but that may be beneficial to the defense. But I don't know that the instruction, if we call that out, there's an incongruity, even if all of it was in, too. I mean, it's like, well, how are we determining, how do we know that the jury found either 1 or 2, just make it 4 times or 2 mil, or they found 3 for a no cap?
Yes, Your Honor. So I think that is, that's why our original verdict form had an extra question, which is, do you have a specific intent? Did you find a specific intent to harm? I think, if these were all going to stay in there, you'd want separate findings on the verdict form so that the court can determine which cap is appropriate, if any. I think if we remove 1 and 2 and leave in 3, it seems less. I mean, we can either have the second question about specific intent, but if we don't, I mean, like I said, it seems to be the same finding that exists in the entitlement phase. So, I mean, I hear what you're saying on it's almost you must find, but I mean, the other option of addressing it is just putting a second question on the verdict form. But we would still, even if we do that, want to remove 1 and 2.
Your Honor, can I ask, why isn't the finding of punitive entitlement to punitive damages, which in this case they've been instructed requires primary intent to harm, not sufficient to establish that in and of itself? Right? If we assume that they're following your instructions, which we're supposed to, then they award entitlement, then they have found a specific intent to harm. In which case the cap is lifted.
Well, I wish I would have been on the committee that drafted the jury instructions, because this is 503C2. All these findings are on there, or all these elements are on there.
Well, you can imagine cases where you may not need a specific intent to harm to obtain entitlement to punitive damages. Right? You could have recklessness potentially, which wouldn't require specific intent to harm. But here, with malice, express malice, and actual malice, it does subsume it. So I could see why since they have no standard jury instructions on defamation, it's not there. Also, obviously, I don't know if you tell this, Your Honor, but you are entitled to deviate from the standard.
Yes, I mean, we could, but I don't know, it just doesn't make any sense when you read the statute and there's specific requirements for each one of them, but the model instructions where it says you should consider and you consider all these things, it doesn't fit with the model verdict form.
I found defamation is a weird character here. It's like the retraction statute. I don't even understand how it works because it only works with a good faith requirement, and in order to find punitive damage, you have to find malice. So how could you ever have a finding of malice but having a finding of good faith? They don't work well together. All the pieces.
Well, think about this. I mean, I wrote it in the summary judgment dealing with the retraction defense. The statute says retraction, which, I mean, what does retraction mean? Pulling something back. I mean, the common usage, and I'm sure if we looked, you got 3 dictionaries or 2 dictionaries sitting on your desk. And I think I actually quoted out of some of the dictionaries in the order. It says pulling something back, but then it says you shall retract by the following means.
Yeah.
Right.
None of them are removing it.
Yeah.
Right.
Now, I can say I won't say on the record that the legislature's doesn't make any sense in drafting that, but I'm bound to follow what the legislature said.
Right. No, I understand.
So it's like, I mean, the statute needs to be fixed, and and it clearly doesn't even contemplate, online media stuff and things of that nature in the statute on a lot of that, tweets and any of that stuff. But
if the model form is for standard punitive damages instructions, you could find cases where you'd have like a recklessness, a punitive damages finding, where you would need to then have a specific intent to harm finding. It's unique to defamation where the only way you get entitlement is already by finding specific intent to harm. It's almost by putting it in, you risk an inconsistent verdict.
We don't see it that way, Your Honor. It's, thank you for the side comment. But, one is baked into, one set of law, and this is baked into the jury instructions for, the actual finding the jury has to make on this at this phase.
all right. Well, that was as far as I got researching was number 2 before we got called back up for the questions. So I just wanted to, I guess, I don't know, kind of chew on that issue a little bit with y'all and see what your thoughts were. But okay, I'm not making a ruling yet at this point in time, but I just wanted to see what your thoughts were because it just didn't make a whole lot of sense to me. You're good? Sure. That was another question from before. All right. Well, I can go back and start looking at this a little bit more. Any other questions, concerns, comments?
Not on the jury instructions.
No, Your Honor.
All right. Y'all be seated. The note is we need to recess for the evening. Jurors are getting hangry and tired.
You want to send boxing gloves?
Potentially. They did go an hour and a half, or, well, an hour and a half from when I said, can you go another hour?
I don't think we can say no longer.
Yeah, I mean, I'm not overly happy about it. But it sounds like they're not going to be productive, so. Doors don't open till 8 in the morning. Well, I was just going to tell them to get here right at 8 and get up here, or assemble downstairs, and y'all can bring them up and we'll get them back there. Any other suggestions, thoughts, options?
I mean, you can offer them dinner, but it doesn't sound like it's going to work.
Yeah.
Tavern bars are happy to do it.
Whatever they want.
All right, I'll ask them if we get dinner up here, will that satisfy it, or are they just tired and need to go? And if they say we're tired and need to go, then I'll release them for the night, read them the instruction. I'll probably put some emphasis and caution beyond the model instruction on not doing any research or talking. And we'll get them back here first thing at 8 o'clock when the doors open. All right.
Thank you.
Yeah. No. Or the night before. Or the night before.
Jurors entering?
All right, y'all be seated. All right, I got a note that in essence said you guys are hangry and tired.
Did you really write hungry? Some are tired, some are hungry.
Yeah. Well, let me ask this question. From my perspective, there's some concerns that are, that breaking in the middle of deliberations is fraught with some peril that occurs or could potentially occur. Will getting you some dinner here satisfy things, or are y'all at a point that you guys are just too tired to continue going?
We've got to call it, don't we? I don't know how much more productivity is going to happen tonight.
We're sort of at an impasse right now.
All right. Well, don't.
Yeah.
Without disclosing any discussions or this point of things, just okay. Because we're willing to get some dinner brought in if getting some food might be helpful. Just because, like I said, there's always potential for problems when the jurors are in the middle of deliberating, break, go home, and then have to come back the following day. And on top of the concerns I had before of a timing issue for purposes of tomorrow if we've got to get to phase 2. But if y'all are telling me that you're too tired to be productive, what we'll do is send you home. Be back here at first. What? Okay. Okay. Did y'all want to go or just eat? And you know, again, y'all are giving us your valuable time, and obviously this being here for 2 weeks has been an inconvenience to your normal lives. So I completely understand that. Y'all want to huddle on?
Yeah, just give us a minute here. All right, we'll stay until 9 o'clock.
All right. You want something to eat?
But
With food.
we need food.
With food.
Is that good? Sorry, guys, I missed.
No. Oh, I appreciate it.
That's the best we can do.
I appreciate it. What kind of food would y'all?
Something with cheese.
I already ate a cold sandwich.
Want to grab?
Free drawer is gone, so whatever.
Like, I mean, something downtown here, like free cheese, or I don't. We'll get you a menu.
Did you say? Okay, all right, let's go.
Something quick. All right. Y'all go ahead and head back, and we'll get you menus brought back to you here shortly. It's open now.
They want Ferrucci.
I suggested that. That was my bad.
We may or may not have mentioned that in the other room.
Courtroom. I mean, is that all right? Just grabbing like free cheese or something?
Sounds good. That's fine.
Yep. Yeah.